Section 1 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Gary B. Clayton. State of the Union Address, James Buchanan, December 8, 1857, Part 1. Fellow citizens of the Senate and House of Representatives, in obedience to the command of the Constitution, it has now become my duty, to give to Congress information of the state of the Union and recommend to their consideration such measures, as I judge to be, necessary and expedient, But first and above all, our thanks are due to Almighty God for the numerous benefits which He has bestowed upon this people, and our united prayers ought to ascend to Him that He would continue to bless our great republic in time to come as He has blessed it in time past. Since the adjournment of the last Congress, our constituents have enjoyed an unusual degree of health. The earth has yielded her fruits abundantly and has bountifully rewarded the toil of the husbandman. Our great staples have commanded high prices, and up till within a brief period our manufacturing, mineral, and mechanical occupations have largely partaken of the general prosperity. We have possessed all the elements of material wealth in rich abundance, and yet, notwithstanding all these advantages, our country in its monetary interests is at the present moment in a deplorable condition. In the midst of unsurpassed plenty in all the productions of agriculture and in all the elements of national wealth, we find our manufactures suspended, your public works retarded, our private enterprises of different kinds abandoned, and thousands of useful laborers thrown out of employment and reduced to want. The revenue of the government, which is chiefly derived from duties on imports from abroad, has been greatly reduced, whilst the appropriations made by Congress at its last session for the current fiscal year are very large in amount. Under these circumstances a loan may be required before the close of our present session, but this, although deeply to be regretted, would prove to be only a slight misfortune when compared with the suffering and distress prevailing among the people. With this the government cannot fail deeply to sympathize, though it may be without the power to extend relief. It is our duty to inquire what has produced such unfortunate results and whether their recurrence can be prevented. In all former revulsions the blame might have been fairly attributed to a variety of cooperating causes, but not so upon the present occasion. It is apparent that our existing misfortunes have proceeded solely from our extravagant and vicious system of paper currency and bank credits, exciting the people to wild speculations and gambling in stocks. These revulsions must continue to recur at successive intervals so long as the amount of the paper currency and bank loans and discounts of the country shall be left to the discretion of 1,400 irresponsible banking institutions, which from the very law of their nature will consult the interest of their stockholders rather than the public welfare. The framers of the Constitution, when they gave to Congress the power to coin money and to regulate the value thereof, and prohibited the states from coining money, emitting bills of credit, or making anything but gold and silver coin a tender in payment of debts, suppose they had protected the people against the evils of an excessive and irredeemable paper currency. They are not responsible for the existing anomaly that a government endowed with the sovereign attribute of coining money and regulating the value thereof should have no power to prevent others from driving this coin out of the country and filling up the channels of circulation with paper which does not represent gold and silver. It is one of the highest and most responsible duties of government to ensure to the people a sound circulating medium, the amount of which ought to be adapted with the utmost possible wisdom and skill to the wants of internal trade and foreign exchanges. If this be either greatly above or greatly below the proper standard, the marketable value of every man's property is increased or diminished in the same proportion, and injustice to individuals as well as incalculable evils to the community are the consequence. Unfortunately, under the construction of the Federal Constitution which has now prevailed too long to be changed, This important and delicate duty has been dissevered from the coining power and virtually transferred to more than 1,400 state banks, acting independently of each other and regulating their paper issues almost exclusively by a regard to the present interest of their stockholders. Exercising the sovereign power of providing a paper currency instead of coin for the country, the first duty which these banks owe to the public is to keep in their vaults a sufficient amount of gold and silver to ensure the convertibility of their notes into coin at all times and under all circumstances. No bank ought ever to be chartered without such restrictions on its business as to secure this result. All other restrictions are comparatively vain. This is the only true touchstone, the only efficient regulator of a paper currency, the only one which can guard the public against overissues and bank suspensions. As a collateral and eventual security, it is doubtless wise, and in all cases ought to be required, that banks shall hold an amount of United States or state securities equal to their notes in circulation and pledged for their redemption. This, however, furnishes no adequate security against overissue. On the contrary, it may be perverted to inflate the currency. Indeed, it is possible by this means to convert all the debts of the United States and state governments into banknotes, without reference to the specie required to redeem them. However valuable these securities may be in themselves, they cannot be converted into gold and silver at the moment of pressure, as our experience teaches, in sufficient time to prevent bank suspensions and the depreciation of bank notes. In England, which is to a considerable extent a paper money country, though vastly behind our own in this respect, it was deemed advisable, anterior to the Act of Parliament of 1844, which wisely separated the issue of notes from the banking department, for the Bank of England always to keep on hand gold and silver equal to 1/3 of its combined circulation and deposits. If this proportion was no more than sufficient to secure the convertibility of its notes, with the whole of Great Britain and to some extent the continent of Europe as a field for its circulation, rendering it almost impossible that a sudden and immediate run to a dangerous amount should be made upon it, the same proportion would certainly be insufficient under our banking system. Each of our 1,400 banks has but a limited circumference for its circulation, and in the course of a very few days the depositors and note holders might demand from such a bank a sufficient amount in specie to compel it to suspend, even although it had coin in its vaults equal to 1/3 of its immediate liabilities. And yet I am not aware, with the exception of the banks of Louisiana, that any state bank throughout the Union has been required by its charter to keep this or any other proportion of gold and silver compared with the amount of its combined circulation and deposits. What has been the consequence? In a recent report made by the Treasury Department on the condition of the banks throughout the various states, according to returns dated nearest to January 1857, the aggregate amount of actual specie in their vaults is $58,349,838. Of their circulation, $214,778,822. And of their deposits, $230,351,352. Thus it appears that these banks in the aggregate have considerably less than $1 in 7 of gold and silver compared with their circulation and deposits. It was palpable, therefore, that the very first pressure must drive them to suspension and deprive the people of a convertible currency, with all its disastrous consequences. It is truly wonderful that they should have so long continued to preserve their credit, when a demand for the payment of 1/7 of their immediate liabilities would have driven them into insolvency. And this is the condition of the banks, notwithstanding that 400 millions of gold from California have flowed in upon us within the last 8 years, and the tide still continues to flow. Indeed, such has been the extravagance of bank credits that the banks now hold a considerably less amount of specie, either in proportion to their capital or to their circulation and deposits combined, than they did before the discovery of gold in California. Whilst in the year 1848 their specie in proportion to their capital was more than equal to $1 for 4.5, in 1857 it does not amount to $1 for every $6.33 of their capital. In the year 1848, the specie was equal within a very small fraction to $1.05 of their circulation and deposits. In 1857, it is not equal to $1.07 of their circulation and deposits. From this statement, it is easy to account for our financial history for the last 40 years. It has been a history of extravagant expansions in the business of the country, followed by ruinous contractions. At successive intervals, the best and most enterprising men have been tempted to their ruin by excessive bank loans of mere paper credit, exciting them to extravagant importations of foreign goods, wild speculations, and ruinous and demoralizing stock gambling. When the crisis arrives, as arrive it must, the banks can extend no relief to the people. In a vain struggle to redeem their liabilities in specie, they are compelled to contract their loans and their issues, and at last, in the hour of distress, when their assistance is most needed, they and their debtors together sink into insolvency. It is this paper system of extravagant expansion, raising the nominal price of every article far beyond its real value, when compared with the cost of similar articles in countries whose circulation is wisely regulated, which has prevented us from competing in our own markets with foreign manufacturers, has produced extravagant importations, and has counteracted the effect of the large incidental protection afforded to our domestic manufacturers by the present revenue tariff. But for this, the branches of our manufactures composed of raw materials, the production of our own country, such as cotton, iron, and woolen fabrics, would not only have acquired almost exclusive possession of the home market, but would have created for themselves a foreign market throughout the world. Deplorable, however, as may be our present financial condition, we may yet indulge in bright hopes for the future. No other nation has ever existed which could have endured such violent expansions and contractions of paper credits without lasting injury. Yet the buoyancy of youth, the energies of our population, and the spirit which never quails before difficulties will enable us soon to recover from our present financial embarrassments, and may even occasion us speedily to forget the lesson which they have taught. In the meantime, it is the duty of the government, by all proper means within its power, to aid in alleviating the sufferings of the people occasioned by the suspension of the banks, and to provide against a recurrence of the same calamity. Unfortunately, in either aspect of the case, it can do but little. Thanks to the independent Treasury, the government has not suspended payment as it was compelled to do by the failure of the banks in 1837. It will continue to discharge its liabilities to the people in gold and silver. Its disbursements in coin will pass into circulation and materially assist in restoring a sound currency. From its high credit, should we be compelled to make a temporary loan, it can be effected on advantageous terms. This, however, shall, if possible, be avoided, but if not, then the amount shall be limited to the lowest practicable sum. I have therefore determined that whilst no useful government works already in progress shall be suspended, new works not already commenced will be postponed if this can be done without injury to the country. Those necessary for its defense shall proceed as though there had been no crisis in our monetary affairs. But the federal government cannot do much to provide against a recurrence of existing evils. Even if insurmountable constitutional objections did not exist against the creation of a national bank, this would furnish no adequate preventive security. The history of the last Bank of the United States abundantly proves the truth of this assertion. Such a bank could not, if it would, regulate the issues and credits of 1,400 state banks in such a manner as to prevent the ruinous expansions and contractions in our currency which afflicted the country throughout the existence of the late bank, or secure us against future suspensions. In 1825, an effort was made by the Bank of England to curtail the issues of the country banks under the most favorable circumstances. The paper currency had been expanded to a ruinous extent, and the bank put forth all its power to contract it in order to reduce prices and restore the equilibrium of the foreign exchanges. It accordingly commenced a system of curtailment of its loans and issues, in the vain hope that the joint stock and private banks of the kingdom would be compelled to follow its example. It found, however, that as it contracted, they expanded, and at the end of the process, to employ the language of a very high official authority, quote, "Whatever reduction of the paper circulation was effected by the Bank of England in 1825 was more than made up by the issues of the country banks." End of quote. But a Bank of the United States would not, if it could, restrain the issues and loans of the state banks, because its duty as a regulator of the currency must often be in direct conflict with the immediate interest of its stockholders. If we expect one agent to restrain or control another, their interests must, at least in some degree, be antagonistic. But the directors of a Bank of the United States would feel the same interest and the same inclination with the directors of the state banks to expand the currency, to accommodate their favorites and friends with loans, and to declare large dividends. Such has been our experience in regard to the last bank. After all, we must mainly rely upon the patriotism and wisdom of the states for the prevention and redress of the evil. If they will afford us a real specie basis for our paper circulation by increasing the denomination of banknotes, first to $20 and afterwards to $50, if they will require that the banks shall at all times keep on hand at least $1 of gold and silver for every $3 of their circulation and deposits, and if they will provide by a self-executing enactment, which nothing can arrest, that the moment they suspend they shall go into liquidation, I believe that such provisions, with a weekly publication by each bank of a statement of its condition, would go far to secure us against future suspensions of specie payments. Congress, in my opinion, possessed the power to pass a uniform bankrupt law applicable to all banking institutions throughout the United States, and I strongly recommend its exercise. This would make it the irreversible organic law of each bank's existence that a suspension of specie payments shall produce its civil death. The instinct of self-preservation would then compel it to perform its duties in such a manner as to escape the penalty and preserve its life. The existence of banks and the circulation of bank paper are so identified with the habits of our people that they cannot at this day be suddenly abolished without much immediate injury to the country. If we could confine them to their appropriate sphere, and prevent them from administering to the spirit of wild and reckless speculation by extravagant loans and issues, they might be continued with advantage to the public. But this I say after long and much reflection. If experience shall prove it to be impossible to enjoy the facilities which well-regulated banks might afford, without at the same time suffering the calamities which the excesses of the banks have hitherto inflicted upon the country, it would then be far the lesser evil to deprive them altogether of the power to issue a paper currency, and confine them to the functions of banks of deposit and discount. Our relations with foreign governments are upon the whole in a satisfactory condition. The diplomatic difficulties which existed between the government of the United States and that of Great Britain at the adjournment of the last Congress have been happily terminated by the appointment of a British minister to this country who has been cordially received. While it is greatly to the interest, as I am convinced it is the sincere desire, of the governments and people of the two countries to be on terms of intimate friendship with each other, it has been our misfortune almost always to have had some irritating, if not dangerous, outstanding question with Great Britain. Since the origin of the government we have been employed in negotiating treaties with that power, and afterwards in discussing their true intent and meaning. In this respect the Convention of April 19, 1850, commonly called the Clayton and Bulwer Treaty, has been the most unfortunate of all, because the two governments placed directly opposite and contrary constructions upon its first and most important article. Whilst in the United States we believe that this treaty would place both powers upon an exact equality by the stipulation that neither will ever, quote, occupy or fortify or colonize or assume or exercise any dominion, end quote, over any part of Central America, it is contended by the British government that the true construction of this language has left them in the rightful possession of all that portion of Central America which was in their occupancy at the date of the treaty. In fact, that treaty is a virtual recognition on the part of the United States of the right of Great Britain, either as owner or protector, to the whole extensive coast of Central America, sweeping round from the Rio Hondo to the port and harbor of San Juan de Nicaragua, together with the adjacent Bay Islands, except the comparatively small portion of this between the Sarstoon and Cape Honduras. According to their construction, the treaty does no more than simply prohibit them from extending their positions in Central America beyond the present limits. It is not too much to assert that if in the United States the treaty had been considered susceptible of such a construction, it never would have been negotiated under the authority of the President, nor would it have received the approbation of the Senate. The universal conviction in the United States was that when our government consented to violate its traditional and time-honored policy and to stipulate with a foreign government never to occupy or acquire territory in the Central American portion of our own continent, the consideration for this sacrifice was that Great Britain should, in this respect at least, be placed in the same position with ourselves. Whilst we have no right to doubt the sincerity of the British government in their construction of the treaty, it is at the same time my deliberate conviction that this construction is in opposition both to its letter and its spirit. Under the late administration, negotiations were instituted between the two governments for the purpose, if possible, of removing these difficulties, and a treaty having this laudable object in view was signed at London on the 17th October, 1856, and was submitted by the President to the Senate on the following 10th of December. Whether this treaty, either in its original or amended form, would have accomplished the object intended without giving birth to new and embarrassing complications between the two governments may perhaps be well questioned. Certain it is, however, it was rendered much less objectionable by the different amendments made to it by the Senate. The treaty as amended was ratified by me on the 12th March, 1857, and was transmitted to London for ratification by the British government. That government expressed its willingness to concur in all the amendments made by the Senate with the single exception of the clause relating to Roatan and the other islands in the Bay of Honduras. The article in the original treaty as submitted to the Senate, after reciting that these islands and their inhabitants, quote, having been, by a convention bearing date of 27th day of August, 1856, between Her Britannic Majesty and the Republic of Honduras, constituted and declared a free territory under the sovereignty of the said Republic of Honduras, end quote, stipulated that, quote, the two contracting parties do hereby mutually engage to recognize and respect in all future time the independence and rights of the said free territory as a part of the Republic of Honduras, end quote. Upon an examination of this convention between Great Britain and Honduras of the 27th August, 1856, it was found that whilst declaring the Bay Islands to be, quote, a free territory under the sovereignty of the Republic of Honduras, end quote, it deprived that republic of rights without which its sovereignty over them could scarcely be said to exist. It divided them from the remainder of Honduras and gave to their inhabitants a separate government of their own, with legislative, executive, and judicial officers elected by themselves. It deprived the government of Honduras of the taxing power in every form, and exempted the people of the islands from the performance of military duty except for their own exclusive defense. It also prohibited that republic from erecting fortifications upon them for their protection, thus leaving them open to invasion from any quarter, and finally it provided, quote, that slavery shall not at any time hereafter be permitted to exist therein, end quote. Had Honduras ratified this convention, she would have ratified the establishment of a state substantially independent within her own limits, and a state at all times subject to British influence and control. Moreover, had the United States ratified the treaty with Great Britain in its original form, we should have been bound, quote, to recognize and respect in all future time, end quote, these stipulations to the prejudice of Honduras. Being in direct opposition to the spirit and meaning of the Clayton and Bulwer Treaty as understood in the United States, the Senate rejected the entire clause and substituted in its stead a simple recognition of the sovereign right of Honduras to these islands in the following language. The two contracting parties do hereby mutually engage to recognize and respect the islands of Roatan, Bonico, Utila, Barbaretta, Helena, and Moral, situate in the Bay of Honduras off the coast of the Republic of Honduras, as under the sovereignty and as part of the said Republic of Honduras. Great Britain rejected this amendment, assigning as the only reason that the ratifications of the Convention of the 27th August 1856 between her and Honduras had not been, quote, exchanged, owing to the hesitation of that government, end quote. Had this been done, it is stated that, quote, Her Majesty's government would have had little difficulty in agreeing to the modifications proposed by the Senate, which then would have had in effect the same significance as the original wording, end quote. Whether this would have been the effect, whether the mere circumstance of the exchange of the ratifications of the British Convention with Honduras prior in point of time to the ratification of our treaty with Great Britain would, quote, in effect, have had the same significance as the original wording, end quote, and thus have nullified the amendment of the Senate may well be doubted. It is perhaps fortunate that the question has never arisen. The British government, immediately after rejecting the treaty as amended, proposed to enter into a new treaty with the United States, similar in all respects to the treaty which they had just refused to ratify, if the United States would consent to add to the Senate's clear and unqualified recognition of the sovereignty of Honduras over the Bay Islands the following conditional stipulation: Whenever and so soon as the Republic of Honduras shall have concluded and ratified a treaty with Great Britain, by which Great Britain shall have ceded and the Republic of Honduras shall have accepted the said islands, subject to the provisions and conditions contained in such a treaty. This proposition was, of course, rejected. After the Senate had refused to recognize the British Convention with Honduras of the 27th August, 1856, with full knowledge of its contents, it was impossible for me, necessarily ignorant of, quote, the provisions and conditions, end quote, which might be contained in a future convention between the same parties, to sanction them in advance. The fact is that when two nations like Great Britain and the United States, mutually desirous as they are, and I trust ever may be, of maintaining the most friendly relations with each other, have unfortunately concluded a treaty which they understand in senses directly opposite, the wisest course is to abrogate such a treaty by mutual consent and to commence anew. Had this been done promptly, all difficulties in Central America would most probably ere this have been adjusted to the satisfaction of both parties. The time spent in discussing the meaning of the Clayton and Bulwer Treaty would have been devoted to this praiseworthy purpose, and the task would have been the more easily accomplished because the interest of the two countries in Central America is identical, being confined to securing safe transits over all the routes across the isthmus. Whilst entertaining these sentiments, I shall, nevertheless, not refuse to contribute to any reasonable adjustment of the Central American questions, which is not practically inconsistent with the American interpretation of the treaty. Overtures for this purpose have been recently made by the British government in a friendly spirit, which I cordially reciprocate, but whether this renewed effort will result in success I am not yet prepared to express an opinion. A brief period will determine. With France, our ancient relations of friendship still continue to exist. The French government have, in several recent instances which need not be enumerated, evinced a spirit of goodwill and kindness to our country which I heartily reciprocate. It is, notwithstanding, much to be regretted that two nations whose productions are of such a character as to invite the most extensive exchanges and freest commercial intercourse should continue to enforce ancient and obsolete restrictions of trade against each other. Our commercial treaty with France is in this respect an exception from our treaties with all other commercial nations. It jealously levies discriminating duties both on tonnage and on articles, the growth, produce, or manufacture of the one country when arriving in vessels belonging to the other. More than 40 years ago, on the 3rd March, 1815, Congress passed an act offering to all nations to admit their vessels laden with their national productions into the ports of the United States upon the same terms with our own vessels provided they would reciprocate to us similar advantages. This act confined the reciprocity to the productions of the respective foreign nations who might enter into the proposed arrangement with the United States. The Act of May 24, 1828, removed this restriction and offered a similar reciprocity to all such vessels without reference to the origin of their cargoes. Upon these principles our commercial treaties and arrangements have been rounded, except with France, and let us hope that this exception may not long exist. Our relations with Russia remain as they have ever been on the most friendly footing. The present emperor, as well as his predecessors, have never failed when the occasion offered to manifest their goodwill to our country, and their friendship has always been highly appreciated by the government and people of the United States. With all other European governments except that of Spain, our relations are as peaceful as we could desire. I regret to say that no progress whatever has been made since the adjournment of Congress toward the settlement of any of the numerous claims of our citizens against the Spanish government. Besides, the outrage committed on our flag by the Spanish war frigate Ferrolana on the high seas off the coast of Cuba in March 1855 by firing into the American mail steamer El Dorado and detaining and searching her remains unacknowledged and unredressed. The general tone and temper of the Spanish government toward that of the United States are much to be regretted. Our present envoy extraordinary and minister plenipotentiary to Madrid has asked to be recalled, and it is my purpose to send out a new minister to Spain with special instructions on all questions pending between the two governments, and with a determination to have them speedily and amicably adjusted if this be possible. In the meantime, whenever our minister urges the just claims of our citizens on the notice of the Spanish government, he is met with the objection that Congress has never made the appropriation recommended by President Polk in his annual message of December 1847, quote, to be paid to the Spanish government for the purpose of distribution among the claimants in the Amistad case, end quote. A similar recommendation was made by my immediate predecessor in his message of December 1853, and entirely concurring with both in the opinion that this indemnity is justly due under the treaty with Spain of the 27th of October, 1795, I earnestly recommend such an appropriation to the favorable consideration of Congress. A treaty of friendship and commerce was concluded at Constantinople on the 13th December, 1856, between the United States and Persia, the ratifications of which were exchanged at Constantinople on the 13th June, 1857, and the treaty was proclaimed by the President on the 18th August, 1857. This treaty, it is believed, will prove beneficial to American commerce. The Shah has manifested an earnest disposition to cultivate friendly relations with our country, and has expressed a strong wish that we should be represented at Tehran by a minister plenipotentiary, and I recommend that an appropriation be made for this purpose. Recent occurrences in China have been unfavorable to a revision of the treaty with that empire of the 3rd July, 1844, with a view to the security and extension of our commerce. The 24th article of this treaty stipulated for a revision of it in case experience should prove this to be requisite, quote, in which case the two governments will, at the expiration of 12 years from the date of said convention, treat amicably concerning the same by means of suitable persons appointed to conduct such negotiations. End of quote. These 12 years expired on the 3rd July, 1856, but long before that period it was ascertained that important changes in the treaty were necessary, and several fruitless attempts were made by the Commissioner of the United States to effect these changes. Another effort was about to be made for the same purpose by our Commissioner in conjunction with the ministers of England and France, but this was suspended by the occurrence of hostilities in the Canton River between Great Britain and the Chinese Empire. These hostilities have necessarily interrupted the trade of all nations with Canton, which is now in a state of blockade, and have occasioned a serious loss of life and property. Meanwhile, the insurrection within the empire against the existing imperial dynasty still continues, and it is difficult to anticipate what will be the result. Under these circumstances, I have deemed it advisable to appoint a distinguished citizen of Pennsylvania, envoy extraordinary and minister plenipotentiary, to proceed to China and to avail himself of any opportunities which may offer to effect changes in the existing treaty favorable to American commerce. He left the United States for the place of his destination in July last in the war steamer Minnesota. Special ministers to China have also been appointed by the governments of Great Britain and France. Whilst our minister has been instructed to occupy a neutral position in reference to the existing hostilities at Canton, he will cordially cooperate with the British and French ministers in all peaceful measures to secure by treaty stipulations those just concessions to commerce which the nations of the world have a right to expect and which China cannot long be permitted to withhold. From assurances received, I entertain no doubt that the three ministers will act in harmonious concert to obtain similar commercial treaties for each of the powers they represent. We cannot fail to feel a deep interest in all that concerns the welfare of the independent republics on our own continent, as well as of the Empire of Brazil. Our difficulties with New Granada, which a short time since bore so threatening an aspect, are, it is to be hoped, in a fair train of settlement in a manner just and honorable to both parties. The Isthmus of Central America, including that of Panama, is the great highway between the Atlantic and Pacific over which a large portion of the commerce of the world is destined to pass. The United States are more deeply interested than any other nation in preserving the freedom and security of all the communications across this isthmus. It is our duty, therefore, to take care that they shall not be interrupted either by invasions from our own country or by wars between the independent states of Central America. Under our treaty with New Granada of the 12th December, 1846, we are bound to guarantee the neutrality of the Isthmus of Panama through which the Panama Railroad passes, as well as the rights of sovereignty and property which New Granada has and possesses over the said territory." This obligation is rounded upon equivalence granted by the treaty to the government and people of the United States. Under these circumstances, I recommend to Congress the passage of an act authorizing the President, in case of necessity, to employ the land and naval forces of the United States to carry into effect this guarantee of neutrality and protection. I also recommend similar legislation for the security of any other route across the isthmus in which we may acquire an interest by treaty. With the independent republics on this continent, it is both our duty and our interest to cultivate the most friendly relations. We can never feel indifferent to their fate and must always rejoice in their prosperity. Unfortunately for both them and for us, our example and advice have lost much of their influence in consequence of the lawless expeditions which have been fitted out against some of them within the limits of our country. Nothing is better calculated to retard our steady material progress or impair our character as a nation than the tolerance of such enterprises in violation of the law of nations. It is one of the first and highest duties of any independent state in its relations with the members of the great family of nations to restrain its people from acts of hostile aggression against their citizens or subjects. The most eminent writers on public law do not hesitate to denounce such hostile acts as robbery and murder. Weak and feeble states like those of Central America may not feel themselves able to assert and vindicate their rights. The case would be far different if expeditions were set on foot within our own territories to make private war against a powerful nation. If such expeditions were fitted out from abroad against any portion of our own country, to burn down our cities, murder and plunder our people, and usurp our government, we should call any power on earth to the strictest account for not preventing such enormities. Ever since the administration of General Washington, acts of Congress have been enforced to punish severely the crime of setting on foot a military expedition within the limits of the United States, to proceed from thence against a nation or state with whom we are at peace. The present Neutrality Act of April 20, 1818, is but little more than a collection of pre-existing laws. Under this act, the President is empowered to employ the land and naval forces and the militia, "for the purpose of preventing the carrying on of any such expedition or enterprise from the territories and jurisdiction of the United States," and the collectors of customs are authorized and required to detain any vessel in port when there is reason to believe she is about to take part in such lawless enterprises. When it was first rendered probable that an attempt would be made to get up another unlawful expedition against Nicaragua, the Secretary of State issued instructions to the marshals and district attorneys, which were directed by the Secretaries of War and the Navy to the appropriate Army and Navy officers, requiring them to be vigilant and to use their best exertions in carrying into effect the provisions of the Act of 1818. Notwithstanding these precautions, the expedition has escaped from our shores. Such enterprises can do no possible good to the country, but have already inflicted much injury both on its interests and its character. They have prevented peaceful emigration from the United States to the states of Central America, which could not fail to prove highly beneficial to all the parties concerned. In a pecuniary point of view alone, our citizens have sustained heavy losses from the seizure and closing of the transit route by the San Juan between the two oceans. The leader of the recent expedition was arrested at New Orleans, but was discharged on giving bail for his appearance in the insufficient sum of $2,000. I commend the whole subject to the serious attention of Congress, believing that our duty and our interest, as well as our national character, require that we should adopt such measures as will be effectual in restraining our citizens from committing such outrages. I regret to inform you that the President of Paraguay has refused to ratify the treaty between the United States and that state as amended by the Senate, the signature of which was mentioned in the message of my predecessor to Congress at the opening of its session in December 1853. The reasons assigned for this refusal will appear in the correspondence herewith submitted. It being desirous to ascertain the fitness of the river La Plata and its tributaries for navigation by steam, the United States steamer Water Witch was sent thither for that purpose in 1853. This enterprise was successfully carried on until February 1855, when, whilst in the peaceful prosecution of her voyage up the Parana River, the steamer was fired upon by a Paraguayan fort. The fire was returned, but as the Water Witch was of small force and not designed for offensive operations, she retired from the conflict. The pretext upon which the attack was made was a decree of the President of Paraguay of October 1854, prohibiting foreign vessels of war from navigating the rivers of that state. As Paraguay, however, was the owner of but one bank of the river of that name, the other belonging to Corrientes, a state of the Argentine Confederation, the right of its government to expect that such a decree would be obeyed cannot be acknowledged. But the Water Witch was not, properly speaking, a vessel of war. She was a small steamer engaged in a scientific enterprise intended for the advantage of commercial states generally. Under these circumstances, I am constrained to consider the attack upon her as unjustifiable and as calling for satisfaction from the Paraguayan government. Citizens of the United States also who were established in business in Paraguay have had their property seized and taken from them, and have otherwise been treated by the authorities in an insulting and arbitrary manner, which requires redress. A demand for these purposes will be made in a firm but conciliatory spirit. This will the more probably be granted if the Executive shall have authority to use other means in the event of a refusal. This is accordingly recommended. End of Section 1. Recording by Gary B. Clayton. Section 2 of State of the Union Addresses 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Gary B. Clayton. State of the Union Address, James Buchanan, December 8, 1857, Part 2. It is unnecessary to state in detail the alarming condition of the territory of Kansas at the time of my inauguration. The opposing parties then stood in hostile array against each other, and any accident might have relighted the flames of civil war. Besides, at this critical moment, Kansas was left without a governor by the resignation of Governor Geary. On the 19th of February previous, the territorial legislature had passed a law providing for the election of delegates on the third Monday of June to a convention to meet on the first Monday of September, for the purpose of framing a constitution preparatory to admission into the Union. This law was in the main fair and just, and it is to be regretted that all the qualified electors had not registered themselves and voted under its provisions. At the time of the election for delegates, an extensive organization existed in the territory whose avowed object it was, if need be, to put down the lawful government by force and to establish a government of their own under the so-called Topeka Constitution. The persons attached to this revolutionary organization abstained from taking any part in the election. The act of the territorial legislature had omitted to provide for submitting to the people the constitution which might be framed by the convention, and in the excited state of public feeling throughout Kansas, an apprehension extensively prevailed that a design existed to force upon them a constitution in relation to slavery against their will. In this emergency, it became my duty, as it was my unquestionable right, having in view the union of all good citizens in support of the territorial laws, to express an opinion on the true construction of the provisions concerning slavery contained in the Organic Act of Congress of the 30th May, 1854. Congress declared it to be, quote, "the true intent and meaning of this act not to legislate slavery into any territory or state, nor to exclude it therefrom, but to leave the people thereof perfectly free to form and regulate their domestic institutions in their own way." End quote. Under it, Kansas, quote, "when admitted as a state," end quote, was to, quote, "be received into the Union with or without slavery, as their Constitution may prescribe at the time of their admission." End quote. Did Congress mean by this language that the delegates elected to frame a Constitution should have authority finally to decide the question of slavery, or did they intend by leaving it to the people that the people of Kansas themselves should decide this question by a direct vote? On this subject I confess I had never entertained a serious doubt, and therefore in my instructions to Governor Walker of the 28th March last, I merely said that when, quote, "a constitution shall be submitted to the people of the territory, they must be protected in the exercise of their right of voting for or against that instrument, and the fair expression of the popular will must not be interrupted by fraud or violence." End quote. In expressing this opinion, it was far from my intention to interfere with the decision of the people of Kansas, either for or against slavery. From this I have always carefully abstained. Entrusted with the duty of taking, quote, "care that the laws be faithfully executed," end quote, my only desire was that the people of Kansas should furnish to Congress the evidence required by the Organic Act, whether for or against slavery, and in this manner smooth their passage into the Union. In emerging from the condition of territorial dependence into that of a sovereign state, it was their duty, in my opinion, to make known their will by the votes of the majority on the direct question whether this important domestic institution should or should not continue to exist. Indeed, this was the only possible mode in which their will could be authentically ascertained. The election of delegates to a convention must necessarily take place in separate districts. From this cause it may readily happen, as has often been the case, that a majority of the people of a state or territory are on one side of a question, whilst a majority of the representatives from the several districts into which it is divided may be upon the other side. This arises from the fact that in some districts delegates may be elected by small majorities, whilst in others those of different sentiments may receive majorities sufficiently great not only to overcome the votes given for the former, but to leave a large majority of the whole people in direct opposition to a majority of the delegates. Besides, our history proves that influences may be brought to bear on the representative sufficiently powerful to induce him to disregard the will of his constituents. The truth is that no other authentic and satisfactory mode exists of ascertaining the will of the majority of the people of any state or territory on an important and exciting question, like that of slavery in Kansas, except by leaving it to a direct vote. How wise, then, was it for Congress to pass over all subordinate and intermediate agencies and proceed directly to the source of all legitimate power under our institutions? How vain would any other principle prove in practice? This may be illustrated by the case of Kansas. Should she be admitted into the Union with a constitution either maintaining or abolishing slavery against the sentiment of the people? This could have no other effect than to continue and to exasperate the existing agitation during the brief period required to make the Constitution conform to the irresistible will of the majority. The friends and supporters of the Nebraska and Kansas Act, when struggling on a recent occasion to sustain its wise provisions before the great tribunal of the American people, never differed about its true meaning on this subject. Everywhere throughout the Union they publicly pledged their faith and their honor that they would cheerfully submit the question of slavery to the decision of the bona fide people of Kansas, without any restriction or qualification whatever. All were cordially united upon the great doctrine of popular sovereignty, which is the vital principle of our free institutions. Had it then been insinuated from any quarter that it would be a sufficient compliance with the requisitions of the organic law for the members of a convention thereafter to be elected to withhold the question of slavery from the people, and to substitute their own will for that of a legally ascertained majority of all their constituents, this would have been instantly rejected. Everywhere they remained true to the resolution adopted on a celebrated occasion recognizing, quote, the right of the people of all the territories, including Kansas and Nebraska, acting through the legally and fairly express will of a majority of actual residents, and whenever the number of their inhabitants justifies it, to form a constitution with or without slavery and be admitted into the Union upon terms of perfect equality with the other states. End quote. The convention to frame a constitution for Kansas met on the first Monday of September last. They were called together by virtue of an act of the territorial legislature, whose lawful existence had been recognized by Congress in different forms and by different enactments. A large proportion of the citizens of Kansas did not think it proper to register their names and to vote at the election for delegates, but an opportunity to do this having been fairly afforded, their refusal to avail themselves of their right could in no manner affect the legality of the convention. This convention proceeded to frame a constitution for Kansas, and finally adjourned on the 7th day of November. But little difficulty occurred in the convention except on the subject of slavery. The truth is that the general provisions of our recent state constitutions are so similar and, I may add, so excellent that the difference between them is not essential. Under the earlier practice of the government, no constitution framed by the convention of a territory preparatory to its admission into the Union as a state had been submitted to the people. I trust, however, the example set by the last Congress requiring that the Constitution of Minnesota, quote, should be subject to the approval and ratification of the people of the proposed state, end quote, may be followed on future occasions. I took it for granted that the Convention of Kansas would act in accordance with this example, rounded as it is on correct principles, and hence my instructions to Governor Walker in favor of submitting the Constitution to the people were expressed in general and unqualified terms. In the Kansas-Nebraska Act, however, this requirement, as applicable to the whole Constitution, had not been inserted, and the convention were not bound by its terms to submit any other portion of the instrument to an election except that which relates to the, quote, domestic institution, unquote, of slavery. This will be rendered clear by a simple reference to its language. It was, quote, not to legislate slavery into any territory or state, nor to exclude it therefrom, but to leave the people thereof perfectly free to form and regulate their domestic institutions in their own way. End quote. According to the plain construction of the sentence, the words domestic institutions have a direct, as they have an appropriate, reference to slavery. Quote, domestic institutions, end quote, are limited to the family. The relation between master and slave and a few others are, quote, domestic institutions, end quote, and are entirely distinct from institutions of a political character. Besides, there was no question then before Congress, nor, indeed, has there since been any serious question before the people of Kansas or the country, except that which relates to the, quote, domestic institution, end quote, of slavery. The convention, after an angry and excited debate, finally determined by a majority of only 2 to submit the question of slavery to the people, though at the last 43 of the 50 delegates present affixed their signatures to the Constitution. A large majority of the convention were in favor of establishing slavery in Kansas. They accordingly inserted an article in the Constitution for this purpose similar in form to those which had been adopted by other territorial conventions. In the schedule, however, providing for the transition from a territorial to a state government, the question has been fairly and explicitly referred to the people whether they will have a constitution, quote, with or without slavery, end quote. It declares that before the Constitution adopted by the convention, quote, shall be sent to Congress for admission into the Union as a state, end quote, an election shall be held to decide this question, at which all the white male inhabitants of the territory above the age of 21 are entitled to vote. They are to vote by ballot, and, quote, the ballots cast at said election shall be endorsed Constitution with slavery and Constitution with no slavery, end quote. If there be a majority in favor of the Constitution with slavery, then it is to be transmitted to Congress by the President of the Convention in its original form. If, on the contrary, there shall be a majority in favor of the Constitution with no slavery, then the article providing for slavery shall be stricken from the Constitution by the President of this convention." End quote. And it is expressly declared that, quote, "no slavery shall exist in the state of Kansas, except that the right of property in slaves now in the territory shall in no manner be interfered with." And in that event it is made his duty to have the Constitution thus ratified transmitted to the Congress of the United States for the admission of the state into the Union. At this election every citizen will have an opportunity of expressing his opinion by his vote, quote, "whether Kansas shall be received into the Union with or without slavery," end quote. And thus this exciting question may be peacefully settled in the very mode required by the organic law. The election will be held under legitimate authority, and if any portion of the inhabitants shall refuse to vote, a fair opportunity to do so having been presented, this will be their own voluntary act and they alone will be responsible for the consequences. Whether Kansas shall be a free or a slave state must eventually, under some authority, be decided by an election, and the question can never be more clearly or distinctly presented to the people than it is at the present moment. Should this opportunity be rejected, she may be involved for years in domestic discord, and possibly in civil war, before she can again make up the issue now so fortunately tendered and again reach the point she has already attained. Kansas has for some years occupied too much of the public attention. It is high time this should be directed to far more important objects. When once admitted into the Union, whether with or without slavery, the excitement beyond her own limits will speedily pass away, and she will then for the first time be left, as she ought to have been long since, to manage her own affairs in her own way. If her constitution on the subject of slavery or any other subject be displeasing to a majority of the people, no human power can prevent them from changing it within a brief period. Under these circumstances it may well be questioned whether the peace and quiet of the whole country are not of greater importance than the mere temporary triumph of either of the political parties in Kansas. Should the Constitution without slavery be adopted by the votes of the majority, the rights of property in slaves now in the territory are reserved. The number of these is very small, but if it were greater the provision would be equally just and reasonable. The slaves were brought into the territory under the Constitution of the United States and are now the property of their masters. This point has at length been finally decided by the highest judicial tribunal of the country, and this upon the plain principle that when a confederacy of sovereign states acquire a new territory at their joint expense, both equality and justice demand that the citizens of one and all of them shall have the right to take into it whatsoever is recognized as property by the common Constitution. To have summarily confiscated the property in slaves already in the territory would have been an act of gross injustice, and contrary to the practice of the older states of the Union which have abolished slavery. A territorial government was established for Utah by act of Congress approved the 9th September, 1850, and the Constitution and laws of the United States were thereby extended over it, quote, "so far as the same or any provisions thereof may be applicable," end quote. This act provided for the appointment by the President, by and with the advice and consent of the Senate, of a governor who was to be ex officio superintendent of Indian affairs, a secretary, 3 judges of the Supreme Court, a marshal, and a district attorney. Subsequent acts provided for the appointment of the officers necessary to extend our land and our Indian system over the territory. Brigham Young was appointed the first governor on the 20th September, 1850, and has held the office ever since. Whilst Governor Young has been both governor and superintendent of Indian affairs throughout this period, he has been at the same time the head of the church called the Latter-day Saints, and professes to govern its members and dispose of their property by direct inspiration and authority from the Almighty. His power has been, therefore, absolute over both church and state. The people of Utah almost exclusively belong to this church, and believing with a fanatical spirit that he is governor of the territory by divine appointment, they obey his commands as if these were direct revelations from heaven. If, therefore, he chooses that his government shall come into collision with the government of the United States, the members of the Mormon Church will yield implicit obedience to his will. Unfortunately, Existing facts leave but little doubt that such is his determination. Without entering upon a minute history of occurrences, it is sufficient to say that all the officers of the United States, judicial and executive, with the single exception of 2 Indian agents, have found it necessary for their own personal safety to withdraw from the territory, and there no longer remains any government in Utah but the despotism of Brigham Young. This being the condition of affairs in the territory, I could not mistake the path of duty. As Chief Executive Magistrate, I was bound to restore the supremacy of the Constitution and laws within its limits. In order to effect this purpose, I appointed a new governor and other federal officers for Utah, and sent with them a military force for their protection and to aid as a posse comitatus in case of need in the execution of the laws. With the religious opinions of the Mormons, as long as they remained mere opinions, however deplorable in themselves and revolting to the moral and religious sentiments of all Christendom, I had no right to interfere. Actions alone, when in violation of the Constitution and laws of the United States, become the legitimate subjects for the jurisdiction of the civil magistrate. My instructions to Governor Cumming have therefore been framed in strict accordance with these principles. At their date, a hope was indulged that no necessity might exist for employing the military in restoring and maintaining the authority of the law, but this hope has now vanished. Governor Young has by proclamation declared his determination to maintain his power by force, and has already committed acts of hostility against the United States. Unless he should retrace his steps, the territory of Utah will be in a state of open rebellion. He has committed these acts of hostility notwithstanding Major Van Vliet, an officer of the Army sent to Utah by the commanding general to purchase provisions for the troops, had given him the strongest assurances of the peaceful intentions of the government, and that the troops would only be employed as a posse comitatus when called on by the civil authority to aid in the execution of the laws. There is reason to believe that Governor Young has long contemplated this result. He knows that the continuance of his despotic power depends upon the exclusion of all settlers from the territory, except those who will acknowledge his divine mission and implicitly obey his will, and that an enlightened public opinion there would soon prostrate institutions at war with the laws of both God and man. Quote, he has therefore for several years, in order to maintain his independence, been industriously employed in collecting and fabricating arms and munitions of war, and in disciplining the Mormons for military service. End quote. As Superintendent of Indian Affairs, he has had an opportunity of tampering with the Indian tribes and exciting their hostile feelings against the United States. This, according to our information, he has accomplished in regard to some of these tribes, while others have remained true to their allegiance and have communicated his intrigues to our Indian agents. He has laid in a store of provisions for 3 years, which in case of necessity, as he informed Major Van Vliet, he will conceal, quote, and then take to the mountains and bid defiance to all the powers of the government. End quote. A great part of all this may be idle boasting, but yet no wise government will lightly estimate the efforts which may be inspired by such frenzied fanaticism as exists among the Mormons in Utah. This is the first rebellion which has existed in our territories, and humanity itself requires that we should put it down in such a manner that it shall be the last. To trifle with it would be to encourage it and to render it formidable. We ought to go there with such an imposing force as to convince these deluded people that resistance would be vain, and thus spare the effusion of blood. We can in this manner best convince them that we are their friends, not their enemies. In order to accomplish this object, it will be necessary, according to the estimate of the War Department, to raise 4 additional regiments, and this I earnestly recommend to Congress. At the present moment of depression in the revenues of the country, I am sorry to be obliged to recommend such a measure, but I feel confident of the support of Congress, cost what it may, in suppressing the insurrection and in restoring and maintaining the sovereignty of the Constitution and laws over the territory of Utah. I recommend to Congress the establishment of a territorial government over Arizona, incorporating with it such portions of New Mexico as they may deem expedient. I need scarcely adduce arguments in support of this recommendation. We are bound to protect the lives and the property of our citizens inhabiting Arizona, and these are now without any efficient protection. Their present number is already considerable and is rapidly increasing, notwithstanding the disadvantages under which they labor. Besides, the proposed territory is believed to be rich in mineral and agricultural resources, especially in silver and copper. The mails of the United States to California are now carried over it through its whole extent, and this route is known to be the nearest and believed to be the best to the Pacific. Long experience has deeply convinced me that a strict construction of the powers granted to Congress is the only true, as well as the only safe, theory of the Constitution. Whilst this principle shall guide my public conduct, I consider it clear that under the war-making power Congress may appropriate money for the construction of a military road through the territories of the United States, when this is absolutely necessary for the defense of any of the states against foreign invasion. The Constitution has conferred upon Congress power, quote, to declare war, to raise and support armies, to provide and maintain a navy, end quote, and to call forth the militia to, quote, repel invasions, end quote. These high sovereign powers necessarily involve important and responsible public duties, and among them there is none so sacred and so imperative as that of preserving our soil from the invasion of a foreign enemy. The Constitution has therefore left nothing on this point to construction, but expressly requires that, quote, the United States shall protect each of them, the states, against invasion, end quote. Now, if a military road over our own territories be indispensably necessary to enable us to meet and repel the invader, it follows as a necessary consequence not only that we possess the power, but it is our imperative duty to construct such a road. It would be an absurdity to invest a government with the unlimited power to make and conduct war, and at the same time deny to it the only means of reaching and defeating the enemy at the frontier. Without such a road, it is quite evident we cannot protect California and our Pacific possessions against invasion. We cannot by any other means transport men and munitions of war from the Atlantic states in sufficient time successfully to defend these remote and distant portions of the Republic. Experience has proved that the routes across the Isthmus of Central America are at best but a very uncertain and unreliable mode of communication. But even if this were not the case, they would at once be closed against us in the event of war with a naval power so much stronger than our own as to enable it to blockade the ports at either end of these routes. After all, therefore, we can only rely upon a military road through our own territories, and ever since the origin of the government, Congress has been in the practice of appropriating money from the public treasury for the construction of such roads. The difficulties and the expense of constructing a military railroad to connect our Atlantic and Pacific states have been greatly exaggerated. The distance on the Arizona route, near the 32nd parallel of north latitude, between the western boundary of Texas on the Rio Grande and the eastern boundary of California on the Colorado, from the best explorations now within our knowledge, does not exceed 470 miles, and the face of the country is in the main favorable. For obvious reasons, the government ought not to undertake the work itself by means of its own agents. This ought to be committed to other agencies which Congress might assist, either by grants of land or money, or by both, upon such terms and conditions as they may deem it most beneficial for the country. Provision might thus be made not only for the safe, rapid, and economical transportation of troops and munitions of war, but also of the public mails. The commercial interests of the whole country, both east and west, would be greatly promoted by such a road. And, above all, it would be a powerful additional bond of union. And although advantages of this kind, whether postal, commercial, or political, cannot confer constitutional power, yet they may furnish auxiliary arguments in favor of expediting a work which, in my judgment, is clearly embraced within the war-making power. For these reasons, I commend to the friendly consideration of Congress the subject of the Pacific Railroad, without finally committing myself to any particular route. The report of the Secretary of the Treasury will furnish a detailed statement of the condition of the public finances and of the respective branches of the public service devolved upon that department of the government. By this report, it appears that the amount of revenue received from all sources into the Treasury during the fiscal year ending the 30th June, 1857, was $68,631,513.67, which amount, with a balance of $19,901,325.45 remaining in the Treasury at the commencement of the year, made an aggregate for the service of the year of $88,532,839.12. The public expenditures for the fiscal year ending 30th June 1857 amounted to $70,822,724.85, of which $5,943,896.91 were applied to the redemption of the public debt, including interest and premium, leaving in the Treasury at the commencement of the present fiscal year on the 1st July, 1857, $17,710,114.27. The receipts into the Treasury for the first quarter of the present fiscal year commencing 1 July 1857 were $20,929,819.81, and the estimated receipts of the remaining 3 quarters of the 30th June 1858 are $36,750,000, making, with the balance before stated, an aggregate of $75,389,934.08 for the service of the present fiscal year. The actual expenditures during the first quarter of the present fiscal year were $23,714,528.37, of which $3,895,232.39 were applied to the redemption of the public debt, including interest and premium. The probable expenditures of the remaining 3 quarters to 30th June 1858 are $51,248,530.04, including interest on the public debt, making an aggregate of $74,963,058.41. leaving an estimated balance in the Treasury at the close of the present fiscal year of $426,875.67. The amount of the public debt at the commencement of the present fiscal year was $29,060,386.90. The amount redeemed since the 1st of July was $3,895,232.39, leaving a balance unredeemed at this time of $25,165,154.51. The amount of estimated expenditures for the remaining 3 quarters of the present fiscal year will in all probability be increased from the causes set forth in the report of the Secretary. His suggestion, therefore, that authority should be given to supply any temporary deficiency by the issue of a limited amount of Treasury notes is approved, and I accordingly recommend the passage of such a law. As stated in the report of the Secretary, the tariff of March 3, 1857, has been in operation for so short a period of time, and under circumstances so unfavorable to a just development of its results as a revenue measure, that I should regard it as inexpedient, at least for the present, to undertake its revision. I transmit herewith the reports made to me by the Secretaries of War and of the Navy, of the Interior, and of the Postmaster General. They all contain valuable and important information and suggestions, which I commend to the favorable consideration of Congress. I have already recommended the raising of 4 additional regiments, and the report of the Secretary of War presents strong reasons proving this increase of the Army under existing circumstances to be indispensable. I would call the special attention of Congress to the recommendation of the Secretary of the Navy in favor of the construction of 10 small war steamers of light draft. For some years, the government has been obliged on many occasions to hire such steamers from individuals to supply its pressing wants. At the present moment, we have no armed vessel in the Navy which can penetrate the rivers of China. We have but few which can enter any of the harbors south of Norfolk, although many millions of foreign and domestic commerce annually pass in and out of these harbors. Some of our most valuable interests and most vulnerable points are thus left exposed. This class of vessels of light draft, great speed, and heavy guns would be formidable in coast defense. The cost of their construction will not be great, and they will require but a comparatively small expenditure to keep them in commission. In time of peace, they will prove as effective as much larger vessels and more useful. One of them should be at every station where we maintain a squadron, and 3 or 4 should be constantly employed on our Atlantic and Pacific coasts. Economy, utility, and efficiency combine to recommend them as almost indispensable. 10 of these small vessels would be of incalculable advantage to the naval service, and the whole cost of their construction would not exceed $2,300,000, or $230,000 each. The report of the Secretary of Interior is worthy of grave consideration. It treats of the numerous, important, and diversified branches of domestic administration entrusted to him by law. Among these, the most prominent are the public lands and our relations with the Indians. Our system for the disposal of the public lands, originating with the fathers of the Republic, has been improved as experience pointed the way, and gradually adapted to the growth and settlement of our Western states and territories. It has worked well in practice. Already 13 states and 7 territories have been carved out of these lands, and still more than 1,000 millions of acres remain unsold. What a boundless prospect this presents to our country of future prosperity and power! We have heretofore disposed of 363,862,464 acres of the public land. Whilst the public lands as a source of revenue are of great importance, their importance is far greater as furnishing homes for a hardy and independent race of honest and industrious citizens who desire to subdue and cultivate the soil. They ought to be administered mainly with a view of promoting this wise and benevolent policy. In appropriating them for any other purpose, we ought to use even greater economy than if they had been converted into money and the proceeds were already in the public treasury. To squander away this richest and noblest inheritance which any people have ever enjoyed upon objects of doubtful constitutionality or expediency would be to violate one of the most important trusts ever committed to any people. Whilst I do not deny to Congress the power, when acting bona fide as a proprietor, to give away portions of them for the purpose of increasing the value of the remainder, yet, considering the great temptation to abuse this power, we cannot be too cautious in its exercise. Actual settlers under existing laws are protected against other purchasers at the public sales in their right of preemption to the extent of a quarter section or 160 acres of land. The remainder may then be disposed of at public or entered at private sale in unlimited quantities. Speculation has of late years prevailed to a great extent in the public lands. The consequence has been that large portions of them have become the property of individuals and companies, and thus the price is greatly enhanced to those who desire to purchase for actual settlement. In order to limit the area of speculation as much as possible, the extinction of the Indian title and the extension of the public surveys ought only to keep pace with the tide of emigration. If Congress should hereafter grant alternative sections to state or companies as they have done heretofore, I recommend that the intermediate sections retained by the government should be subject to preemption by actual settlers. It ought ever to be our cardinal policy to reserve the public lands as much as may be for actual settlers, and this at moderate prices. We shall thus not only best promote the prosperity of the new states and territories and the power of the Union, but shall secure homes for our posterity for many generations. The extension of our limits has brought within our jurisdiction many additional and populous tribes of Indians, a large proportion of which are wild, untractable, and difficult to control. Predatory and warlike in their disposition and habits, it is impossible altogether to restrain them from committing aggressions on each other, as well as upon our frontier citizens and those emigrating to our distant states and territories. Hence, expensive military expeditions are frequently necessary to overawe and chastise the more lawless and hostile. The present system of making them valuable presents to influence them to remain at peace has proved ineffectual. It is believed to be the better policy to colonize them in suitable localities where they can receive the rudiments of education and be gradually induced to adopt habits of industry. So far as the experiment has been tried, it has worked well in practice, and it will doubtless prove to be less expensive than the present system. The whole number of Indians within our territorial limits is believed to be, from the best data in the Interior Department, about 325,000. The tribes of Cherokees, Choctaws, Chickasaws, and Creeks settled in the territory set apart for them west of Arkansas are rapidly advancing in education and in all the arts of civilization and self-government, and we may indulge the agreeable anticipation that at no very distant day they will be incorporated into the Union as one of the sovereign states. It will be seen from the report of the Postmaster General that the Post Office Department still continues to depend upon the Treasury, as it has been compelled to do for several years past, for an important part of the means of sustaining and extending its operation. Their rapid growth and expansion are shown by a decennial statement of the number of post offices and the length of post roads, commencing with the year 1827. In that year there were 7,000 post offices. In 1837, 11,177. In 1847, 15,146. And in 1857, they number 26,586. In this year, 1,725 post offices have been established and 704 discontinued, leaving a net increase of 1,021. The postmasters of 368 offices are appointed by the President. The length of post roads in 1827 was 105,336 miles. In 1837, 141,242 miles. In 1847, 153,818 miles. And in the year 1857, there are 242,601 miles of post road, including 22,530 miles of railroad on which the mails are transported. The expenditures of the department for the fiscal year ending on the 30th June, 1857, as adjusted by the auditor, amounted to $11,507,670. To defray these expenditures, there was to the credit of the department on the 1st July, 1856, the sum of $789,599. The gross revenue of the year, including the annual allowances for the transportation of free mail matter, produced $8,053,951, and the remainder was supplied by the appropriation from the Treasury of $2,250,000. Granted by the Act of Congress approved August 18, 1856, and by the appropriation of $666,883 made by the Act of March 3, 1857, leaving $252,763 to be carried to the credit of the department in the accounts of the current year. I commend to your consideration the report of the department in relation to the establishment of the overland mail route from the Mississippi River to San Francisco, California. The route was selected with my full concurrence as the one, in my judgment, best calculated to attain the important objects contemplated by Congress. The late disastrous monetary revulsion may have one good effect should it cause both the government and the people to return to the practice of a wise and judicious economy both in public and private expenditures. An overflowing treasury has led to habits of prodigality and extravagance in our legislation. It has induced Congress to make large appropriations to objects for which they never would have provided had it been necessary to raise the amount of revenue required to meet them by increased taxation or by loans. We are now compelled to pause in our career and to scrutinize our expenditures with the utmost vigilance. And in performing this duty, I pledge my cooperation to the extent of my constitutional competency. It ought to be observed that at the same time that true public economy does not consist in withholding the means necessary to accomplish important national objects entrusted to us by the Constitution, and especially such as may be necessary for the common defense. In the present crisis of the country, it is our duty to confine our appropriations to objects of this character, unless in cases where justice to individuals may demand a different course. In all cases, care ought to be taken that the money granted by Congress shall be faithfully and economically applied. Under the federal Constitution, quote, "Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law," end quote, "be approved and signed by the President. And if not approved, quote, he shall return it with his objections to that House in which it shall have originated," end quote. In order to perform this high and responsible duty, sufficient time must be allowed the President to read and examine every bill presented to him for approval. Unless this be afforded, the Constitution becomes a dead letter in this particular, and even worse, it becomes a means of deception. Our constituents, seeing the President's approval and signature attached to each act of Congress, are induced to believe that he has actually performed his duty, when in truth nothing is in many cases more unfounded. From the practice of Congress, such an examination of each bill as the Constitution requires has been rendered impossible. The most important business of each session is generally crowded into its last hours, and the alternative presented to the President is either to violate the constitutional duty which he owes to the people and approve bills for want of time it is impossible he should have examined, or by his refusal to do this subject the country and individuals to great loss and inconvenience. Besides, a practice has grown up of late years to legislate in appropriation bills at the last hours of the session on new and important subjects. This practice constrains the President either to suffer measures to become laws which he does not approve, or to incur the risk of stopping the wheels of the government by vetoing an appropriation bill. Formerly, such bills were confined to specific appropriations for carrying into effect existing laws and the well-established policy of the country, and little time was then required by the President for their examination. For my own part, I have deliberately determined that I shall approve no bills which I have not examined, and it will be a case of extreme and most urgent necessity which shall ever induce me to depart from this rule. I therefore respectfully but earnestly recommend that the two Houses would allow the President at least 2 days previous to the adjournment of each session within which no new bill shall be presented to him for approval. Under the existing joint rule, 1 day is allowed, but this rule has been hitherto so constantly suspended in practice that important bills continue to be presented to him up till the very last moments of the session. In a large majority of cases, no great public inconvenience can arise from the want of time to examine their provisions, because the Constitution has declared that if a bill be presented to the President within the last 10 days of the session, he is not required to return it, either with an approval or with a veto, quote, "in which case it shall not be a law," end quote. It may then lie over and be taken up and passed at the next session. Great inconvenience would only be experienced in regard to appropriation bills, but fortunately, under the late excellent law allowing a salary instead of a per diem to members of Congress, the expense and inconvenience of a called session will be greatly reduced. I cannot conclude without commending to your favorable consideration the interests of the people of this district. Without a representative on the floor of Congress, they have for this very reason peculiar claims upon our just regard. To this, I know, from my long acquaintance with them, they are eminently entitled. End of Section 2. Recording by Gary B. Clayton.
Section 3 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. State of the Union Address, James Buchanan, December 6, 1858, Part 1. Fellow citizens of the Senate and House of Representatives, when we compare the condition of the country at the present day with what it was 1 year ago at the meeting of Congress, we have much reason for gratitude to that Almighty Providence, which has never failed to interpose for our relief at the most critical periods of our history. 1 year ago, the sectional strife between the North and the South on the dangerous subject of slavery had again become so intense as to threaten the peace and perpetuity of the Confederacy. The application for the admission of Kansas as a state into the Union fostered this unhappy agitation and brought the whole subject once more before Congress. It was the desire of every patriot that such measures of legislation might be adopted as would remove the excitement from the States and confine it to the territory where it legitimately belonged. Much has been done, I am happy to say, toward the accomplishment of this object during the last session of Congress. The Supreme Court of the United States had previously decided that all American citizens have an equal right to take into the territories whatever is held as property under the laws of any of the states, and to hold such property there under the guardianship of the Federal Constitution so long as the territorial condition shall remain. This is now a well-established position, and the proceedings of the last session were alone wanting to give it practical effect. The principle has been recognized in some form or another by an almost unanimous vote of both houses of Congress, that a territory has a right to come into the Union either as a free or a slave state, according to the will of a majority of its people. The just equality of all the states has thus been vindicated, and a fruitful source of dangerous dissension among them has been removed. Whilst such has been the beneficial tendency of your legislative proceedings outside of Kansas, their influence has nowhere been so happy as within that territory itself. Left to manage and control its own affairs in its own way, without the pressure of external influence, the revolutionary Topeka organization and all resistance to the territorial government established by Congress have been finally abandoned. As a natural consequence, that fine territory now appears to be tranquil and prosperous, and is attracting increasing thousands of immigrants to make it their happy home. The past unfortunate experience of Kansas has enforced the lesson so often already taught, that resistance to lawful authority under our form of government cannot fail in the end to prove disastrous to its authors. Had the people of the territory yielded obedience to the laws enacted by their legislature, it would at the present moment have contained a large additional population of industrious and enterprising citizens who have been deterred from entering its borders by the existence of civil strife and organized rebellion. It was the resistance to rightful authority and the persevering attempts to establish a revolutionary government under the Topeka Constitution which caused the people of Kansas to commit the grave error of refusing to vote for delegates to the convention to frame a constitution under a law not denied to be fair and just in its provisions. This refusal to vote has been the prolific source of all the evils which have followed. In their hostility to the territorial government, they disregarded the principle, absolutely essential to the working of our form of government, that a majority of those who vote, not the majority who may remain at home, from whatever cause, must decide the result of an election. For this reason, seeking to take advantage of their own error, they denied the authority of the convention thus elected to frame a constitution. The convention, notwithstanding, proceeded to adopt a constitution unexceptionable in its general features, and providing for the submission of the slavery question to a vote of the people, which, in my opinion, they were bound to do under the Kansas and Nebraska Act. This was the all-important question which had alone convulsed the territory, and yet the opponents of the lawful government, persisting in their first error, refrained from exercising their right to vote, and preferred that slavery should continue rather than surrender their revolutionary Topeka organization. A wiser and better spirit seemed to prevail before the first Monday of January last, when an election was held under the Constitution. A majority of the people then voted for a governor and other state officers. for a member of Congress and members of the state legislature. This election was warmly contested by the two political parties in Kansas, and a greater vote was polled than at any previous election. A large majority of the members of the legislature elect belonged to that party which had previously refused to vote. The anti-slavery party were thus placed in the ascendant, and the political power of the state was in their own hands. Had Congress admitted Kansas into the Union under the Lecompton Constitution, the legislature might at its very first session have submitted the question to a vote of the people whether they would or would not have a convention to amend their constitution, either on the slavery or on any other question, and have adopted all necessary means for giving speedy effect to the will of the majority. Thus, the Kansas question would have been immediately and finally settled. Under these circumstances, I submitted to Congress the Constitution thus framed, with all the officers already elected necessary to put the state government into operation, accompanied by a strong recommendation in favor of the admission of Kansas as a state. In the course of my long public life, I have never performed any official act which, in the retrospect, has afforded me more heartfelt satisfaction. Its admission could have inflicted no possible injury on any human being, whilst it would within a brief period have restored peace to Kansas and harmony to the Union. In that event, the slavery question would ere this have been finally settled, according to the legally expressed will of a majority of the voters, and popular sovereignty would thus have been vindicated in a constitutional manner. With my deep convictions of duty, I could have pursued no other course. It is true that as an individual I had expressed an opinion, both before and during the session of the convention, in favor of submitting the remaining clauses of the Constitution, as well as that concerning slavery to the people. But, acting in an official character, neither myself nor any human authority had the power to rejudge the proceedings of the convention and declare the Constitution which it had framed to be a nullity. To have done this would have been a violation of the Kansas and Nebraska Act, which left the people of the territory perfectly free to form and regulate their domestic institutions in their own way, subject only to the Constitution of the United States. It would equally have violated the great principle of popular sovereignty at the foundation of our institutions to deprive the people of the power, if they thought proper to exercise it, of confiding to delegates elected by themselves the trust of framing a constitution, without requiring them to subject their constituents to the trouble, expense, and delay of a second election. It would have been in opposition to many precedents in our history, commencing in the very best age of the Republic, of the admission of territories as states into the Union without a previous vote of the people approving their constitution. It is to be lamented that a question so insignificant, when viewed in its practical effects on the people of Kansas, whether decided one way or the other, should have kindled such a flame of excitement throughout the country. This reflection may prove to be a lesson of wisdom and of warning for our future guidance. Practically considered, the question is simply whether the people of that territory should first come into the Union and then change any provision in their constitution not agreeable to themselves, or accomplish the very same object by remaining out of the Union and framing another constitution in accordance with their will. In either case, the result would be precisely the same. The only difference in point of fact is that the object would have been much sooner attained, and the pacification of Kansas more speedily effected, had it been admitted as a state during the last session of Congress. My recommendation, however, for the immediate admission of Kansas failed to meet the approbation of Congress. They deemed it wiser to adopt a different measure for the settlement of the question. For my own part, I should have been willing to yield my assent to almost any constitutional measure to accomplish this object. I therefore cordially acquiesced in what has been called the English Compromise, and approved the act for the admission of the State of Kansas into the Union upon the terms therein prescribed. Under the ordinance which accompanied the Lecompton Constitution, the people of Kansas had claimed double the quantity of public lands for the support of common schools, which had ever been previously granted to any state upon entering the Union, and also the alternate sections of land for 12 miles on each side of 2 railroads proposed to be constructed from the northern to the southern boundary and from the eastern to the western boundary of the state. Congress deeming these claims unreasonable, provided by the act of May 4, 1858, to which I have just referred, for the admission of the state on an equal footing with the original states, but upon the fundamental condition precedent that a majority of the people thereof, at an election to be held for that purpose, should, in place of the very large grants of public lands which they had deemed under the ordinance, accept such grants as had been made to Minnesota and other new states. Under this act, should a majority reject the proposition offered them, it shall be deemed and held that the people of Kansas do not desire admission into the Union with said Constitution under the conditions set forth in said proposition. In that event, the act authorizes the people of the territory to elect delegates to form a constitution and state government for themselves, whenever and not before it is ascertained by a census duly and legally taken that the population of said territory equals or exceeds the ratio of representation required for a member of the House of Representatives of the Congress of the United States. The delegates thus assembled shall first determine by a vote whether it is the wish of the people of the proposed state to be admitted into the Union at that time, and if so, shall proceed to form a constitution and take all necessary steps for the establishment of a state government in conformity with the federal Constitution. After this constitution shall have been formed, Congress, carrying out the principles of popular sovereignty and non-intervention, have left the mode and manner of its approval or ratification by the people of the proposed state to be prescribed by law, and they shall then be admitted into the Union as a state under such constitution, thus fairly and legally made, with or without slavery, as said constitution may prescribe. An election was held throughout Kansas, in pursuance of the provisions of this act, on the 2nd day of August last, and it resulted in the rejection by a large majority of the proposition submitted to the people by Congress. This being the case, they are now authorized to form another constitution, preparatory to admission into the Union, but not until their number, as ascertained by a census, shall equal or exceed the ratio required to elect a member to the House of Representatives. It is not probable, in the present state of the case, that a third constitution can be lawfully framed and presented to Congress by Kansas before its population shall have reached the designated number, nor is it to be presumed that after their sad experience in resisting the territorial laws, they will attempt to adopt a constitution in express violation of the provisions of an act of Congress. During the session of 1856, much of the time of Congress was occupied on the question of admitting Kansas under the Topeka Constitution. Again, nearly the whole of the last session was devoted to the question of its admission under the Lecompton Constitution. Surely it is not unreasonable to require the people of Kansas to wait before making a third attempt until the number of their inhabitants shall amount to 93,420. During this brief period, the harmony of the states, as well as the great business interests of the country, demand that the people of the Union shall not for a third time be convulsed by another agitation on the Kansas question, By waiting for a short time and acting in obedience to law, Kansas will glide into the Union without the slightest impediment. This excellent provision, which Congress have applied to Kansas, ought to be extended and rendered applicable to all territories which may hereafter seek admission into the Union. Whilst Congress possesses the undoubted power of admitting a new state into the Union, however small may be the number of its inhabitants, yet this power ought not, in my opinion, to be exercised before the population shall amount to the ratio required by the act for the admission of Kansas. Had this been previously the rule, the country would have escaped all the evils and misfortunes to which it has been exposed by the Kansas question. Of course, it would be unjust to give this rule a retrospective application and exclude a state which, acting upon the past practice of the government, has already formed its constitution, elected its legislature and other officers, and is now prepared to enter the Union. The rule ought to be adopted whether we consider its bearing on the people of the territories or upon the people of the existing states. Many of the serious dissensions which have prevailed in Congress and throughout the country would have been avoided had this rule been established at an earlier period of the government. Immediately upon the formation of a new territory, people from different states and from foreign countries rush into it for the laudable purpose of improving their condition. Their first duty to themselves is to open and cultivate farms, to construct roads, to establish schools, to erect places of religious worship, and to devote their energies generally to reclaim the wilderness and to lay the foundations of a flourishing and prosperous commonwealth. If in this incipient condition, with a population of a few thousand, they should prematurely enter the Union, they are oppressed by the burden of the state taxation, and the means necessary for the improvement of the territory and the advancement of their own interests are thus diverted to very different purposes. The federal government has ever been a liberal parent to the territories and a generous contributor to the useful enterprises of the early settlers. It has paid the expenses of their governments and legislative assemblies out of the common treasury, and thus relieved them from a heavy charge. Under these circumstances, nothing can better be calculated to retard their material progress than to divert them from their useful employments by prematurely exciting angry political contests among themselves for the benefit of aspiring leaders. It is surely no hardship for embryo governors, senators, and members of Congress to wait until the number of inhabitants shall equal those of a single congressional district. They surely ought not to be permitted to rush into the Union with a population less than one half of several of the large counties in the interior of some of the states. This was the condition of Kansas when it made application to be admitted under the Topeka Constitution. Besides, it requires some time to render the mass of a population collected in a new territory at all homogeneous and to unite them on anything like a fixed policy. Establish the rule, and all will look forward to it and govern themselves accordingly. But justice to the people of the several states require that this rule should be established by Congress. Each state is entitled to 2 senators and at least 1 representative in Congress. Should the people of the states fail to elect a vice president, the power devolves upon the Senate to select this officer from the 2 highest candidates on the list. In case of the death of the president, the vice president thus elected by the Senate becomes president of the United States. On all questions of legislation, the senators from the smallest states of the Union have an equal vote with those from the largest. The same may be said in regard to the ratification of treaties and of executive appointments. All this has worked admirably in practice, whilst it conforms in principle with the character of a government instituted by sovereign states. I presume no American citizen would desire the slightest change in the arrangement. Still, Is it not unjust and unequal to the existing states to invest some 40,000 or 50,000 people collected in a territory with the attributes of sovereignty and place them on an equal footing with Virginia and New York in the Senate of the United States? For these reasons, I earnestly recommend the passage of a general act which shall provide that upon the application of a territorial legislature declaring their belief that the territory contains a number of inhabitants which, if in a state, would entitle them to elect a member of Congress, it shall be the duty of the President to cause a census of the inhabitants to be taken, and if found sufficient, then, by the terms of this act, to authorize them to proceed in their own way to frame a state constitution preparatory to admission into the Union. I also recommend that an appropriation be made to enable the President to take a census of the people of Kansas. The present condition of the territory of Utah, when contrasted with what it was 1 year ago, is a subject for congratulation. It was then in a state of open rebellion, and, cost what it might, the character of the government required that this rebellion should be suppressed, and the Mormons compelled to yield obedience to the Constitution and the laws. In order to accomplish this object, as I informed you in my last annual message, I appointed a new governor instead of Brigham Young, and other federal officers to take the place of those who, consulting their personal safety, had found it necessary to withdraw from the territory. To protect these civil officers and to aid them as a posse comitatus in the execution of the laws, in case of need, I ordered a detachment of the Army to accompany them to Utah. The necessity for adopting these measures is now demonstrated. On the 15th of September, 1857, Governor Young issued his proclamation in the style of an independent sovereign, announcing his purpose to resist by force of arms the entry of the United States troops into our own territory of Utah. By this he acquired all the forces in the territory to hold themselves in readiness to march at a moment's notice to repel any and all such invasion, and establish martial law from its date throughout the territory. These proved to be no idle threats. Forts Bridger and Supply were vacated and burnt down by the Mormons to deprive our troops of a shelter after their long and fatiguing march. Orders were issued by Daniel H. Wells, styling himself Lieutenant General Nauvoo Legion, to stampede the animals of the United States troops on their march, to set fire to their trains, to burn the grass and the whole country before them and on their flanks, to keep them from sleeping by night surprises, and to blockade the road by felling trees and destroying the fords of rivers, etc. These orders were promptly and effectually obeyed. On the 4th of October, 1857, the Mormons captured and burned on Green River 3 of our supply trains, consisting of 75 wagons loaded with provisions and tents for the army, and carried away several hundred animals. This diminished the supply of provisions so materially that General Johnston was obliged to reduce the ration, and even with this precaution there was only sufficient left to subsist the troops until the 1st of June. Our little army behaved admirably in the encampment at Fort Bridger under these trying privations. In the midst of the mountains, in a dreary, unsettled, and inhospitable region, more than 1,000 miles from home, they passed the severe and inclement weather without a murmur. They looked forward with confidence for relief from their country in due season, and in this they were not disappointed. The Secretary of War employed all his energies to forward them the necessary supplies, and to muster and send such a military force to Utah as would render resistance on the part of the Mormons hopeless, and thus terminate the war without the effusion of blood. In his efforts, he was efficiently sustained by Congress. They granted appropriations sufficient to cover the deficiency thus necessarily created, and also provided for raising 2 regiments of volunteers for the purpose of quelling disturbances in the territory of Utah, for the protection of supply and emigrant trains, and the suppression of Indian hostilities on the frontiers. Happily, there was no occasion to call these regiments into service. If there had been, I should have felt serious embarrassment in selecting them. So great was the number of our brave and patriotic citizens anxious to serve their country in this distant and apparently dangerous expedition. Thus it has ever been, and thus it may ever be. The wisdom and economy of sending sufficient reinforcements to Utah are established not only by the event, but in the opinion of those who, from their position and opportunities, are the most capable of forming a correct judgment. General Johnston, the commander of the forces, in addressing the Secretary of War from Fort Bridger, under date of October 18, 1857, expresses the opinion that unless a large force is sent here, from the nature of the country, a protracted war on their, the Mormons' part is inevitable. This he considered necessary to terminate the war speedily and more economically than if attempted by insufficient means. In the meantime, it was my anxious desire that the Mormons should yield obedience to the Constitution and the laws without rendering it necessary to resort to military force. To aid in accomplishing this object, I deemed it advisable in April last to dispatch 2 distinguished citizens of the United States, Messrs. Powell and McCulloch, to Utah. They bore with them a proclamation addressed by myself to the inhabitants of Utah, dated on the 6th day of the month, warning them of their true condition, and how hopeless it was on their part to persist in rebellion against the United States, and offering all those who should submit to the laws a full pardon for their past seditions and treasons. At the same time, I assured those who should persist in rebellion against the United States that they must expect no further lenity, but look to be rigorously dealt with according to their deserts. The instructions to these agents, as well as a copy of the proclamation and their reports, are herewith submitted. It will be seen by their report on the 3rd of July last that they have fully confirmed the opinion expressed by General Johnston in the previous October as to the necessity of sending reinforcements to Utah. In this they state that they are firmly impressed with the belief that the presence of the Army here and the large additional force that had been ordered to this territory were the chief inducements that caused the Mormons to abandon the idea of resisting the authority of the United States. A less decisive policy would probably have resulted in a long, bloody, and expensive war. These gentlemen conducted themselves to my entire satisfaction, and rendered useful services in executing the humane intentions of the government. It also affords me great satisfaction to state that Governor Cumming has performed his duty in an able and conciliatory manner, and with the happiest effect. I cannot in this connection refrain from mentioning the valuable services of Colonel Thomas L. Kane, who, from motives of pure benevolence and without any official character or pecuniary compensation, visited Utah during the last inclement winter for the purpose of contributing to the pacification of the territory. I am happy to inform you that the governor and other civil officers of Utah are now performing their appropriate functions without resistance. The authority of the Constitution and the laws have been fully restored, and peace prevails throughout the territory. A portion of the troops sent to Utah are now encamped in Cedar Valley, 44 miles southwest of Salt Lake City, and the remainder have been ordered to Oregon to suppress Indian hostilities. The march of the army to Salt Lake City through the Indian Territory has had a powerful effect in restraining the hostile feelings against the United States, which existed among the Indians in that region, and in securing emigrants to the far West against their depredations. This will also be the means of establishing military posts and promoting settlements along the route. I recommend that the benefits of our land laws and preemption system be extended to the people of Utah by the establishment of a land office in that territory. I have occasion also to congratulate you on the result of our negotiations with China. You were informed by my last annual message that our minister had been instructed to occupy a neutral position in the hostilities conducted by Great Britain and France against Canton. He was, however, at the same time directed to cooperate cordially with the British and French ministers in all peaceful measures to secure by treaty those just concessions to foreign commerce which the nations of the world had a right to demand. It was impossible for me to proceed further than this on my own authority without usurping the war-making power which under the Constitution belongs exclusively to Congress. Besides, after a careful examination of the nature and extent of our grievances, I did not believe they were of such pressing and aggravated character as would have justified Congress in declaring war against the Chinese Empire without first making another earnest attempt to adjust them by peaceful negotiation. I was the more inclined to this opinion because of the severe chastisement which had then but recently been inflicted upon the Chinese by our squadron in the capture and destruction of the barrier forts to avenge an alleged insult to our flag. The event has proved the wisdom of our neutrality. Our minister has executed his instructions with eminent skill and ability. In conjunction with the Russian plenipotentiary, he has peacefully but effectually cooperated with the English and French plenipotentiaries, and each of the four powers has concluded a separate treaty with China of a highly satisfactory character. The treaty concluded by our own plenipotentiary will immediately be submitted to the Senate. I am happy to announce that through the energetic yet conciliatory efforts of our Consul General in Japan, a new treaty has been concluded with that empire, which may be expected materially to augment our trade and intercourse in that quarter, and to remove from our countrymen the disabilities which have heretofore been imposed upon the exercise of their religion. The treaty shall be submitted to the Senate for approval without delay. It is my earnest desire that every misunderstanding with the government of Great Britain should be amicably and speedily adjusted. It has been the misfortune of both countries, almost ever since the period of the Revolution, to have been annoyed by a succession of irritating and dangerous questions threatening the friendly relations. This has partially prevented the full development of those feelings of mutual friendship between the people of the two countries, so natural in themselves and so conducive to their common interest. Any serious interruption of the commerce between the United States and Great Britain would be equally injurious to both. In fact, no two nations have ever existed on the face of the earth which could do each other so much good or so much harm. Entertaining these sentiments, I am gratified to inform you that the long pending controversy between the two governments in relation to the question of visitation and search has been amicably adjusted. The claim on the part of Great Britain forcibly to visit American vessels on the high seas in time of peace could not be sustained under the law of nations, and it had been overruled by her own most eminent jurists. This question was recently brought to an issue by the repeated acts of British cruisers in boarding and searching our merchant vessels in the Gulf of Mexico and the adjacent seas. These acts were the more injurious and annoying as these waters are traversed by a large portion of the commerce and navigation of the United States, and their free and unrestricted use is essential to the security of the coastwise trade between the different states of the Union. Such vexatious interruptions could not fail to excite the feelings of the country and to require the interposition of the government. Remonstrances were addressed to the British government against these violations of our rights of sovereignty, and a naval force was at the same time ordered to the Cuban waters with directions to protect all vessels of the United States on the high seas from a search or detention by the vessels of war of any other nation. These measures received the unqualified and even enthusiastic approbation of the American people. Most fortunately, however, no collision took place, and the British government promptly avowed its recognition of the principles of international law upon this subject, as laid down by the government of the United States in the note of the Secretary of State to the British minister at Washington of April 10, 1858, which secured the vessels of the United States upon the high seas from visitation or search in time of peace under any circumstances whatever. The claim has been abandoned in a manner reflecting honor on the British government and evincing a just regard for the law of nations, and cannot fail to strengthen the amicable relations between the two countries. The British government, at the same time, proposed to the United States that some mode should be adopted by mutual arrangement between the two countries of a character which may be found effective without being offensive, for verifying the nationality of vessels suspected on good grounds of carrying false colors. They have also invited the United States to take the initiative and propose measures for this purpose. Whilst declining to assume so grave a responsibility, the Secretary of State has informed the British government that we are ready to receive any proposals which they may feel disposed to offer, having this object in view, and to consider them in an amicable spirit. A strong opinion is, however, expressed that the occasional abuse of the flag of any nation is an evil far less to be deprecated than would be the establishment of any regulations which might be incompatible with the freedom of the seas. This government has yet received no communication specifying the manner in which the British government would propose to carry out their suggestion, and I am inclined to believe that no plan which can be devised will be free from grave embarrassments. Still, I shall form no decided opinion on the subject until I shall have carefully and in the best spirit examined any proposals which they may think proper to make. I am truly sorry I cannot also inform you that the complications between Great Britain and the United States, arising out of the Clayton and Bulwer Treaty of April 1850, have been finally adjusted. At the commencement of your last session, I had reason to hope that, emancipating themselves from further unavailing discussions, the two governments would proceed to settle the Central American questions in a practical manner, alike honorable and satisfactory to both, and this hope I have not yet abandoned. In my last annual message I stated that overtures had been made by the British government for this purpose in a friendly spirit, which I cordially reciprocated. Their proposal was to withdraw these questions from direct negotiation between the two governments, but to accomplish the same object by a negotiation between the British government and each of the Central American republics, whose territorial interests are immediately involved. The settlement was to be made in accordance with the general tenor of the interpretation placed upon the Clayton and Bulwer Treaty by the United States, with certain modifications. As negotiations are still pending upon this basis, it would not be proper for me now to communicate their present condition. A final settlement of these questions is greatly to be desired, as this would wipe out that last remaining subject of dispute between the two countries. Our relations with the great empires of France and Russia, as well as with all other governments on the continent of Europe except that of Spain, continue to be of the most friendly character. With Spain, our relations remain in an unsatisfactory condition. In my message of December last, I informed you that our envoy extraordinary and minister plenipotentiary to Madrid had asked for his recall, and it was my purpose to send out a new minister to that court with special instructions on all questions pending between the two governments, and with a determination to have them speedily and amicably adjusted if that were possible. This purpose has been hitherto defeated by causes which I need not enumerate. The mission to Spain has been entrusted to a distinguished citizen of Kentucky who will proceed to Madrid without delay and make another and a final attempt to obtain justice from that government. Spanish officials under the direct control of the Captain General of Cuba have insulted our national flag, and in repeated instances have from time to time inflicted injuries on the persons and properties of our citizens. These have given birth to numerous claims against the Spanish government, the merits of which have been ably discussed for a series of years by our successive diplomatic representatives. Notwithstanding this, we have not arrived at a practical result in any single instance, unless we may except the case of the Black Warrior under the late administration, and that presented an outrage of such a character as would have justified an immediate resort to war. All our attempts to obtain redress have been baffled and defeated. The frequent and oft-recurring changes in the Spanish ministry have been employed as reasons for delay. We have been compelled to wait again and again until the new minister shall have had time to investigate the justice of our demands. Even what have been denominated the Cuban claims, in which more than 100 of our citizens are directly interested, have furnished no exception. These claims were for the refunding of duties unjustly exacted from American vessels at different custom houses in Cuba, so long ago as the year 1844. The principles upon which they rest are so manifestly equitable and just that after a period of nearly 10 years in 1854 they were recognized by the Spanish government. Proceedings were afterwards instituted to ascertain their amount, and this was finally fixed, according to their own statement, with which we were satisfied, as the sum of $128,635.54, just at that moment, after a delay of 14 years. When we had reason to expect that this sum would be repaid with interest, we have received a proposal offering to refund one-third of that amount, $42,878.41, but without interest, if we would accept this in full satisfaction. The offer is also accompanied by a declaration that this indemnification is not founded on any reason of strict justice, but is made as a special favor. One alleged cause for procrastination in the examination and adjustment of our claims arises from an obstacle which it is the duty of the Spanish government to remove. Whilst the Captain General of Cuba is invested with general despotic authority in the government of that island, the power is withheld from him to examine and redress wrongs committed by officials under his control on citizens of the United States. Instead of making our complaints directly to him at Havana, we are obliged to present them through our minister at Madrid. These are then referred back to the Captain General for information, and much time is thus consumed in preliminary investigations and correspondence between Madrid and Cuba before the Spanish government will consent to proceed to negotiation. Many of the difficulties between the two governments would be obviated and a long train of negotiation avoided if the Captain General were invested with authority to settle questions of easy solutions on the spot, where all the facts are fresh and could be promptly and satisfactorily ascertained. We have hitherto in vain urged upon the Spanish government to confer this power upon the Captain General, and our minister to Spain will again be instructed to urge this subject on their notice. In this respect we occupy a different position from the powers of Europe. Cuba is almost within the sight of our shores. Our commerce with it is far greater than that of any other nation, including Spain itself, and our citizens are in habits of daily and extended personal intercourse with every part of the island. It is therefore a great grievance that when any difficulty occurs, no matter how unimportant, which might be readily settled at the moment, we should be obliged to resort to Madrid, especially when the very first step to be taken there is to refer it back to Cuba. The truth is that Cuba, in its existing colonial condition, is a constant source of injury and annoyance to the American people. It is the only spot in the civilized world where the African slave trade is tolerated, and we are bound by treaty with Great Britain to maintain a naval force on the coast of Africa at much expense both of life and treasure, solely for the purpose of arresting slavers bound to that island. The last serious difficulties between the United States and Great Britain respecting the right of search, now so happily terminated, could never have arisen if Cuba had not afforded a market for slaves. As long as this market shall remain open, there can be no hope for the civilization of benighted Africa. Whilst the demand for slaves continues in Cuba, wars will be waged among the petty and barbarous chiefs in Africa for the purpose of seizing subjects to supply this trade. In such a condition of affairs, it is impossible that the light of civilization and religion can ever penetrate these dark abodes. It has been made known to the world by my predecessors that the United States have on several occasions endeavored to acquire Cuba from Spain by honorable negotiation. If this were accomplished, the last relic of the African slave trade would instantly disappear. We would not, if we could, acquire Cuba in any other manner. This is due to our national character. All the territory which we have acquired since the origin of the government has been by fair purchase from France, Spain, and Mexico, or by the free and voluntary act of the independent state of Texas in blending her destinies with our own. This course we shall ever pursue, unless circumstances should occur which we do not now anticipate, rendering a departure from it clearly justifiable under the imperative and overruling law of self-preservation. The island of Cuba, from its geographical position, commands the mouth of the Mississippi and the immense and annually increasing trade, foreign and coastwise, from the valley of that noble river, now embracing half the sovereign states of the Union. With that island under the dominion of a distant foreign power, this trade of vital importance to these states is exposed to the danger of being destroyed in time of war, and it has hitherto been subjected to perpetual injury and annoyance in time of peace. Our relations with Spain, which ought to be of the most friendly character, must always be placed in jeopardy whilst the existing colonial government over the island shall remain in its present condition. Whilst the possession of the island would be of vast importance to the United States, its value to Spain is comparatively unimportant. Such was the relative situation of the parties when great Napoleon transferred Louisiana to the United States. Jealous as he ever was of the national honor and interests of France, no person throughout the world has imputed blame to him for accepting a pecuniary equivalent for the cession. The publicity which has been given to our former negotiations upon this subject and the large appropriation which may be required to effect this purpose, render it expedient, before making another attempt to renew the negotiation, that I should lay the whole subject before Congress. This is especially necessary, as it may become indispensable to success that I should be entrusted with the means of making an advance to the Spanish government immediately after the signing of the treaty, without awaiting the ratification of it by the Senate. I am encouraged to make this suggestion by the example of Mr. Jefferson, previous to the purchase of Louisiana from France, and by that of Mr. Polk, in view of the acquisition of territory from Mexico. I refer the whole subject to Congress, and commend to it their careful consideration. I repeat the recommendation made in my message of December last, in favor of an appropriation to be paid to the Spanish government for the purpose of distribution among the claimants in the Amistad case. President Polk first made a similar recommendation in December 1847, and it was repeated by my immediate predecessor in December of 1853. I entertain no doubt that indemnity is fairly due to these claimants under our treaty with Spain of October 27, 1795, and whilst demanding justice, we ought to do justice. An appropriation promptly made for this purpose could not fail to exert a favorable influence on our negotiations with Spain. End of Part 1. End of Section 3. Section 4 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. State of the Union Address, James Buchanan, December 6, 1858, Part 2. Our position in relation to the independent states south of us on this continent, and especially those within the limits of North America, is of a peculiar character. The northern boundary of Mexico is coincident with our own southern boundary from ocean to ocean, and we must necessarily feel a deep interest in all that concerns the well-being and the fate of so near a neighbor. We have always cherished the kindest wishes for the success of that republic, and have indulged the hope that it might at last, after all its trials, enjoy peace and prosperity under a free and stable government. We have never hitherto interfered, directly or indirectly, with its internal affairs, and it is a duty which we owe to ourselves to protect the integrity of its territory against the hostile interference of any other power. Our geographical position, our direct interest in all that concerns Mexico, and our well-settled policy in regard to the North American continent render this an indispensable duty. Mexico has been in a state of constant revolution almost ever since it achieved its independence. One military leader after another has usurped the government in rapid succession, and the various constitutions from time to time adopted have been set at naught almost as soon as they were proclaimed. The successive governments have afforded no adequate protection, either to Mexican citizens or foreign residents, against lawless violence. Heretofore, a seizure of the capital by a military chieftain has been generally followed by at least the nominal submission of the country to his rule for a brief period, but not so at the present crisis of Mexican affairs. A civil war has been raging for some time throughout the Republic between the central government at the City of Mexico, which has endeavored to subvert the constitution last framed by military power, and those who maintain the authority of that constitution. The antagonistic parties each hold possession of different states of the Republic, and the fortunes of the war are constantly changing. Meanwhile, the most reprehensible means have been employed by both parties to extort money from foreigners as well as natives to carry on this ruinous contest. The truth is that this fine country, blessed with a productive soil and a benign climate, has been reduced by civil dissension to a condition of almost hopeless anarchy and imbecility. It would be vain for this government to attempt to enforce payment in money of the claims of American citizens now amounting to more than $10 million against Mexico, because she is destitute of all pecuniary means to satisfy these demands. Our late minister was furnished with ample powers and instructions for the adjustment of all pending questions with the central government of Mexico, and he performed his duty with zeal and ability. The claims of our citizens, some of them arising out of the violation of an express provision of the Treaty of Guadalupe Hidalgo, and others from gross injuries to persons as well as property, have remained unredressed and even unnoticed. Remonstrances against these grievances have been addressed without effect to that government. Meantime, in various parts of the Republic, instances have been numerous of the murder, imprisonment, and plunder of our citizens by different parties claiming and exercising a local jurisdiction. But the central government, although repeatedly urged thereto, have made no effort either to punish the authors of these outrages or to prevent their recurrence. No American citizen can now visit Mexico on lawful business without eminent danger to his person and property. There is no adequate protection to either, and in this respect our treaty with that republic is almost a dead letter. This state of affairs was brought to a crisis in May last by the promulgation of a decree levying a contribution pro rata upon all the capital in the Republic between certain specified amounts, whether held by Mexicans or foreigners. Mr. Forsyth, regarding this decree in the light of a forced loan, formally protested against its application to his countrymen and advised them not to pay the contribution, but to suffer it to be forcibly exacted. Acting upon this advice, an American citizen refused to pay the contribution, and his property was seized by armed men to satisfy the amount. Not content with this, the government proceeded still further and issued a decree banishing him from the country. Our minister immediately notified them that if this decree should be carried into execution, he would feel it to be his duty to adopt the most decided measures that belong to the powers and obligations of the representative office. Notwithstanding this warning, the banishment was enforced, and Mr. Forsyth promptly announced to the government the suspension of the political relations of his legation with them until the pleasure of his own government should be ascertained. This government did not regard the contribution imposed by the decree of the 15th May last to be in strictness a forced loan, and as such prohibited by the 10th article of the Treaty of 1826 between Great Britain and Mexico, to the benefits of which American citizens are entitled by treaty. Yet the imposition of the contribution upon foreigners was considered an unjust and oppressive measure. Besides, internal factions in other parts of the Republic were at the same time levying similar exactions upon the property of our citizens and interrupting their commerce. There had been an entire failure on the part of our minister to secure redress for the wrongs which our citizens had endured, notwithstanding his persevering efforts. And from the temper manifested by the Mexican government, he had repeatedly assured us that no favorable change could be expected until the United States should give striking evidence of their will and power to protect their citizens, and that severe chastening is the only earthly remedy for our grievances. From this statement of facts, it would have been worse than idle to direct Mr. Forsyth to retrace his steps and resume diplomatic relations with that government, and it was therefore deemed proper to sanction his withdrawal of the legation from the City of Mexico. Abundant cause now undoubtedly exists for a resort to hostilities against the government, still holding possession of the capital. Should they succeed in subduing the constitutional forces, all reasonable hope will then have expired of a peaceful settlement of our difficulties. On the other hand, should the constitutional party prevail, and their authority be established over the Republic, there is reason to hope that they will be animated by a less unfriendly spirit, and may grant that redress to American citizens which justice requires, so far as they may possess the means. But for this expectation, I should have at once recommended to Congress to grant the necessary power to the President to take possession of a sufficient portion of the remote and unsettled territory of Mexico, to be held in pledge until our injuries shall be redressed and our just demands be satisfied. We have already exhausted every milder means of obtaining justice. In such a case, this remedy of reprisals is recognized by the law of nations not only as just in itself, but as a means of preventing actual war. But there is another view of our relations with Mexico arising from the unhappy condition of affairs along our southwestern frontier, which demands immediate action. In that remote region, where there are but few white inhabitants, large bands of hostile and predatory Indians roam promiscuously over the Mexican states of Chihuahua and Sonora and our adjoining territories. The local governments of these states are perfectly helpless, and are kept in a state of constant alarm by the Indians. They have not the power, if they possessed the will, even to restrain lawless Mexicans from passing the border and committing the depredations on our remote settlers. A state of anarchy and violence prevails throughout that distant frontier. The laws are a dead letter, and life and property wholly insecure. For this reason, the settlement of Arizona is arrested, whilst it is of great importance that a chain of inhabitants should extend all along its southern border sufficient for their own protection and that of the United States mail passing to and from California. Well-founded apprehensions are now entertained that the Indians and wandering Mexicans, equally lawless, may break up the important stage and postal communication recently established between our Atlantic and Pacific possessions. This passes very near to the Mexican boundary throughout the whole length of Arizona. I can imagine no possible remedy for these evils, and no mode of restoring law and order on that remote and unsettled frontier, but for the government of the United States to assume a temporary protectorate over the northern portions of Chihuahua and Sonora, and to establish military posts within the same, and this I earnestly recommend to Congress. This protection may be withdrawn as soon as local governments shall be established in these Mexican states, capable of performing their duties to the United States, restraining the lawless, and preserving peace along the border. I do not doubt that this measure will be viewed in a friendly spirit by the governments and people of Chihuahua and Sonora, as it will prove equally effectual for the protection of their citizens on that remote and lawless frontier as for citizens of the United States. And in this connection, permit me to recall your attention to the condition of Arizona. The population of that territory, numbering, as is alleged, more than 10,000 souls, are practically without a government, without laws, and without any regular administration of justice. Murder and other crimes are committed with impunity. This state of things calls loudly for redress, and I therefore repeat my recommendation for the establishment of a territorial government over Arizona. The political condition of the narrow isthmus of Central America, through which transit routes pass between the Atlantic and Pacific Oceans, presents a subject of deep interest to all commercial nations. It is over these transits that a large proportion of the trade and travel between the European and Asiatic continents is destined to pass. To the United States, these routes are of incalculable importance as a means of communication between their Atlantic and Pacific possessions. The latter now extended throughout 17 degrees of latitude on the Pacific coast, embracing the important state of California and the flourishing territories of Oregon and Washington. All commercial nations, therefore, have a deep and direct interest that these communications shall be rendered secure from interruption. If an arm of the sea connecting the two oceans penetrated through Nicaragua and Costa Rica, it could not be pretended that these states would have the right to arrest or retard its navigation to the injury of other nations. The transit by land over this narrow isthmus occupies nearly the same position. It is a highway in which they themselves have little interest when compared with the vast interests of the rest of the world. Whilst their rights of sovereignty ought to be respected, it is the duty of other nations to require that this important passage shall not be interrupted by the civil wars and revolutionary outbreaks which have so frequently occurred in that region. The stake is too important to be left at the mercy of rival companies claiming to hold conflicting contracts with Nicaragua. The commerce of other nations is not to stand still and await the adjustment of such petty controversies. The government of the United States expect no more than this, and they will not be satisfied with less. They would not, if they could, derive any advantage from the Nicaragua transit, not common to the rest of the world. Its neutrality and protection for the common use of all nations is their only object. They have no objection that Nicaragua shall demand and receive a fair compensation from the companies and individuals who may traverse the route, but they insist that it shall never hereafter be closed by an arbitrary decree of that government. If disputes arise between it and those with whom they may have entered into contracts, these must be adjusted by some fair tribunal provided for the purpose, and the route must not be closed pending the controversy. This is our whole policy, and it cannot fail to be acceptable to other nations. All these difficulties might be avoided if, consistently with the good faith of Nicaragua, the use of this transit could be thrown open to general competition, providing at the same time for the payment of a reasonable rate to the Nicaraguan government on passengers and freight. In August 1852, the Accessory Transit Company made its first interoceanic trip over the Nicaraguan route and continued in successful operation with great advantage to the public until the 18th February, 1856, when it was closed, and the grant to this company, as well as its charter, were summarily and arbitrarily revoked by the government of President Rivas. Previous to this date, however, in 1854, serious disputes concerning the settlement of their accounts had arisen between the company and the government, threatening the interruption of the route at any moment. These the United States in vain endeavored to compose. It would be useless to narrate the various proceedings which took place between the parties up till the time when the transit was discontinued. Suffice it to say that since February 1856 it has remained closed, greatly to the prejudice of citizens of the United States. Since that time the competition has ceased between the rival routes of Panama and Nicaragua, and in consequence thereof an unjust and unreasonable amount has been exacted from our citizens for the passage to and from California. A treaty was signed on the 16th day of November, 1857, by the Secretary of State and Minister of Nicaragua, under the stipulations of which the use and protections of the transit route would have been secured not only to the United States, but equally to all other nations. How and on what pretext this treaty has failed to receive the ratification of the Nicaraguan government will appear by the papers herewith communicated from the State Department. The principal objection seems to have been to the provision authorizing the United States to employ force to keep the route open in case Nicaragua should fail to perform her duty in this respect. From the feebleness of that republic, its frequent changes of government, and its constant internal dissensions, this had become a most important stipulation, and one essentially necessary not only for the security of the route, but for the safety of American citizens passing and repassing to and from our Pacific possessions. Were such a stipulation embraced in a treaty between the United States and Nicaragua, the knowledge of this fact would of itself most probably prevent hostile parties from committing aggressions on the route, and render our actual interference for its protection unnecessary. The executive government of this country and its intercourse with foreign nations is limited to the employment of diplomacy alone. When this fails, it can proceed no further. It cannot legitimately resort to force without the direct authority of Congress, except in resisting and repelling hostile attacks. It would have no authority to enter the territories of Nicaragua, even to prevent the destruction of the transit and protect the lives and property of our own citizens on their passage. It is true that on a sudden emergency of this character, the President would direct any armed force in the vicinity to march to their relief, but in doing this he would act upon his own responsibility. Under these circumstances, I earnestly recommend to Congress the passage of an act authorizing the President, under such restrictions as they may deem proper, to employ the land and naval forces of the United States in preventing the transit from being obstructed or closed by lawless violence, and in protecting the lives and property of American citizens traveling thereupon, requiring at the same time that these forces shall be withdrawn the moment the danger shall have passed away. Without such a provision, our citizens will be constantly exposed to interruption in their progress and to lawless violence. A similar necessity exists for the passage of such an act for the protection of the Panama and Tehuantepec routes. In reference to the Panama route, the United States, by their existing treaty with New Granada, expressly guarantee the neutrality of the isthmus, with the view that the free transit from the one to the other sea may not be interrupted or embarrassed in any future time while this treaty exists. In regard to the Tehuantepec route, which has been recently opened under the most favorable auspices, our treaty with Mexico of the 30th December 1853 secures to the citizens of the United States a right of transit over it for their persons and merchandise, and stipulates that neither government shall interpose any obstacle thereto. It also concedes to the United States the right to transport across the isthmus in closed bags the mails of the United States not intended for distribution along the line of the communication. Also, the effects of the United States government and its citizens, which may be intended for transit and not for distribution on the isthmus, free of custom house or other charges by the Mexican government. These treaty stipulations with New Granada and Mexico, in addition to the considerations applicable to the Nicaragua route, seem to require legislation for the purpose of carrying them into effect. The injuries which have been inflicted upon our citizens in Costa Rica and Nicaragua during the last 2 or 3 years have received the prompt attention of this government. Some of these injuries were of the most aggravated character. The transaction at Virgin Bay in April 1856, when a company of unarmed Americans, who were in no way connected with any belligerent conduct or party, were fired upon by the troops of Costa Rica, and numbers of them killed and wounded, was brought to the knowledge of Congress by my predecessor soon after its occurrence, and was also presented to the government of Costa Rica for that immediate investigation and redress which the nature of the case demanded. A similar course was pursued with reference to other outrages in these countries, some of which were hardly less aggravated in their character than the transaction at Virgin Bay. At the time, however, when our present minister to Nicaragua was appointed, in December of 1857, no redress had been obtained for any of these wrongs, and no reply even had been received to the demands which had been made by this government upon that of Costa Rica more than a year before. Our minister was instructed, therefore, to lose no time in expressing to those governments the deep regret with which the President had witnessed this inattention to the just claims of the United States, and in demanding their prompt and satisfactory adjustment. Unless this demand shall be complied with at an early day, it will only remain for this government to adopt such other measures as may be necessary in order to obtain for itself that justice which it has in vain attempted to secure by peaceful means from the governments of Nicaragua and Costa Rica. While it has shown and will continue to show the most sincere regard for the rights and honor of these republics, it cannot permit this regard to be met by an utter neglect on their part of what is due to the government and citizens of the United States. Against New Granada, we have long-standing causes of complaint arising out of the unsatisfied claims of our citizens upon that republic, and to these have been more recently added the outrages committed upon our citizens at Panama in April 1856. A treaty for the adjustment of these difficulties was concluded by the Secretary of State and the Minister of New Granada in September of 1857, which contained just and acceptable provisions for that purpose. This treaty was transmitted to Bogota and was ratified by the government of New Granada, but with certain amendments. It was not, however, returned to this city until after the close of the last session of the Senate. It will be immediately transmitted to that body for their advice and consent, and should this be obtained, it will remove all our existing causes of complaint against New Granada on the subject of claims. Questions have arisen between the two governments as to the right of New Granada to levy a tonnage duty upon the vessels of the United States in its ports of the Isthmus, and to levy a passenger tax upon our citizens arriving in that country, whether with a design to remain there or to pass from ocean to ocean by the transit route, and also a tax upon the mail of the United States transported over the Panama Railroad. The government of New Granada has been informed that the United States would consider the collection of either of these taxes as an act in violation of the treaty between the two countries, and as such would be resisted by the United States. At the same time, we are prepared to discuss these questions in a spirit of amity and justice, and with a sincere desire to adjust them in a satisfactory manner. A negotiation for that purpose has already been commenced. No effort has recently been made to collect these taxes, nor is any anticipated under present circumstances. With the Empire of Brazil, our relations are of the most friendly character. The productions of the two countries, and especially those of an agricultural nature, are such as to invite extensive mutual exchanges. A large quantity of American flour is consumed in Brazil, whilst more than treble the amount and value of Brazilian coffee is consumed in the United States. Whilst this is the case, a heavy duty has been levied until very recently upon the importation of American flour into Brazil. I am gratified, however, to be able to inform you that in September last this has been reduced from $1.32 to about 49 cents per barrel, and the duties on other articles of our production have been diminished in nearly the same proportion. I regret to state that the government of Brazil still continues to levy an export duty of about 11% on coffee, notwithstanding this article is admitted free from duty in the United States. This is a heavy charge upon the consumers of coffee in our country, as we purchase half of the entire surplus crop of that article raised in Brazil. Our minister, under instructions, will reiterate his efforts to have this export duty removed, and it is hoped that the enlightened government of the Emperor will adopt this wise, just, and equal policy. In that event, there is good reason to believe that the commerce between the two countries will greatly increase, much to the advantage of both. The claims of our citizens against the government of Brazil are not in the aggregate of very large amount, but some of these rest upon plain principles of justice, and their settlement ought not to be longer delayed. A renewed and earnest, and I trust a successful effort will be made by our minister to procure their final adjustment. On the 2nd of June last, Congress passed a joint resolution authorizing the President to adopt such measures and use such force as in his judgment may be necessary and advisable for the purpose of the differences between the United States and the Republic of Paraguay, in connection with the attack on the United States steamer Water Witch, and which other measures refer to in his annual message, and on the 12th of July following, they made an appropriation to defray the expenses and compensation of a commissioner to that republic, should the President deem it proper to make such all appointment. In compliance with these enactments, I have appointed a commissioner who has proceeded to Paraguay with full powers and instructions to settle these differences in an amicable and peaceful manner, if this be practicable. His experience and discretion justify the hope that he may prove successful in convincing the Paraguayan government that it is due both to honor and justice that they should voluntarily and promptly make atonement for the wrongs which they have committed against the United States, and indemnify our injured citizens whom they have forcibly despoiled of their property. Should our commissioner prove unsuccessful after a sincere and earnest effort to accomplish the object of his mission, then no alternative will remain but the employment of force to obtain just satisfaction from Paraguay. In view of this contingency, the Secretary of the Navy, under my direction, has fitted out and dispatched a naval force to rendezvous near Buenos Aires, which it is believed will prove sufficient for the occasion. It is my earnest desire, however, that it may not be found necessary to resort to this last alternative. When Congress met in December last, the business of the country had just been crushed by one of those periodical revulsions which are the inevitable consequence of our unsound and extravagant system of bank credits and inflated currency. With all the elements of national wealth in abundance, our manufacturers were suspended. Our useful public and private enterprises were arrested, and thousands of laborers were deprived of employment and reduced to want. Universal distress prevailed among the commercial, manufacturing, and mechanical classes. This revulsion was felt the more severely in the United States because similar causes had produced the like deplorable effects throughout the commercial nations of Europe. All were experiencing sad reverses at the same moment. Our manufacturers everywhere suffered severely, not because of the recent reduction in the tariff of duties on imports, but because there was no demand at any price for their productions. The people were obliged to restrict themselves in their purchases to articles of prime necessity. In the general prostration of business, the iron manufacturers in different states probably suffered more than any other class, and much destitution was the inevitable consequence among the great number of workmen who had been employed in this useful branch of industry. There could be no supply where there is no demand. To present an example, there could be no demand for railroad iron after our magnificent system of railroads, extending its benefits to every portion of the Union, had been brought to a dead pause. The same consequences have resulted from similar causes to many other branches of useful manufactures. It is self-evident that where there is no ability to purchase manufactured articles, these cannot be sold, and consequently must cease to be produced. No government, and especially a government of such limited powers as that of the United States, could have prevented the late revulsion. The whole commercial world seemed for years to have been rushing to this catastrophe. The same ruinous consequences would have followed in the United States whether the duties upon foreign imports had remained as they were under the tariff of 1846 or had been raised to a much higher standard. The tariff of 1857 had no agency in the result. The general causes existing throughout the world could not have been controlled by the legislation of any particular country. The periodical revulsions which have existed in our past history must continue to return at intervals so long as our present unbounded system of bank credits shall prevail. They will, however, probably be the less severe in future, because it is not to be expected, at least for many years to come, that the commercial nations of Europe, with whose interests our own are so materially involved, will expose themselves to similar calamities. But this subject was treated so much at large in my last annual message that I shall not now pursue it further. Still, I respectfully renew the recommendation in favor of the passage of a uniform bankrupt law applicable to banking institutions. This is all the direct power over the subject which I believe the federal government possesses. Such a law would mitigate, though it may not prevent, the evil. The instinct of self-preservation might produce a wholesome restraint upon their banking business if they knew in advance that a suspension of specie payments would inevitably produce their civil death. But the effects of the revulsion are now slowly but surely passing away. The energy and enterprise of our citizens, with our unbounded resources, will within the period of another year restore a state of wholesome industry and trade. Capital has again accumulated in our large cities. The rate of interest is there very low. Confidence is gradually reviving, and so soon as it is discovered that this capital can be profitably employed in commercial and manufacturing enterprises and in the construction of railroads and other works of public and private improvement, prosperity will again smile throughout the land. It is vain, however, to disguise the fact from ourselves that a speculative inflation of our currency, without a corresponding inflation in other countries, whose manufactures come into competition with our own, must ever produce disastrous results to our domestic manufacturers. No tariff, short of absolute prohibition, can prevent these evil consequences. In connection with this subject, it is proper to refer to our financial condition. The same causes which have produced pecuniary distress throughout the country have so reduced the amount of imports from foreign countries that the revenue has proved inadequate to meet the necessary expenses of the government. To supply the deficiency, Congress, by the act of December 23, 1857, authorized the issue of $20 million of Treasury notes, and this proving inadequate, They authorized, by the act of June 14, 1858, a loan of $20 million to be applied to the payment of appropriations made by law. No statesman would advise that we should go on increasing the national debt to meet the ordinary expenses of the government. This would be a most ruinous policy. In case of war, our credit must be our chief resource, at least for the first year, and this would be greatly impaired by having contracted a large debt in time of peace. It is our true policy to increase our revenue so as to equal our expenditures. It would be ruinous to continue to borrow. Besides, it may be proper to observe that the incidental protection thus afforded by a revenue tariff would at the present moment, to some extent, increase the confidence of the manufacturing interests and give a fresh impulse to our reviving business. To this surely no person will object. In regard to the mode of assessing and collecting duties under a strictly revenue tariff, I have long entertained and often expressed the opinion that sound policy requires this should be done by specific duties in cases to which these can be properly applied. They are well adapted to commodities which are usually sold by weight or by measure, and which from their nature are of equal or of nearly equal value. Such, for example, are the articles of iron of different classes, raw sugar, and foreign wines and spirits. In my deliberate judgment, specific duties are the best, if not the only means of securing the revenue against false and fraudulent invoices, and such has been the practice adopted for this purpose by other commercial nations. Besides, specific duties would afford to the American manufacturer the incidental advantages to which he is fairly entitled under a revenue tariff. The present system is a sliding scale to his disadvantage. Under it, when prices are high and business prosperous, the duties rise in amount when he least requires their aid. On the contrary, when prices fall and he is struggling against adversity, the duties are diminished in the same proportion, greatly to his injury. Neither would there be danger that a higher rate of duty than that intended by Congress could be levied in the form of specific duties. It would be easy to ascertain the average value of any imported article for a series of years, and instead of subjecting it to an ad valorem duty at a certain rate per centum, to substitute in its place an equivalent specific duty. By such an arrangement the consumer would not be injured. It is true he might have to pay a little more duty on a given article in one year, but if so, he would pay a little less in another, and in a series of years these would counterbalance each other and amount to the same thing so far as his interest is concerned. This inconvenience would be trifling when contrasted with the additional security thus afforded against frauds upon the revenue in which every consumer is directly interested. I have thrown out these suggestions as the fruit of my own observation, to which Congress in their better judgment will give such weight as they may justly deserve. The report of the Secretary of the Treasury will explain in detail the operations of that department of the government. The receipts into the Treasury from all sources during the fiscal year ending June 30th, 1858, including the Treasury notes authorized by the act of December 23rd, 1857, were $70,273,869.59, which amount, with the balance of $17,710,114.27 remaining in the Treasury at the commencement of the year, made an aggregate for the service of the year of $87,983,983.86. The public expenditures during the fiscal year ending June 30th, 1858, amounted to $81,585,667.76, of which $9,684,537.99 were applied to the payment of the public debt and the redemption of Treasury notes with the interest thereon, leaving in the Treasury on July 1st, 1858, being the commencement of the present fiscal year, $6,398,316.10. The receipts into the Treasury during the first quarter of the present fiscal year, commencing the 1st of July, 1858, including one half of the loan of $20 million with the premium upon it authorized by the Act of June 14, 1858, were $25,230,879.46, and the estimated receipts for the remaining 3 quarters to the 30th of June, 1859, from ordinary sources are $38,500,000, making, with the balance before stated, an aggregate of $70,129,195.56. The expenditures during the first quarter of the present fiscal year, $21,708,198.51, of which $1,010,142.37 were applied to the payment of the public debt and the redemption of Treasury notes and the interest thereon. The estimated expenditures during the remaining 3 quarters to June 30th, 1859, are $52,357,698.48, making an aggregate of $74,065,896.99, being in excess of expenditure beyond the estimated receipts into the Treasury from ordinary sources during the fiscal year to the 30th of June, 1859, of $3,936,701.43. Extraordinary means are placed by law within the command of the Secretary of the Treasury by the reissue of Treasury notes redeemed and by negotiating the balance of the loan authorized by the Act of June 14, 1858, to the extent of $11 million, which, if realized during the present fiscal year, will leave a balance in the Treasury on the first day of July, 1859, of $7,063,298.57. The estimated receipts during the next fiscal year ending June 30th, 1860, are $62 million, which, with the above estimated balance of $7,063,298.57, make an aggregate for the service of the next fiscal year of $69,063,298.57. The estimated expenditures during the next fiscal year ending June 30th, 1860, are $73,139,147.46, which leaves a deficit of estimated means, compared with the estimated expenditures for that year, commencing on July 1st, 1859, of $4,075,848.89. In addition to this sum, the Postmaster General will require from the Treasury, for the service of the Post Office Department, $3,838,728, as explained in the report of the Secretary of the Treasury, which will increase the estimated deficit on June 30th, 1860, to $7,914,576.89. To provide for the payment of this estimated deficiency, which will be increased by such appropriations as may be made by Congress, not estimated for in the report of the Treasury Department, as well as to provide for the gradual redemption from year to year of the outstanding Treasury notes, the Secretary of the Treasury recommends such a revision of the present tariff as will raise the required amount. After what I have already said, I need scarcely add that I concur in the opinion expressed in his report, that the public debt should not be increased by an additional loan, and would therefore strongly urge upon Congress the duty of making at their present session the necessary provision for meeting these liabilities. The public debt on July 1st, 1858, the commencement of the present fiscal year, was $25,155,977.66. During the first quarter of the present year, the sum of $10 million has been negotiated of the loan authorized by the Act of June 14, 1858, making the present outstanding public debt, exclusive of the Treasury notes, $35,155,977.66. There was on the 1st of July, 1858, of Treasury notes issued by authority of the Act of December 23, 1857, unredeemed, the sum of $19,754,800, making the amount of actual indebtedness at that date $54,910,777.66. To this will be added $10 million during the present fiscal year, this being the remaining half of the loan of $20 million not yet negotiated. The rapid increase of the public debt and the necessity which exists for a modification of the tariff to meet even the ordinary expenses of the government ought to admonish us all in our respective spheres of duty to the practice of rigid economy. The objects of expenditure should be limited in number as far as this may be practicable, and the appropriations necessary to carry them into effect ought to be disbursed under the strictest accountability. Enlightened economy does not consist in the refusal to appropriate money for constitutional purposes essential to the defense, progress, and prosperity of the Republic, but in taking care that none of this money shall be wasted by mismanagement in its application to the objects designated by law. Comparisons between the annual expenditure at the present time and what it was 10 or 20 years ago are altogether fallacious. The rapid increase of our country in extent and population renders a corresponding increase of expenditure to some extent unavoidable. This is consistently creating new objects of expenditure and augmenting the amount required for the old. The true questions, then, are, have these objects been unnecessarily multiplied, or has the amount expended upon any or all of them been larger than comports with due economy? In accordance with these principles, the heads of the different executive departments of the government have been instructed to reduce their estimates for the next fiscal year to the lowest standard consistent with the efficiency of the service, and this duty they have performed in a spirit of just economy. The estimates of the Treasury, War, Navy, and Interior departments have each been in some degree reduced, and unless a sudden and unforeseen emergency should arise, it is not anticipated that a deficiency will exist in either within the present or the next fiscal year. The Post Office Department is placed in a peculiar position different from the other departments, and to this I shall hereafter refer. I invite Congress to institute a rigid scrutiny to ascertain whether the expenses in all the departments cannot be still further reduced, and I promise them all the aid in my power in pursuing the investigation. I transmit herewith the reports made to me by the Secretaries of War, of the Navy, of the Interior, and of the Postmaster General. They each contain valuable information and important recommendations to which I invite the attention of Congress. In my last annual message, I took occasion to recommend the immediate construction of 10 small steamers of light draft for the purpose of increasing the efficiency of the Navy. Congress responded to the recommendation by authorizing the construction of 8 of them. The progress which has been made in executing this authority is stated in the report of the Secretary of the Navy. I concur with him in the opinion that a greater number of these class of vessels is necessary for the purpose of protecting in a more efficient manner the persons and property of American citizens on the high seas and in foreign countries, as well as in guarding more effectually our own coasts. I accordingly recommend the passage of an act for this purpose. The suggestions contained in the report of the Secretary of the Interior, especially those in regard to the disposition of the public domain, the pension and bounty land system, the policy toward the Indians, and the amendment of our patent laws, are worthy of the serious consideration of Congress. The Post Office Department occupies a position very different from that of the other departments. For many years it was the policy of the government to render this a self-sustaining department, and if this cannot now be accomplished in the present condition of the country, we ought to make as near an approach to it as may be practical. The Postmaster General is placed in a most embarrassing position by the existing laws. He is obliged to carry these into effect. He has no other alternative. He finds, however, that this cannot be done without heavy demands upon the Treasury, over and above what is received for postage, and these have been progressively increasing from year to year until they amounted for the last fiscal year, ending on the 30th of June, 1858, to more than $4,500,000. Whilst it is estimated that for the present fiscal year they will amount to $6,290,000. These sums are exclusive of the annual appropriation of $700,000 for compensation for the mail service performed for the two houses of Congress and the other departments and officers of the government in the transmission of free matter. The cause of these large deficits is mainly attributable to the increased expense of transporting the mails. In 1852 the sum paid for this service was but a fraction above $4 millions and a quarter. Since that year it has annually increased, until in 1858 it has reached more than $8 millions and a quarter, and for the service of 1859 it is estimated that will amount to more than $10 million. The receipts of the Post Office Department can be made to approach or to equal its expenditure only by means of the legislation of Congress. In applying any remedy, care should be taken that the people shall not be deprived of the advantages which they are fairly entitled to enjoy from the Post Office Department. The principal remedies recommended to the consideration of Congress by the Postmaster General are to restore the former rate of postage upon single letters to 5 cents, to substitute for the franking privilege the delivery to those now entitled to enjoy it of post office stamps for their correspondence, and to direct the Department in making contracts for the transportation of the mail to confine itself to the payment of the sum necessary for this single purpose, without requiring it to be transported in post coaches or carriages of any particular description. Under the present system, the expense to the government is greatly increased by requiring that the mail shall be carried in such vehicles as will accommodate passengers. This will be done without pay from the Department over all roads where the travel will remunerate the contractors. These recommendations deserve the grave consideration of Congress. I would call again your attention to the construction of a Pacific Railroad. Time and reflection have but served to confirm me in the truth and justice of the observations which I made on this subject in my last annual message, to which I beg leave respectfully to refer. It is freely admitted that it would be inexpedient for this government to exercise the power of constructing the Pacific Railroad by its own immediate agents. Such a policy would increase the patronage of the executive to a dangerous extent and introduce a system of jobbing and corruption which no vigilance on the part of federal officials could either prevent or detect. This can only be done by the keen eye and active and careful supervision of individual and private interest. The construction of this road ought therefore to be committed to companies incorporated by the states or other agencies whose pecuniary interests would be directly involved. Congress might then assist them in the work by grants of land or of money or both, under such conditions and restrictions as would secure the transportation of troops and munitions of war free from any charge, and that of the United States mail at a fair and reasonable price. The progress of events since the commencement of your last session has shown how soon difficulties disappear before a firm and determined resolution. At that time such a road was deemed by wise and patriotic men to be a visionary project. The great distance to be overcome and the intervening mountains and deserts in the way were obstacles which, in the opinion of many, could not be surmounted. Now, after the lapse of but a single year, these obstacles, it has been discovered, are far less formidable than they were supposed to be, and mail stages with passengers now pass and repass regularly twice in each week by a common wagon road between San Francisco and St. Louis and Memphis in less than 25 days. The service has been as regularly performed as it was in former years between New York and this city. Whilst disclaiming all authority to appropriate money for the construction of this road, except that derived from the war-making power of the Constitution, there are important collateral considerations urging us to undertake the work as speedily as possible. The first and most momentous of these is that such a road would be a powerful bond of union between the states east and west of the Rocky Mountains. This is so self-evident as to require no illustration. But again, in a commercial point of view, I consider this the great question of the day. With the eastern front of our republic stretching along the Atlantic, and its western front along the Pacific, if all the parts should be united by a safe, easy, and rapid intercommunication, we must necessarily command a very large proportion of the trade both of Europe and Asia. Our recent treaties with China and Japan will open these rich and populous empires to our commerce, and the history of the world proves that the nation which has gained possession of the trade with Eastern Asia has always become wealthy and powerful. The peculiar geographical position of California and our Pacific possessions invites American capital and enterprise into this fruitful field. To reap the rich harvest, however, it is an indispensable prerequisite that we shall first have a railroad to convey and circulate its products throughout every portion of the Union. Besides, such a railroad through our temperate latitude, which would not be impeded by the frosts and snows of winter, nor by the tropical heats of summer, would attract to itself much of the travel and the trade of all nations passing between Europe and Asia. On the 21st of August last, Lieutenant J.N. Maffitt of the United States brig Dolphin captured the slaver Echo, formerly the Putnam of New Orleans, near Cape Verde, on the coast of Cuba, with more than 300 African Negroes on board. The prize, under the command of Lieutenant Bradford of the United States Navy, arrived at Charleston on the 27th August, when the Negroes, 306 in number, were delivered into the custody of the United States Marshal for the District of South Carolina. They were first placed in Castle Pinckney and afterwards in Fort Sumter for safekeeping, and were detained there until the 19th September, when the survivors, 271 in number, were delivered on board the United States steamer Niagara to be transported to the coast of Africa under the charge of the agent of the United States, pursuant to the provisions of the Act of the 3rd March, 1819, in addition to the acts prohibiting the slave trade. Under the second section of this act, The President is authorized to make such regulations and arrangements as he may deem expedient for the safekeeping, support, and removal beyond the limits of the United States of all such Negroes, mulattoes, or persons of color captured by vessels of the United States as may be delivered to the marshal of the district into which they are brought, and to appoint a proper person or persons residing upon the coast of Africa as agent or agents for receiving the Negroes, mulattoes, or persons of color delivered from on board vessels seized in the prosecution of the slave trade by commanders of the United States armed vessels. A doubt immediately arose as to the true construction of this act. It is quite clear from its terms that the President was authorized to provide for the safekeeping, support, and removal of these Negroes up till the time of their delivery to the agent on the coast of Africa, but no express provision was made for their protection and support after they had reached the place of their destination. Still, an agent was to be appointed to receive them in Africa, and it could not have been supposed that Congress intended he should desert them at the moment they were received, and turn them loose on that inhospitable coast, to perish for want of food, or to become again the victims of the slave trade. Had this been the intention of Congress, the employment of an agent to receive them who is required to reside on the coast was unnecessary. They might have been landed by our vessels anywhere in Africa and left exposed to the sufferings and the fate which would certainly await them. Mr. Monroe, in his special message of December 17th, 1819, at the first session after the act was passed, announced to Congress what in his opinion was its true construction. He believed it to be his duty under it to follow these unfortunates into Africa and make provisions for them there until they should be able to provide for themselves. In communicating this interpretation of the act to Congress, he stated that some doubt had been entertained as to its true intent and meaning, and he submitted the question to them so that they might, should it be deemed advisable, amend the same before further proceedings are had under it. Nothing was done by Congress to explain the act, and Mr. Monroe proceeded to carry it into execution according to his own interpretation. This then became the practical construction. When the Africans from on board the Echo were delivered to the marshal at Charlestown, it became my duty to consider what disposition ought to be made of them under the law. For many reasons it was expedient to remove them from that locality as speedily as possible. Although the conduct of the authorities and citizens of Charleston in giving countenance to the execution of the law was just what might have been expected from their high character, yet a prolonged continuance of 300 Africans in the immediate vicinity of that city could not have failed to become a source of inconvenience and anxiety to its inhabitants. Where to send them was the question. There was no portion of the coast of Africa to which they could be removed with any regard to humanity except to Liberia. Under these circumstances, an agreement was entered into with the Colonization Society on the 7th of September last, a copy of which is herewith transmitted, under which the Society engaged for the consideration of $45,000 to receive these Africans in Liberia from the agent of the United States and furnish them during the period of 1 year thereafter with comfortable shelter, clothing, provisions, and medical attendance, causing the children to receive schooling, and all, whether children or adults, to be instructed in the arts of civilized life suitable to their condition. This aggregate of $45,000 was based upon an allowance of $150 for each individual, and as there has been considerable mortality among them, and it may be more before they reach Africa, the Society have agreed in an equitable spirit to make such a deduction from the amount as under the circumstances may appear just and reasonable. This cannot be fixed. until we shall ascertain the actual number which may become a charge to the society. It was also distinctly agreed that under no circumstances shall this government be called upon for any additional expenses. The agents of the society manifested a laudable desire to conform to the wishes of the government throughout the transaction. They assured me that after a careful calculation they would be required to expend the sum of $150 on each individual in complying with the agreement, and they would have nothing left to remunerate them for their care, trouble, and responsibility. At all events, I could make no better arrangement, and there was no other alternative. During the period when the government itself, through its own agents, undertook the task of providing for captured Negroes in Africa, the cost per head was very much greater. There having been no outstanding appropriation applicable to this purpose, I could not advance any money on the agreement. I therefore recommend that an appropriation be made of the amount necessary to carry it into effect. Other captures of a similar character may and probably will be made by our naval forces, and I earnestly recommend that Congress may amend the second section of the Act of March 3, 1819, so as to free its construction from the ambiguity which has so long existed, and render the duty of the President plain in executing its provisions. I recommend to your favorable regard the local interests of the District of Columbia. As the residents of Congress and the executive departments of the government, we cannot fail to feel a deep concern in its welfare. This is heightened by the high character and the peaceful and orderly conduct of its resident inhabitants. I cannot conclude without performing the agreeable duty of expressing my gratification that Congress so kindly responded to the recommendation of my last annual message by affording me sufficient time before the close of their last session for the examination of all the bills presented to me for approval. This change in the practice of Congress has proved to be a wholesome reform. It exerted a beneficial influence on the transaction of legislative business, and elicited the general approbation of the country. It enabled Congress to adjourn with that dignity and deliberation so becoming to the representatives of this great republic, without having crowded into general appropriation bills provisions foreign to their nature and of doubtful constitutionality and expediency. Let me warmly and strongly commend this precedent, established by themselves as a guide to their proceedings during the present session. James Buchanan, December 6, 1858. End of section 4.
Section 5 of State of the Union Addresses, 1857 through 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Aashna Moorjani at offtoamazingplacesblog.wordpress.com. Section 5, James Buchanan, December 18, 1859, Part 1. Fellow citizens of the Senate and House of Representatives, our deep and heartfelt gratitude is due to that almighty power which has bestowed upon us such varied and numerous blessings throughout the past year. The general health of the country has been excellent, our harvests have been unusually plentiful, and prosperity smiles throughout the land. Indeed, notwithstanding our demerits, we have much reason to believe from the past events in our history that we have enjoyed the special protection of divine providence ever since our origin as a nation. We have been exposed to many threatening and alarming difficulties in our progress, but on each successive occasion the impending cloud has been dissipated at the moment it appeared ready to burst upon our head, and the danger to our institutions has passed away. May we ever be under the divine guidance and protection. Whilst it is the duty of the President from time to time to give to Congress information of the state of the Union, I shall not refer in detail to the recent sad and bloody occurrences at Harper's Ferry. Still, it is proper to observe that these events, however bad and cruel in themselves, derive their chief importance from the apprehension that they are but symptoms of an incurable disease in the public mind, which may break out in still more dangerous outrages and terminate at last in an open war by the North to abolish slavery in the South. Whilst for myself I entertain no such apprehension, they ought to afford a solemn warning to us all to beware of the approach of danger. Our Union is a stake of such inestimable value as to demand our constant and watchful vigilance for its preservation. In this view, let me implore my countrymen, North and South, to cultivate the ancient feelings of mutual forbearance and goodwill toward each other, and strive to allay the demon spirit of sectional hatred and strife now alive in the land. This advice proceeds from the heart of an old public functionary whose service commenced in the last generation among the wise and conservative statesmen of that day, now nearly all passed away, and whose first and dearest earthly wish is to leave his country tranquil, prosperous, united, and powerful. We ought to reflect that in this age, and especially in this country, there is an incessant flux and reflux of public opinion. Questions which in their day assumed a most threatening aspect have now nearly gone from the memory of men. They are volcanoes burnt out, and on the lava and ashes and squalid scoria of old eruptions grow the peaceful olive, the cheering vine, and the sustaining corn. Such, in my opinion, will prove to be the fate of the present sectional excitement, should those who wisely seek to apply the remedy continue always to confine their efforts within the pale of the Constitution. If this course be pursued, the existing agitation on the subject of domestic slavery, like everything human, will have its day and give place to the other and less threatening controversies. Public opinion in this country is all-powerful, and when it reaches a dangerous excess upon any question, the good sense of the people will furnish the corrective and bring it back within safe limits. Still, to hasten this auspicious result at the present crisis, we ought to remember that every rational creature must be presumed to intend the natural consequences of his own teachings. Those who announce abstract doctrines subversive of the Constitution and the Union must not be surprised should their heated partisans advance one step further and attempt by violence to carry these doctrines into practical effect. In this view of the subject, it ought never to be forgotten that however great have been the political advantages resulting from the Union to every portion of our common country, these would all prove to be as nothing should the time ever arrive when they cannot be enjoyed without serious danger to the personal safety of the people of 15 members of the Confederacy. If the peace of the domestic fireside throughout these states should ever be invaded, if the mothers of families within this extensive region should not be able to retire to rest at night without suffering dreadful apprehensions of what may be their own fate and that of their children before the morning, it would be vain to recount to such a people the political benefits which result to them from the Union. Self-preservation is the first instinct of nature, and therefore any state of society in which the sword is all the time suspended over the heads of the people must at last become intolerable. But I indulge in no such gloomy forbearings. On the contrary, I firmly believe that the events at Harper's Ferry, by causing the people to pause and reflect upon the possible peril to their cherished institutions, will be the means under Providence of allaying the existing excitement and preventing further outbreaks of a similar character. They will resolve that the Constitution and the Union shall not be endangered by rash counsels, knowing that should the silver cord be loosened, or the golden bowl be broken at the fountain, human power could never reunite the scattered and hostile fragments. I cordially congratulate you upon the final settlement by the Supreme Court of the United States of the question of slavery in the territories, which has presented an aspect so truly formidable at the commencement of my administration. The right has been established of every citizen to take his property of any kind, including slaves, into the common territories belonging equally to all the states of the Confederacy, and to have it protected there under the federal Constitution. Neither Congress nor a territorial legislator, nor any human power has any authority to annul or impair this vested right. The Supreme Judicial Tribunal of the country, which is a coordinate branch of the government, has sanctioned and affirmed these principles of constitutional law, so manifestly just in themselves and so well calculated to promote peace and harmony among the states. It is a striking proof of the sense of justice which is inherent in our people that the property in slaves has never been disturbed to my knowledge in any of the territories. Even throughout the late troubles in Kansas, there has not been any attempt, as I am credibly informed, to interfere in a single instance with the right of the master. Had any such attempt been made, the judiciary would doubtless have afforded an adequate remedy. Should they fail to do this hereafter, it will then be time enough to strengthen their hands by further legislation. Had it been decided that either Congress or the territorial legislator possessed the power to annul or impair the right to property in slaves, the evil would be intolerable. In the latter event, there would be a struggle for the majority of the members of the legislature at each successive election, and the sacred rights of property held under the federal Constitution would depend for the time being on the result. The agitation would thus be rendered incessant while the territorial condition remained, and its baneful influence would keep alive a dangerous excitement among the people of the several states. Thus has the status of a territory during the immediate period from its first settlement until it shall become a state been irrevocably fixed by the final decision of the Supreme Court. Fortunate has this been for now the prosperity of the territories as well as the tranquility of the states. Now emigrants from the North and the South, the East and the West, will meet in the territories on a common platform, having brought with them that species of property best adapted, in their own opinion, to promote their welfare. From natural causes, the slavery question will in each case soon virtually settle itself, and before the territory is prepared for admission as a state into the Union, this decision one way or the other will have been a foregone conclusion. Meanwhile, the settlement of the new territory will proceed without serious interruption, and its progress and prosperity will not be endangered or retarded by violent political struggles. When in the progress of events the inhabitants of any territory shall have reached the number required to form a state, they will then proceed in a regular manner and in the exercise of the rights of popular sovereignty to form a constitution preparatory to admission into the Union. After this has been done, to employ the language of the Kansas-Nebraska Act, they shall be received into the Union with or without slavery as their constitution may prescribe at the time of their admission. The sound principle has happily been recognized in some form or other by an almost unanimous vote of both houses of the last Congress. All lawful means at my command have been employed and shall continue to be employed to execute the laws against the African slave trade. After most careful and rigorous examination of our coasts and a thorough investigation of the subject, we have not been able to discover that any slaves have been imported into the United States except the cargo by the wanderer numbering between 300 and 400. Those engaged in this unlawful enterprise have been rigorously prosecuted, but not with as much success as their crimes have deserved. A number of them are still under prosecution. Our history proves that the fathers of the Republic, in advance of all other nations, condemned the African slave trade. It was notwithstanding deemed expedient by the framers of the Constitution to deprive Congress of the power to prohibit the migration or importation of such persons as any of the states now existing shall think proper to admit prior to the year 1808. It will be seen that this restriction on the power of Congress was confined to such states only as might think proper to admit the importation of slaves. It did not extend to other states or to the trade carried on abroad. Accordingly, we find that so early as the 22nd March 1794, Congress passed an act imposing severe penalties and punishments upon citizens and residents of the United States who should engage in this trade between foreign nations. The provisions of this act were extended and enforced by the Act of 10th May, 1800. Again, the states themselves had a clear right to waive the constitutional privilege intended for their benefit and to prohibit by their own laws this trade at any time they thought proper previous to 1808. Several of them exercised this right before that period, and among them some containing the greatest number of slaves. This gave to Congress the immediate power to act in regard to all such states because they themselves had removed the constitutional barrier. Congress accordingly passed an act on 28 February 1803 to prevent the importation of certain persons into certain states, whereby the laws thereof their admission is prohibited. In this manner, the importation of African slaves into the United States was to a great extent prohibited, some years in advance of 1808. As the year 1808 approached, Congress determined not to suffer this trade to exist even for a single day after they had the power to abolish it. On the 2nd of March 1807, they passed an act to take effect from and after the first day of January 1808, prohibiting the importation of African slaves into the United States. This was followed by subsequent acts of a similar character to which I need not specifically refer. Such were the principles and such the practice of our ancestors more than 50 years ago in regard to the African slave trade. It did not occur to the revered patriots who had been delegates to the convention and afterwards became members of Congress that in passing these laws they had violated the Constitution which they had framed with so much care and deliberation. They supposed that to prohibit Congress in express terms from exercising a specified power before an appointed day necessarily involved the right to exercise this power after that day had arrived. If this were not the case, the framers of the Constitution had expended much labor in vain. Had they imagined that Congress would possess no power to prohibit the trade either before or after 1808, they would not have taken so much care to protect the states against the exercise of this power before that period. Nay, more, they would not have attached such vast importance to this provision as to have excluded it from the possibility of future repeal or amendment to which other portions of the Constitution were exposed. It would then have been wholly unnecessary to engraft on the 5th article of the Constitution, prescribing the mode of its own future amendment, the proviso that no amendment which may be made prior to the year 1808 shall in any manner affect the provision in the Constitution securing to the states the right to admit the importation of African slaves previous to that period. According to the adverse construction, the clause itself, on which so much care and discussion had been employed by the members of the convention, was an absolute nullity from the beginning, and all that has been since done under it a mere usurpation. It was well and wise to confer this power on Congress, because had it been left to the states, its efficient exercise would have been impossible. In that event, any one state could have effectually continued the trade, not only for itself, but for all the other slave states, though never so much against their will. And why? Because African slaves, when once brought within the limits of any one state in accordance with its laws, cannot practically be excluded from any state where slavery exists, and even if all the states had separately passed laws prohibiting the importation of slaves, these laws would have failed of effect for want of a naval force to capture the slavers and to guard the coast. Such a force no state can employ in time of peace without the consent of Congress. These acts of Congress, it is believed, have with very rare and insignificant expectations accomplished their purpose. For a period of more than half a century, there has been no perceptible addition to the number of our domestic slaves. During this period, their advancement in civilization has far surpassed that of any other portion of the African race. The light and blessings of Christianity have been extended to them, and both their moral and physical condition has been greatly improved. Reopen the trade, and it would be difficult to determine whether the effects would be more deleterious on the interests of the master or on those of the native-born slave. Of the evils to the master, the one most to be dreaded would be the introduction of wild, heathen, and ignorant barbarians among the sober, orderly, and quiet slaves whose ancestors have been on the soil for several generations. This might tend to barbarize, demoralize, and exacerbate the whole mass and produce most deplorable consequences. The effect upon the existing slave would, if possible, be still more deplorable. At present he is treated with kindness and humanity. He is well fed, well clothed, and not overworked. His condition is incomparably better than that of the coolies which modern nations of high civilization have employed as a substitute for African slaves. Both the philanthropy and the self-interest of the master have combined to produce this humane result. But let this trade be opened, and what will be the effect? the same to a considerable extent as on a neighboring island, the only spot now on earth where the African slave trade is openly tolerated, and this in defiance of solemn treaties with a power abundantly able at any moment to enforce their execution. There the master, intent upon present gain, extorts from the slave as much labor as his physical powers are capable of enduring, knowing that when death comes to his relief, his place can be supplied at a price reduced to the lowest point by the competition of rival African slave traders. Should this ever be the case in our country, which I do not deem possible, the present useful character of the domestic institution, wherein those too old and too young to work are provided for with care and humanity, and those capable of labor are not overtasked, would undergo an unfortunate change. The feeling of reciprocal dependence and attachment which now exists between master and slave would be converted into a mutual distrust and hostility. But we are obliged as a Christian and moral nation to consider what would be the effect upon unhappy Africa itself if we should reopen the slave trade. This would give the trade an impulse and extension which it never had even in its palmiest days. The numerous victims required to supply it would convert the whole slave coast into a perfect pandemonium for which this country would be held responsible in the eyes of both God and man. Its petty tribes would then be constantly engaged in predatory wars against each other for the purpose of seizing slaves to supply the American market. All hopes of African civilization would thus be ended. On the other hand, when a market for African slaves shall no longer be furnished in Cuba, and thus all the world be closed against the trade, we may then indulge a reasonable hope for the gradual improvement of Africa. The chief motive of war among the tribes will cease whenever there is no longer any demand for slaves. The resources of that fertile but miserable country may then be developed by the hand of industry, and afford subjects for legitimate foreign and domestic commerce. In this manner, Christianity and civilization may gradually penetrate the existing gloom. The wisdom of the course pursued by this government toward China has been vindicated by the event. Whilst we sustain a neutral position in the war waged by Great Britain and France against the Chinese Empire, our late minister, in obedience to his instructions, judiciously cooperated with the ministers of these powers in all peaceful measures to secure by treaty the just concessions demanded by the interests of foreign commerce. The result is that satisfactory treaties have been concluded with China by the respective ministers of the United States, Great Britain, France, and Russia. Our treaty or general convention of peace, amity, and commerce with that empire was concluded at Tientsin on the 18th June, 1858, and was ratified by the President by and with the advice and consent of the Senate on the 21st December following. On the 15th December 1858, John E. Ward, a distinguished citizen of Georgia, was duly commissioned as envoy extraordinary and minister plenipotentiary to China. He left the United States for the place of his destination on the 5th of February 1859, bearing with him the ratified copy of this treaty, and arrived at Shanghai on the 28th May. From thence he proceeded to Peking on the 16th June, but did not arrive in that city until the 27th July. According to the terms of the treaty, the ratifications were to be exchanged on or before the 18th June, 1859. This rendered impossible by reasons and events beyond his control, not necessary to detail, but still it is due to the Chinese authorities at Shanghai to state that they always assured him no advantage should be taken of the delay, and this pledge has been faithfully redeemed. On the arrival of Mr. Ward at Peking, he requested an audience of the Emperor to present his letter of credence. This he did not obtain in consequence of his very proper refusal to submit to the humiliating ceremonies required by the etiquette of this strange people in approaching their sovereign. Nevertheless, the interviews on this question were conducted in the most friendly spirit, and with all due regard to his personal feelings and the honor of his country. When a presentation to His Majesty was found to be impossible, the letter of credence from the President was received with peculiar honors by Kuei Liang, the Emperor's Prime Minister and the second man in the Empire to the Emperor himself. The ratifications of the treaty were afterwards, on the 16th of August, exchanged in proper form at Pietzing. As the exchange did not take place until after the day prescribed by the treaty, it is deemed proper before its publication again to submit it to the Senate. It is but simple justice to the Chinese authorities to observe that throughout the whole transaction they appear to have acted in good faith and in a friendly spirit towards the United States. It is true this has been done after their own peculiar fashion, but we ought to regard with a lenient eye the ancient customs of an empire dating back for thousands of years, so far as this may be consistent with our own national honor. The conduct of our minister on the occasion has received my entire approbation. In order to carry out the spirit of this treaty and to give it full effect, it became necessary to conclude two supplemental conventions, the one for the adjustment and satisfaction of the claims of our citizen, and the other to fix a tariff on imports and exports, and to regulate the transit of duties and trade of our merchants with China. This duty was satisfactorily performed by our late minister. These conventions bear date at Shanghai on the 8th November 1858. Having considered in the light of binding agreement subsidiary to the principal treaty and to be carried into execution without delay, they did not provide for formal ratification or exchange of ratifications by the contracting parties. This was not deemed necessary by the Chinese, who are already proceeding in good faith to satisfy the claims of our citizens, and it is hoped to carry out the other provisions of the conventions. Still, I thought it was proper to submit them to the Senate, by which they were ratified on the 3rd of March, 1859. The ratified copies, however, did not reach Shanghai until the departure of our minister to Peking, and these conventions could not therefore be exchanged at the same time with the principal treaty. No doubt is entertained that they will be ratified and exchanged by the Chinese government should this be thought advisable, but under the circumstances presented, I shall consider them binding engagements from their date on both parties, and cause them to be published as such for the information and guidance of our merchants trading with the Chinese Empire. It affords me much satisfaction to inform you that all our difficulties with the Republic of Paraguay have been satisfactorily adjusted. It happily did not become necessary to employ the force for this purpose, which Congress had placed at my command under the joint resolution of 2nd June, 1858. On the contrary, the President of that Republic, in friendly spirit, acceded promptly to the just and reasonable demands of the government of the United States. Our commissioner arrived at Assumption, the capital of the Republic, on the 25th of January, 1859, and left it on the 17th of February, having in 3 weeks ably and successfully accomplished all the objects of his mission. The treaties which he concluded will be immediately submitted to the Senate. In the view that the employment of other than peaceful means become necessary to obtain just satisfaction from Paraguay, a strong naval force was concentrated in the waters of the La Plata to await contingencies, whilst our commissioner ascended the rivers to Assumption. The Navy Department is entitled to great credit for the promptness, efficiency, and economy with which this expedition was fitted out and conducted. It consisted of 19 armed vessels, great and small, carrying 200 guns and 2,500 men, all under the command of the veteran and gallant Shubrick. The entire expenses of the expedition have been defrayed out of the ordinary appropriations for the naval service, except the sum of $289,000 applied to the purchase of 7 of the steamers constituting a part of it, under the authority of the Naval Appropriation Act of the 3rd March last. It is believed that these steamers are worth more than their cost, and they are all now usefully and actively employed in the naval service. The appearance of so large a force, fitted out in such a prompt manner in the far distant waters of the La Plata, and the admirable conduct of the officers and men employed in it, have had a happy effect in favor of our country throughout all that remote portion of the world. Our relations with the great empires of France and Russia, as well as with other governments on the continent of Europe, unless we may except that of Spain, happily continue to be of the most friendly character. In my last annual message, I presented a statement of the unsatisfactory condition of our relations with Spain, and I regret to say that this has not materially improved. Without special reference to other claims, even the Cuban claims, payment of which has been ably urged by our ministers, and in which more than 100 of our citizens are directly interested, remain unsatisfied notwithstanding both their justice and their amount. $128,635.54 has been recognized and ascertained by the Spanish government itself. I again recommend that an appropriation be made to be paid to the Spanish government for the purpose of distribution among the claimants in the Amistad case. In common with two of my predecessors, I entertain no doubt that this is required by our treaty with Spain of the 27th October 1795. The failure to discharge this obligation has been employed by the Cabinet of Madrid as a reason against the settlement of our claims. I need not repeat the arguments which I urged in my last annual message in favor of the acquisition of Cuba by fair purchase. My opinions on that measure remain unchanged. I therefore again invite the serious attention of Congress to this important subject. Without a recognition of this policy on their part, it will be almost impossible to institute negotiations with any reasonable prospect of success. Until a recent period, there was good reason to believe that I should be able to announce to you on the present occasion that our difficulties with Great Britain, arising out of the Clayton and Bulwer Treaty, have been finally adjusted in a manner alike honorable and satisfactory to both parties. From causes, however, which the British government had not anticipated, they have not yet completed treaty arrangements with the republics of Honduras and Nicaragua in pursuance of the understanding between the two governments. It is nevertheless confidently expected that this good work will ere long be accomplished. Whilst indulging the hope that no other subject remained which could disturb the good understanding of the two countries, the question arising out of the adverse claims of the parties to the island of San Juan under the Oregon Treaty of the 15th June, 1846, suddenly assumed a threatening prominence. In order to prevent unfortunate collisions on that remote frontier, the late Secretary of State on the 17th July, 1855, addressed a note to Mr. Crampton, then British Minister at Washington, communicating to him a copy of the instructions which he, Mr. Marcy, had given on the 14th July to Governor Stevens of Washington Territory, having a special reference to an apprehended conflict between our citizens and the British subjects on the island of San Juan. To prevent this, the governor was instructed that the officers of the territory should abstain from all acts on the disputed grounds which are calculated to provoke any conflicts, so far as it can be done without implying the concession to the authorities of Great Britain of an exclusive right over the premises. The title ought to be settled before either party should attempt to exclude the other by force or exercise complete and exclusive sovereign rights within fairly disputed limits. In acknowledging the receipt on the next day of Mr. Marcy's note, the British minister expressed his entire concurrence in the propriety of your course recommended to the Governor of Washington Territory by your Mr. Marcy's instructions to that officer, and stating that he had lost no time in transmitting a copy of that document to the Governor General of British North America, and has earnestly recommended to His Excellency to take such measures as to him may appear best calculated to secure on the part of the British local authorities and the inhabitants of the neighborhood of the line in question the exercise of the same spirit of forbearance which is inculcated by you, Mr. Marcy, on the authorities and citizens of the United States. Thus matters remained upon the faith of this arrangement until the 9th July last, when General Harney paid a visit to the island. He found upon its 25 American residents and their families, and also an establishment of the Hudson's Bay Company for the purpose of raising sheep. A short time before his arrival, one of these residents had shot an animal belonging to the company whilst trespassing upon his premises, for which, however, he offered to pay twice its value, but that was refused. Soon after, the chief factor of the company at Victoria, Mr. Dale's son-in-law of Governor Douglas, came to the island in the British sloop of War Satellite and threatened to take this American, Mr. Cutler, by force to Victoria to answer for the trespass he had committed. The American seized his rifle and told Mr. Dales if any such attempt was made, he would kill him upon the spot. The affair then ended. Under these circumstances, the American settlers presented a petition to the General through the United States Inspector of Customs, Mr. Hubbs, to place a force upon the island to protect them from the Indians, as well as the oppressive interference of the authorities of the Hudson's Bay Company at Victoria with their rights as American citizens. The General immediately responded to the petition and ordered Captain George E. Pickett, 9th Infantry, to establish his company on Bellevue or San Juan Island on some suitable portion near the border at the southeastern extremity. The order was promptly obeyed, and a military post was established at the place designated. The force was afterwards increased so that, by the last return, the whole number of troops then on the island amounted in the aggregate to 691 men. Whilst I do not deem it proper on the present occasion to go further into the subject and discuss the weight which ought to be attached to the statements of the British colonial authorities contesting the accuracy of the information on which the gallant general acted, it was due to him that I should thus present his own reasons for issuing the order to Captain Pickett. From these, it is quite clear his object was to prevent the British authorities on Vancouver's Island from exercising jurisdiction over American residents on the island of San Juan, as well as to protect them against the incursions of the Indians. Much excitement prevailed for some time throughout that region, and serious danger of collisions between the parties was apprehended. The British had a large naval force in the vicinity, and it is but an act of simple justice to the admiral on that station to state that he wisely and discreetly forbore to commit any hostile act, but determined to refer the whole affair to his government and await their instructions. The aspect of the matter, in my opinion, demanded serious attention. It would have been a great calamity for both nations had they been precipitated into acts of hostility, not on the question of title to the island, but merely concerning what should be its condition during the intervening period, whilst the two governments might be employed in settling the question to which of them it belongs. For this reason, Lieutenant General Scott was dispatched on the 17th of September last to Washington Territory to take immediate command of the United States forces on the Pacific coast, should they deem this necessary. The main object of his mission was to carry out the spirit of the precautionary arrangement by the late Secretary of State and the British minister, and thus preserve the peace and prevent collision between the British and American authorities pending the negotiations between the two governments. Entertaining no doubt of the validity of our title, I need scarcely to add that in any event American citizens were to be placed on a footing at least as favorable as that of British subjects, it being understood that Captain Pickett's company should remain on the island. It is proper to observe that, considering the distance from the scene of action, and in ignorance of what might have transpired on the spot before the general's arrival, it was necessary to leave much to his discretion. I am happy to state the event has proven that this discretion could not have been entrusted to more competent hands. General Scott has recently returned from his mission, having successfully accomplished its objects, and there is no longer any good reason to apprehend a collision between the forces of the two countries during the pendency of the existing negotiations. I regret to inform you that there has been no improvement in the affairs of Mexico since my last annual message, and I am again obliged to ask the earnest attention of Congress to the unhappy condition of that republic. End of section 5.
Section 6 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. State of the Union Addresses, James Buchanan, December 19, 1859, Part 2. The Constituent Congress of Mexico, which adjourned on the 17th of February, 1857, adopted a constitution and provided for a popular election. This took place in the following July, 1857, and General Comonfort was chosen president almost without opposition. At the same election, a new Congress was chosen, whose first session commenced on the 16th of September, 1857. By the Constitution of 1857, the presidential term was to begin on the 1st of December, 1857, and continue for 4 years. On that day, General Comonfort appeared before the assembled Congress in the City of Mexico, took the oath to support the new Constitution, and was duly inaugurated as president. Within a month afterwards, he had been driven from the capital, and a military rebellion had assigned the supreme power of the Republic to General Zuloaga. The Constitution provided that in the absence of the President, his office should devolve upon the Chief Justice of the Supreme Court, and General Comonfort, having left the country, This functionary, General Juarez, proceeded to form at Guanajuato a constitutional government. Before this was officially known, however, at the capital the government of Zuloaga had been recognized by the entire diplomatic corps, including the Minister of the United States, as the de facto government of Mexico. The constitutional president, nevertheless, maintained his position with firmness, and was soon established, with his cabinet, at Vera Cruz. Meanwhile, the government of Zuloaga was earnestly resisted in many parts of the republic, and even in the capital, a portion of the army having pronounced against it, its functions were declared terminated, and an assembly of citizens was invited for the choice of a new president. This assembly elected General Miramort, but that officer repudiated the plan under which he was chosen, and Zuloaga was thus restored to his previous position. He assumed it, however, only to withdraw from it, and Miramon, having become by his appointment president substitute, continues with that title at the head of the insurgent party. In my last annual message, I communicated to Congress the circumstances under which the late minister of the United States suspended his official relations with the central government and withdrew from the country. It was impossible to maintain friendly intercourse with a government like that at the capital, under whose usurped authority wrongs were constantly committed but never redressed. Had this been an established government, with its power extending by the consent of the people over the whole of Mexico, a resort to hostilities against it would have been quite justifiable and indeed necessary. But the country was a prey to civil war, and it was hoped that the success of the constitutional president might lead to a condition of things less injurious to the United States. This success became so probable that in January last I employed a reliable agent to visit Mexico and report to me the actual condition and prospects of the contending parties. In consequence of his report, and from information which reached me from other sources favorable to the prospects of the constitutional cause, I felt justified in appointing a new minister to Mexico, who might embrace the earliest suitable opportunity of restoring our diplomatic relations with that republic. For this purpose a distinguished citizen of Maryland was selected, who proceeded on his mission on the 8th of March last, with discretionary authority to recognize the government of President Juarez if on his arrival in Mexico he should find it entitled to such recognition according to the established practice of the United States. On the 7th of April following, Mr. McLean presented his credentials to President Juarez, having no hesitation in pronouncing the government of Juarez to be the only existing government of the Republic. He was cordially received by the authorities at Vera Cruz, and they have ever since manifested the most friendly disposition toward the United States. Unhappily, however, the constitutional government has not been able to establish its power over the whole republic. It is supported by a large majority of the people and the states, but there are important parts of the country where it can enforce no obedience. General Miramon maintains himself at the capital, and in some of the distant provinces there are military governors who pay little respect to the decrees of either government. In the meantime, the excesses which always attend upon civil war, especially in Mexico, are constantly recurring. Outrages of the worst description are committed both upon persons and property. There is scarcely any form of injury which has not been suffered by our citizens in Mexico during the last few years. We have been nominally at peace with that republic, but so far as the interests of our commerce or of our citizens who have visited the country as merchants, shipmasters, or in other capacities are concerned, we might as well have been at war. Life has been insecure, property unprotected, and trade impossible, except at a risk of loss which prudent men cannot be expected to incur. Important contracts involving large expenditures entered into by the central government have been set at defiance by the local governments. Peaceful American residents occupying their rightful possessions have been suddenly expelled the country in defiance of treaties and by the mere force of arbitrary power. Even the course of justice has not been safe from control, and a recent decree of Miramort permits the intervention of government in all suits where either party is a foreigner. Vessels of the United States have been seized without law, and a consular officer who protested against such seizure has been fined and imprisoned for disrespect to the authorities. Military contributions have been levied in violation of every principle of right, and the American who resisted the lawless demand has had his property forcibly taken away and has been himself banished. From a conflict of authority in different parts of the country, tariff duties which have been paid in one place have been exacted over again in another place. Large numbers of our citizens have been arrested and imprisoned without any form of examination or any opportunity for a hearing, and even when released have only obtained their liberty after much suffering and injury, and without any hopes of redress. The wholesale massacre of Crabbe and his associates without trial in Sonora, as well as the seizure and murder of 4 sick Americans who had taken shelter in the house of an American upon the soil of the United States, was communicated to Congress at its last session. Murders of a still more atrocious character have been committed in the very heart of Mexico, under the authority of Miramon's government, during the present year. Some of these were only worthy of a barbarous age, and if they had not been dearly proven, would have seemed impossible in a country which claims to be civilized. Of this description was the brutal massacre in April last, by order of General Marquez, of 3 American physicians who were seized in the hospital at Tacubaya while attending upon the sick and the dying of both parties, and without trial, as without crime, were hurried away to speedy execution. Little less shocking was the recent fate of Ormond Chase, who was shot in Tepic on the 7th of August, by order of the same Mexican general, not only without a trial, but without any conjecture by his friends of the cause of his arrest. He is represented as a young man of good character and intelligence, who had made numerous friends in Tepic by the courage and humanity which he had displayed on several trying occasions, and his death was as unexpected as it was shocking to the whole community. Other outrages might be enumerated, but these are sufficient to illustrate the wretched state of the country and the unprotected condition of the persons and property of our citizens in Mexico. In all these cases, our ministers have been constant and faithful in their demands for redress, but both they and this government, which they have successfully represented, have been wholly powerless to make their demands effective. Their testimony in this respect, and in reference to the only remedy which in their judgments would meet the exigency, has been both uniform and emphatic. Nothing but a manifestation of the power of the government of the United States, wrote our late minister in 1856, and of its purpose to punish these wrongs, will avail. I assure you that the universal belief here is that there is nothing to be apprehended from the government of the United States, and that local Mexican officials can commit these outrages upon American citizens with absolute impunity. I hope the President, wrote our present minister in August last, will feel authorized to ask from Congress the power to enter Mexico with the military forces of the United States at the call of the constitutional authorities in order to protect the citizens and the treaty rights of the United States. Unless such a power is conferred upon him, neither the one nor the other will be respected in the existing state of anarchy and disorder, and the outrages already perpetrated will never be chastised. And I assure you, in my number 23, all these evils must increase until every vestige of order and government disappears from the country. I have been reluctantly led to the same opinion, and in justice to my countrymen who have suffered wrongs from Mexico and who may still suffer them, I feel bound to announce this conclusion to Congress. The case presented, however, is not merely a case of individual claims, although our just claims against Mexico have reached a very large amount. Nor is it merely the case of protection to the lives and property of the few Americans who may still remain in Mexico, although the life and property of every American citizen ought to be sacredly protected in every quarter of the world. But it is a question which relates to the future as well as to the present and the past, and which involves, indirectly at least, the whole subject of our duty to Mexico as a neighboring state. The exercise of the power of the United States in that country to redress the wrongs and protect the rights of our citizens is none the less to be desired, because efficient and necessary aid may thus be rendered at the same time to restore peace and order to Mexico itself. In the accomplishment of this result, the people of the United States must necessarily feel a deep and earnest interest. Mexico ought to be a rich and prosperous and powerful republic. She possesses an extensive territory, a fertile soil, and an incalculable store of mineral wealth. She occupies an important position between the Gulf and the ocean, for transit routes and for commerce. Is it possible that such a country as this can be given up to anarchy and ruin without an effort from any quarter for its rescue and its safety? Will the commercial nations of the world, which have so many interests connected with it, remain wholly indifferent to such result? Can the United States, especially, which ought to share most largely in its commercial intercourse, allow their immediate neighbor thus to destroy itself and injure them? Yet without support from some quarter, it is impossible to perceive how Mexico can resume her position among nations and enter upon a career which promises any good results. The aid which she requires, and which the interests of all commercial countries require that she should have, it belongs to this government to render, not only by virtue of our neighborhood to Mexico, along whose territory we have a continuous frontier of nearly 1,000 miles, but by virtue also of our established policy, which is inconsistent with the intervention of any European power in the domestic concerns of that republic. The wrongs which we have suffered from Mexico are before the world, and must deeply impress every American citizen. A government which is either unable or unwilling to redress such wrongs is derelict to its highest duties. The difficulty consists in selecting and enforcing the remedy. We may in vain apply to the constitutional government at Vera Cruz, although it is well disposed to do us justice for adequate redress. Whilst its authority is acknowledged in all the important ports and throughout the seacoasts of the Republic, its power does not extend to the City of Mexico and the states in its vicinity, where nearly all the recent outrages have been committed on American citizens. We must penetrate into the interior before we can reach the offenders, and this can only be done by passing through the territory in the occupation of the constitutional government. The most acceptable and least difficult mode of accomplishing the object will be to act in concert with that government. their consent and their aid might, I believe, be obtained. But if not, our obligation to protect our own citizens in their just rights secured by treaty would not be the less imperative. For these reasons, I recommend to Congress to pass a law authorizing the President, under such conditions as they may deem expedient, to employ a sufficient military force to enter Mexico for the purpose of obtaining indemnity for the past and security for the future. I purposely refrain from any suggestion as to whether this force shall consist of regular troops or volunteers or both. This question may be most appropriately left to the decision of Congress. I would merely observe that should volunteers be selected, such a force could be easily raised in this country among those who sympathize with the sufferings of our unfortunate fellow citizens in Mexico and with the unhappy condition of that republic. Such an accession to the forces of the constitutional government would enable it soon to reach the city of Mexico and extend its power over the whole republic. In that event, there is no reason to doubt that the just claims of our citizens would be satisfied and adequate redress obtained for the injuries inflicted upon them. The constitutional government have ever evinced a strong desire to do justice, and this might be secured in advance by a preliminary treaty. It may be said that these measures will, at least indirectly, be inconsistent with our wise and settled policy not to interfere in the domestic concerns of foreign nations. But does not the present case fairly constitute an exception? An adjoining republic is in a state of anarchy and confusion, from which she has proved wholly unable to extricate herself. She is entirely destitute of the power to maintain peace upon her borders or to prevent the incursions of banditti into our territory. In her fate and in her fortune, in her power to establish and maintain a settled government, we have a far deeper interest, socially, commercially, and politically, than any other nation. She is now a wreck upon the ocean, drifting about as she is impelled by different factions. As a good neighbor, shall we not extend to her a helping hand to save her? If we do not, it would not be surprising should some other nation undertake the task, and thus force us to interfere at last under circumstances of increased difficulty for the maintenance of our established policy. I repeat the recommendation contained in my last annual message that authority may be given to the President to establish one or more temporary military posts across the Mexican line in Sonora and Chihuahua where these may be necessary to protect the lives and property of American and Mexican citizens against the incursions and depredations of the Indians, as well as of lawless rovers on that remote region. The establishment of one such post at a point called Arizpe in Sonora, in a country now almost depopulated by the hostile inroads of the Indians from our side of the line, would, it is believed, have prevented much injury and many cruelties during the past season. A state of lawlessness and violence prevails on that distant frontier. Life and property are there wholly insecure. The population of Arizona, now numbering more than 10,000 souls, are practically destitute of government, of laws, or of any regular administration of justice. Murder, rapine, and other crimes are committed with impunity. I therefore again call the attention of Congress to the necessity for establishing a territorial government in Arizona. The treaty with Nicaragua on the 16th of February, 1857, to which I referred in my last annual message, failed to receive the ratification of the government of that republic, for reasons which I need not enumerate. A similar treaty has been since concluded between the parties, bearing date on the 16th of March, 1859, which has already been ratified by the Nicaraguan Congress. This will be immediately submitted to the Senate for their ratification. Its provisions cannot, I think, fail to be acceptable to the people of both countries. Our claims against the governments of Costa Rica and Nicaragua remain unredressed, though they are pressed in an earnest manner and not without hope of success. I deem it to be my duty once more earnestly to recommend to Congress the passage of a law authorizing the President to employ the naval force at his command for the purpose of protecting the lives and property of American citizens passing in transit across the Panama, Nicaragua, and Tehuantepec routes against sudden and lawless outbreaks and depredations. I shall not repeat the arguments employed in former messages in support of this measure. Suffice it to say that the lives of many of our people and the security of vast amounts of treasure passing and repassing over one or more of these routes between the Atlantic and Pacific may be deeply involved in the action of Congress on this subject. I would also again recommend to Congress that authority be given to the President to employ the naval force to protect American merchant vessels, their crews and cargoes, against violent and lawless seizure and confiscation in the ports of Mexico and the Spanish-American states, when these countries may be in a disturbed and revolutionary condition. The mere knowledge that such an authority had been conferred, as I have already stated, would of itself in a great degree prevent the evil. Neither would this require any additional appropriation for the naval service. The chief objection urged against the grant of this authority is that Congress, by conferring it, would violate the Constitution, that it would be a transfer of the war-making, or, strictly speaking, the war-declaring power to the executive. If this were well rounded, it would of course be conclusive. A very brief examination, however, will place this objection at rest. Congress possesses the sole and exclusive power under the Constitution to declare war. They alone can raise and support armies and provide and maintain a navy. But after Congress shall have declared war, and provided the force necessary to carry it on, the President, as Commander-in-Chief of the Army and Navy, can alone employ this force in making war against the enemy. This is the plain language, and history proves that it was the well-known intention of the framers of the Constitution. It will not be denied that the general power to declare war is without limitation, and it embraces within itself not only what writers on the law of nations term a public or perfect war, but also an imperfect war, and, in short, every species of hostility, however confined or limited. Without the authority of Congress, the President cannot fire a hostile gun in any case, except to repel the attacks of an enemy. It will not be doubted that under this power Congress could, if they thought proper, authorize the President to employ the force at his command to seize a vessel belonging to an American citizen which had been illegally and unjustly captured in a foreign port and restore it to its owner. But can Congress only act after the fact, after the mischief has been done? Have they no power to confer upon the President the authority in advance to furnish instant redress should such a case afterwards occur? Must they wait until the mischief has been done? And can they apply the remedy only when it is too late? To confer this authority to meet future cases under circumstances strictly specified It is clearly within the war-declaring power as such an authority conferred upon the President by act of Congress after the deed had been done. In the progress of a great nation, many exigencies must arise, imperatively requiring that Congress should authorize the President to act promptly on certain conditions which may or may not afterwards arise. Our history has already presented a number of such cases. I shall refer only to the latest. Under the resolution of June 2nd, 1858, for the adjustment of difficulties with the Republic of Paraguay, the President is authorized to adopt such measures and use such force as in his judgment may be necessary and advisable in the event of a refusal of just satisfaction by the government of Paraguay. Just satisfaction. For what? For the attack on the United States steamer Water Witch, and other matters referred to in the annual message of the President. Here the power is expressly granted upon the condition that the government of Paraguay shall refuse to render this just satisfaction. In this and other similar cases, Congress has conferred upon the President power in advance to employ the Army and Navy upon the happening of contingent future events, and this most certainly is embraced within the power to declare war. Now, if this conditional and contingent power could be constitutionally conferred upon the President in the case of Paraguay, why may it not be conferred for the purpose of protecting the lives and property of American citizens in the event that they may be violently and unlawfully attacked in passing over the transit routes to and from California, or assailed by the seizure of their vessels in a foreign port? To deny this power is to render the Navy in a great degree useless for the protection of the lives and property of American citizens in countries where neither protection nor redress can be otherwise obtained. The 35th Congress terminated on the 3rd of March, 1859, without having passed the act making appropriations for the service of the Post Office Department during the fiscal year ending the 30th of June, 1860. This act also contained an appropriation to supply deficiencies in the revenue of the Post Office Department for the year ending 30th of June, 1859. I believe this is the first instance since the origin of the federal government, now more than 70 years ago, when any Congress went out of existence without having passed all the general appropriation bills necessary to carry on the government until the regular period for the meeting of a new Congress. This event imposed on the executive a grave responsibility. It presented a choice of evils. Had this omission of duty occurred at the first session of the last Congress, the remedy would have been plain. I might then have instantly recalled them to complete their work, and thus without expense to the government. But on the 4th of March last, there were 15 of the 33 states which had not elected any representatives to the present Congress. Had Congress been called together immediately, these states would have been virtually disenfranchised. If an intermediate period had been selected, several of the states would have been compelled to hold extra sessions of their legislatures at great inconvenience and expense, to provide for elections at an earlier day than that previously fixed by law. In the regular course, 10 of these states would not elect until after the beginning of August, and 5 of these 10 not until October and November. On the other hand, when I came to examine carefully the condition of the Post Office Department, I did not meet as many or as great difficulties as I had apprehended. Had the bill which failed been confined to appropriations for the fiscal year ending on the 30th of June next, there would have been no reason of pressing importance for the call of an extra session. Nothing would become due on contracts, those with railroad companies only excepted, for carrying the mail for the first quarter of the present fiscal year, commencing on the 1st of July until the 1st of December, less than 1 week before the meeting of the present Congress. The reason is that the mail contractors for this and the current year did not complete their first quarter's service until the 30th of September last, and by the terms of their contracts, 60 days more are allowed for the settlement of their accounts before the department could be called upon for payment. The great difficulty and the great hardship consisted in the failure to provide for the payment of the deficiency in the fiscal year ending the 30th of June, 1859. The department had entered into contracts, in obedience to existing laws, for the service of that fiscal year, and the contractors were fairly entitled to their compensation as it became due. The deficiency, as stated in the bill, amounted to $3,838,728. But after a careful settlement of all these accounts, it had been ascertained that it amounts to $4,296,009. With the scanty means at his command, the Postmaster General has managed to pay that portion of this deficiency which occurred in the first 2 quarters of the past fiscal year, ending on the 31st of December last. In the meantime, the contractors themselves, under these trying circumstances, have behaved in a manner worthy of all commendation. They had one resource in the midst of their embarrassments. After the amount due to each of them had been ascertained and finally settled according to law, this became a specific debt of record against the United States, which enabled them to borrow money on this unquestionable security. Still, they were obliged to pay interest in consequence of the default of Congress, and on every principle of justice ought to receive interest from the government. This interest should commence from the date when a warrant would have issued for the payment of the principal had an appropriation been made for this purpose. Calculated to the 1st December, it will not exceed $96,660, a sum not to be taken into account when contrasted with the great difficulties and embarrassments of a public and private character, both to the people and states, which would have resulted from convening and holding a special session of Congress. For these reasons, I recommend the passage of a bill at as early a day as may be practicable to provide for the payment of the amount with interest due to these last-mentioned contractors, as well as to make the necessary appropriations for the service of the Post Office Department for the current fiscal year. The failure to pass the Post Office bill necessarily gives birth to serious reflections. Congress, by refusing to pass the general appropriation bills necessary to carry on the government, may not only arrest its action, but might even destroy its existence. The Army, the Navy, the Judiciary, in short, every department of the government can no longer perform their functions if Congress refuse the money necessary for their support. If this failure should teach the country the necessity of electing a full Congress in sufficient time to enable the President to convene them in any emergency, even immediately after the old Congress has expired, it will have been productive of great good. In a time of sudden and alarming danger, foreign or domestic, which all nations must expect to encounter in their progress, the very salvation of our institutions may be staked upon the assembling of Congress without delay. If under such circumstances the President should find himself in the condition in which he was placed at the close of the last Congress, with nearly half the States of the Union destitute of representatives, the consequence might be disastrous. I therefore recommend to Congress to carry into effect the provisions of the Constitution on this subject, and to pass a law appointing some day previous to the 4th March in each year of odd number for the election of representatives throughout all the states. They have already appointed a day for the election of electors for President and Vice President, and this measure has been approved by the country. I would again express a most decided opinion in favor of the construction of a Pacific Railroad, for the reasons stated in my last 2 annual messages. When I reflect upon what would be the defenseless condition of our states and territories west of the Rocky Mountains in case of a war with a naval power sufficiently strong to interrupt all intercourse with them by the routes across the isthmus, I am still more convinced than ever of the vast importance of this railroad. I have never doubted the constitutional competency of Congress to provide for its construction, but this exclusively under the war-making power. Besides, the Constitution expressly requires as an imperative duty that the United States shall protect each of them, the states, against invasion. I am at a loss to conceive how this protection can be afforded to California and Oregon against such a naval power by any other means. I repeat the opinion contained in my last annual message that it would be inexpedient for the government to undertake this great work by agents of its own appointment and under its direct and exclusive control. This would increase the patronage of the executive to a dangerous extent, and would foster a system of jobbing and corruption which no vigilance on the part of federal officials could prevent. The construction of this road ought therefore to be entrusted to incorporated companies or other agencies who would exercise that active and vigilant supervision over it which can be inspired alone by a sense of corporate and individual interest. I venture to assert that the additional cost of transporting troops, munitions of war, and necessary supplies for the Army across the vast intervening plains to our possessions on the Pacific coast would be greater in such a war than the whole amount required to construct the road. And yet this resort would after all be inadequate for their defense and protection. We have yet scarcely recovered from the habits of extravagant expenditure produced by our overflowing treasury during several years prior to the commencement of my administration. The financial reverses which we have since experienced ought to teach us all to scrutinize our expenditures with the greatest vigilance, and to reduce them to the lowest possible point. The executive departments of the government have devoted themselves to the accomplishment of this object with considerable success, as will appear from their different reports and estimates. To these I invite the scrutiny of Congress for the purpose of reducing them still lower, if this be practicable consistent with the great public interests of this country. In aid of the policy of retrenchment, I pledge myself to examine closely the bills appropriating lands or money, so that if any of these should inadvertently pass both houses, as must sometimes be the case, I may afford them an opportunity for reconsideration. At the same time, we ought never to forget that true public economy consists not in withholding the means necessary to accomplish important national objects confided to us by the Constitution, but in taking care that the money appropriated for these purposes shall be faithfully and frugally expended. It will appear from the report of the Secretary of the Treasury that it is extremely doubtful, to say the least, whether we shall be able to pass through the present and the next fiscal year without providing additional revenue. This can only be accomplished by strictly confining the appropriations within the estimates of the different departments, without making an allowance for any additional expenditures which Congress may think proper in their discretion to authorize, and without providing for the redemption of any portion of the $20 million of Treasury notes which have been already issued. In the event of a deficiency which I consider probable, this ought never to be supplied by a resort to additional loans. It would be a ruinous practice in the days of peace and prosperity to go on increasing the national debt to meet the ordinary expenses of the government. This policy would cripple our resources and impair our credit in case the existence of war should render it necessary to borrow money. Should such a deficiency occur as I apprehend, I would recommend that the necessary revenue be raised by an increase of our present duties on imports. I need not repeat the opinions expressed in my last annual message as to the best mode and manner of accomplishing this object, and shall now merely observe that these have since undergone no change. The report of the Secretary of the Treasury will explain in detail the operations of that department of the government. The receipts into the Treasury from all sources during the fiscal year ending June 30th, 1859, including the loan authorized by the act of June 14th, 1858, and the issues of Treasury notes authorized by existing laws, were $81,692,471.01, which sum, with the balances of $6,398,316.10 remaining in the Treasury at the commencement of the fiscal year, made an aggregate for the service of the year of $88,090,787.11. The public expenditures during the fiscal year ending June 30th, 1859, amounted to $83,751,511.57. Of this sum, $17,405,285.44 were applied to the payment of interest on the public debt and the redemption of the issues of Treasury notes. The expenditures for all other branches of the public service during that fiscal year were therefore $66,346,226.13. The balance remaining in the Treasury on the 1st of July, 1859, being the commencement of the present fiscal year, was $4,339,275.54. The receipts into the Treasury during the first quarter of the present fiscal year, commencing July 1, 1859, were $20,618,865.85. Of this amount, $3,821,300 was received on account of the loan and the issue of Treasury notes, the amount of $16,797,565.85 having been received during the quarter from the ordinary sources of public revenue. The estimated receipts for the remaining 3 quarters of the present fiscal year to June 30th, 1860, are $50,426,400. Of this amount, it is estimated that $5,756,400 will be received for Treasury notes which may be reissued under the 5th section of the Act of 3rd March last, and $1,170,000 on account of the loan authorized by the Act of June 14, 1858, making $6,926,400 from these extraordinary sources, and $43,500,000 from the ordinary sources of the public revenue, making an aggregate, with the balance in the Treasury on the 1st of July, 1859, of $75,384,541.89 for the estimated means of the present fiscal year ending June 30th, 1860. The expenditures during the first quarter of the present fiscal year were $20,007,174.76. $4,664,366.76 of this sum were applied to the payment of interest on the public debt and the redemption of the issues of Treasury notes, and the remainder being $15,342,808 were applied to ordinary expenditures during the quarter. The estimated expenditures during the remaining 3 quarters to June 30th, 1860 are $40,995,558.23, of which sum $2,886,621.34 are estimated for the interest on the public debt. The ascertained and estimated expenditures for the fiscal year ending June 30th, 1860, on account of the public debt, are accordingly $7,550,988.10, and for the ordinary expenditures of the government, $53,451,744.89, making an aggregate of $61,002,732.99, leaving an estimated balance in the Treasury on June 30th, 1860 of $14,381,808.40. The estimated receipts during the next fiscal year ending June 30th, 1861 are $66,225,000, which, with the balance estimated as before stated, as remaining in the Treasury on the 30th of June, 1860, will make an aggregate for the service of the next fiscal year of $80,606,808.40. The estimated expenditures during the next fiscal year, ending June 30th, 1861, are $66,714,928.79. Of this amount, $3,386,621.34 will be required to pay the interest on the public debt, leaving the sum of $63,328,307.45 for the estimated ordinary expenditures during the fiscal year ending the 30th of June, 1861. Upon these estimates, a balance will be left in the Treasury on the 30th of June, 1861 of $13,891,879.61. But this balance, as well as that estimated to remain in the Treasury on the 1st of July, 1860, will be reduced by such appropriations as shall be made by law to carry into effect certain Indian treaties during the present fiscal year, asked for by the Secretary of the Interior to the amount of $539,350. And upon the estimates of the Postmaster General for the service of his department the last fiscal year, ending June 30th, 1859, amounting to $4,296,009, together with the further estimate of that officer for the service of the present fiscal year, ending the 30th of June, 1860, being $5,526,324, making an aggregate of $10,361,683. Should these appropriations be made as requested by the proper departments, the balance in the Treasury on the 30th of June, 1861, will not, it is estimated, exceed $3,530,196.61. I transmit herewith the reports of the Secretaries of War, of the Navy, of the Interior, and of the Postmaster General, They each contain valuable information and important recommendations well worthy of the serious consideration of Congress. It will appear from the report of the Secretary of War that the Army expenditures have been materially reduced by a system of rigid economy, which in his opinion offers every guarantee that the reduction will be permanent. The estimates of the Department for the next have been reduced nearly $2 million below the estimates for the present fiscal year and $500,000 below the amount granted for this year at the last session of Congress. The expenditures of the Post Office Department during the past fiscal year ending on the 30th of June, 1859, exclusive of payments for mail service specially provided for by Congress out of the General Treasury, amounted to $14,964,493.33, and its receipts to $7,968,484.07, showing a deficiency to be supplied from the Treasury of $6,996,009.26 against $5,235,677.15 for the year ending the 30th of June, 1858. The increased cost of transportation growing out of the expansion of the service required by Congress explains this rapid augmentation of the expenditures. It is gratifying, however, to observe an increase of receipts for the year ending on the 30th of June, 1859, equal to $481,691.21, compared with those in the year ending on the 30th of June, 1858. It is estimated that the deficiency for the current fiscal year will be $5,988,424.04, but that for the year ending the 30th of June, 1861, it will not exceed $1,342,473.90, should Congress adopt the measures of reform proposed and urged by the Postmaster General. Since the month of March, retrenchments have been made in the expenditures amounting to $1,826,471 annually, which, however, did not take effect until after the commencement of the present fiscal year. The period seems to have arrived for determining the question whether this department shall become a permanent and ever-increasing charge upon the Treasury, or shall be permitted to resume the self-sustaining policy which had so long controlled its administration. The course of legislation recommended by the Postmaster General for the relief of the Department from its present embarrassments and for restoring it to its original independence is deserving of your early and earnest consideration. In conclusion, I would again commend to the just liberality of Congress the local interests of the District of Columbia. Surely the city bearing the name of Washington, and destined, I trust, for ages to be the capital of our united, free, and prosperous Confederacy, has strong claims on our favorable regard. James Buchanan, December 19, 1859. End of Section 6. Section 7 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. State of the Union Address, James Buchanan, December 3, 1860, Part 1. Fellow Citizens of the Senate and House of Representatives. Throughout the year since our last meeting, The country has been eminently prosperous in all its material interests. The general health has been excellent. Our harvests have been abundant, and plenty smiles throughout the land. Our commerce and manufactures have been prosecuted with energy and industry, and have yielded fair and ample returns. In short, no nation in the tide of time has ever presented a spectacle of greater material prosperity than we have done until within a very recent period. Why is it, then, that discontent now so extensively prevails, and the union of states, which is the source of all these blessings, is threatened with destruction? The long-continued and intemperate interference of the Northern people with the question of slavery in the Southern states has at length produced its natural effects. The different sections of the Union are now arrayed against each other, and the time has arrived, so much dreaded by the Father of his country, when hostile geographical parties have been formed. I have long foreseen and often forewarned my countrymen of the now impending danger. This does not proceed solely from the claim on the part of Congress or the territorial legislatures to exclude slavery from the territories, nor from the efforts of different states to defeat the execution of the fugitive slave law. All or any of these evils might have been endured by the South without danger to the Union, as others have been, in the hope that time and reflection might apply the remedy. The immediate peril arises not so much from these causes as from the fact that the incessant and violent agitation of the slavery question throughout the North for the last quarter of a century has at length produced its malign influence on the slaves and inspired them with vague notions of freedom. Hence, a sense of security no longer exists around the family altar. This feeling of peace at home has given place to apprehension of servile insurrections. Many a matron throughout the South retires at night in dread of what may befall herself and children before the morning. Should this apprehension of domestic danger, whether real or imaginary, extend and intensify itself until it shall pervade the masses of the Southern people, then disunion will become inevitable. Self-preservation is the first law of nature, and has been implanted in the heart of man by his Creator for the wisest purpose, and no political union, however fraught with blessings and benefits in all other respects, can long continue if the necessary consequence be to render the homes and the firesides of nearly half the parties to it habitually and hopelessly insecure. Sooner or later, the bonds of such a union must be severed. It is my conviction that this fatal period has not yet arrived, and my prayer to God is that He would preserve the Constitution and the Union throughout all generations. But let us take warning in time and remove the cause of danger. It cannot be denied that for 25 years the agitation at the North against slavery has been incessant. In 1835, pictorial handbills and inflammatory appeals were circulated extensively throughout the South, of a character to excite the passions of the slaves, and, in the language of General Jackson, to stimulate them to insurrection and produce all the horrors of a servile war. This agitation has ever since been continued by the public press, by the proceedings of state and county conventions, and by abolition sermons and lectures. The time of Congress has been occupied in violent speeches on this never-ending subject, and appeals, in pamphlet and other forms, endorsed by distinguished names, have been sent forth from this central point and spread broadcast over the Union. How easy it would be for the American people to settle the slavery question forever, and to restore peace and harmony to this distracted country. They and they alone can do it. All that is necessary to accomplish the object, and all for which the slave states have ever contended, is to be let alone and permitted to manage their domestic institutions in their own way. As sovereign states, they and they alone are responsible before God and the world for the slavery existing among them. For this, the people of the North are not more responsible and have no more fight to interfere than with similar institutions in Russia or in Brazil. Upon their good sense and patriotic forbearance, I confess I still greatly rely. Without their aid, it is beyond the power of any president, no matter what may be his own political proclivities, to restore peace and harmony among the states. Wisely limited and restrained as is his power under our Constitution and laws, he alone can accomplish but little good, or for evil, on such a momentous question. And this brings me to observe that the election of any one of our fellow citizens to the office of President does not of itself afford just cause for dissolving the Union. This is more especially true if his election has been effected by a mere plurality, and not a majority of the people, and has resulted from transient and temporary causes which may probably never again occur. In order to justify a resort to revolutionary resistance, the federal government must be guilty of a deliberate, palpable, and dangerous exercise of powers not granted by the Constitution. The late presidential election, however, has been held in strict conformity with its express provisions. How then can the result justify a revolution to destroy this very Constitution? Reason, justice, a regard for the Constitution, all require that we shall wait for some overt and dangerous act on the part of the President-elect before resorting to such a remedy. It is said, however, that the antecedents of the President-elect have been sufficient to justify the fears of the South, that he will attempt to invade their constitutional rights. But are such apprehensions of contingent danger in the future sufficient to justify the immediate destruction of the noblest system of government ever devised by mortals? From the very nature of his office and its high responsibilities, he must necessarily be conservative. The stern duty of administering the vast and complicated concerns of this government affords in itself a guarantee that he will not attempt any violation of a clear constitutional right. After all, he is no more than the chief executive officer of the government. His province is not to make, but to execute the laws. And it is a remarkable fact in our history that, notwithstanding the repeated efforts of the anti-slavery party, no single act has ever passed Congress, unless we may possibly accept the Missouri Compromise, impairing in the slightest degree the rights of the South to their property in slaves. And it may also be observed, judging from present indications, that no probability exists of the passage of such an act by a majority of both houses, either in the present or in the next Congress. Surely under these circumstances we ought to be restrained from present action by the precept of him who spake as man never spoke, that sufficient unto the day is the evil thereof. The day of evil may never come unless we shall rashly bring it upon ourselves. It is alleged as one cause for immediate secession that the Southern states are denied equal rights with the other states in the common territories. But by what authority are these denied? Not by Congress, which has never passed, and I believe never will pass, any act to exclude slavery from these territories, and certainly not by the Supreme Court, which has solemnly decided that slaves are property, and, like all other property, their owners have a right to take them into the common territories and hold them there under the protection of the Constitution. So far, then, as Congress is concerned, the objection is not to anything that they have already done, but to what they may do hereafter. It will surely be admitted that this apprehension of future danger is no good reason for an immediate dissolution of the Union. It is true that the territorial legislature of Kansas on the 23rd of February, 1860, passed in great haste an act over the veto of the governor declaring that slavery is and shall be forever prohibited in this territory. Such an act, however, plainly violating the rights of property secured by the Constitution, will surely be declared void by the judiciary whenever it shall be presented in a legal form. Only 3 days after my inauguration, the Supreme Court of the United States solemnly adjudged that this power did not exist in a territorial legislature. Yet such has been the factious temper of the times, that the correctness of this decision has been extensively impugned before the people, and the question has given rise to angry political conflicts throughout the country. Those who have appealed from this judgment of our highest constitutional tribunal to popular assemblies would, if they could, invest a territorial legislature with power to annul the sacred rights of property. This power Congress is expressly forbidden by the Federal Constitution to exercise. Every state legislature in the Union is forbidden by its own Constitution to exercise it. It cannot be exercised in any state except by the people in their highest sovereign capacity when framing or amending their state constitution. In like manner, it can only be exercised by the people of a territory represented in a convention of delegates for the purpose of framing a constitution preparatory to admission as a state into the Union. Then, and not until then, are they invested with power to decide the question whether slavery shall or shall not exist within their limits. This is an act of sovereign authority, and not of subordinate territorial legislation. Were it otherwise, then indeed would the equality of the states in the territories be destroyed, and the rights of property in slaves would depend not upon the guarantees of the Constitution, but upon the shifting majorities of an irresponsible territorial legislature. Such a doctrine, from its intrinsic unsoundness, cannot long influence any considerable portion of our people. Much less can it afford a good reason for a dissolution of the Union. The most palpable violations of constitutional duty which have yet been committed consist in the acts of different state legislatures to defeat the execution of the fugitive slave law. It ought to be remembered, however, that for these acts neither Congress nor any president can justly be held responsible. Having been passed in violation of the Federal Constitution, they are therefore null and void. All the courts, both state and national, before whom the question has arisen, have from the beginning declared the fugitive slave law to be constitutional. The single exception is that of a state court in Wisconsin, and this has not only been reversed by the proper appellate tribunal, but has met with such universal reprobation that there can be no danger from it as a precedent. The validity of this law has been established over and over again by the Supreme Court of the United States with perfect unanimity. It is rounded upon an express provision of the Constitution requiring that fugitive slaves who escape from service in one state to another shall be delivered up to their masters. Without this provision, it is well known historical fact that the Constitution itself could never have been adopted by the Convention. In one form or another, under the Acts of 1793 and 1850, both being substantially the same, the fugitive slave law has been the law of the land from the days of Washington until the present moment. Here, then, a clear case is presented in which it will be the duty of the next president, as it has been my own, to act with vigor in executing this supreme law against the conflicting enactments of state legislatures. Should he fail in the performance of this high duty, he will then have manifested a disregard of the Constitution and laws, to the great injury of the people, of nearly one-half of the states of the Union. But are we to presume in advance that he will thus violate his duty? This would be at war with every principle of justice and of Christian charity. Let us wait for the overt act. The fugitive slave law has been carried into execution in every contested case since the commencement of the present administration, though often it is to be regretted with great loss and inconvenience to the master, and with considerable expense to the government. Let us trust that the state legislatures will repeal their unconstitutional and obnoxious enactments. Unless this shall be done without unnecessary delay, it is impossible for any human power to save the Union. The Southern states, standing on the basis of the Constitution, have right to demand this act of justice from the states of the North. Should it be refused, then the Constitution, to which all the states are parties, will have been willfully violated by one portion of them, any provision essential to the domestic security and happiness of the remainder. In that event, the injured states, after having first used all peaceful and constitutional means to obtain redress, would be justified in revolutionary resistance to the government of the Union. I have purposely confined my remarks to revolutionary resistance because it has been claimed within the last few years that any state, whenever this shall be its sovereign will and pleasure, may secede from the Union in accordance with the Constitution, and without any violation of the constitutional rights of the other members of the Confederacy. That as each became parties to the Union by the vote of its own people assembled in convention, so any one of them may retire from the Union in a similar manner by the vote of such a convention. In order to justify secession as a constitutional remedy, must be on the principle that the federal government is a mere voluntary association of states, to be dissolved at pleasure by any one of the contracting parties. If this be so, the Confederacy is a rope of sand, to be penetrated and dissolved by the first adverse wave of public opinion in any of the states. In this manner, our 33 states may resolve themselves into as many petty, jarring, and hostile republics, each one retiring from the Union without responsibility whenever any sudden excitement may impel them to such a course. By this process a Union might be entirely broken into fragments in a few weeks, which cost our forefathers many years of toil, privation, and blood to establish. Such a principle is wholly inconsistent with the history as well as the character of the Federal Constitution. After it was framed, with the greatest deliberation and care, it was submitted to conventions of the people of the several states for ratification. Its provisions were discussed at length in these bodies, composed of the first men of the country. Its opponents contended that it conferred powers upon the federal government dangerous to the rights of the states, whilst its advocates maintained that under a fair construction of the instrument there was no foundation for such apprehensions. In that mighty struggle between the first intellects of this or any other country, it never occurred to any individual, either among its opponents or advocates, to assert or even to intimate that their efforts were all vain labor, because the moment that any state felt herself aggrieved, she might secede from the Union. What a crushing argument would this have proved against those who dreaded that the rights of the states would be endangered by the Constitution. The truth is that it was not until many years after the origin of the federal government that such a proposition was first advanced. It was then met and refuted by the conclusive arguments of General Jackson, who in his message of the 16th of January, 1833, transmitting the nullifying ordinance of South Carolina to Congress, employs the following language: "The right of the people of a single state to absolve themselves at will and without the consent of the other states from their most solemn obligations, and hazard the liberties and happiness of the millions composing this Union, cannot be acknowledged. Such authority is believed to be utterly repugnant both to the principles upon which the general government is constituted and to the objects which it is expressly formed to attain. It is not pretended that any clause in the Constitution gives countenance to such a theory. It is altogether rounded upon inference, not from any language contained in the instrument itself, but from the sovereign character of the several states by which it was ratified. But is it beyond the power of a state, like an individual, to yield a portion of its sovereign rights to secure the remainder? In the language of Mr. Madison, who has been called the father of the Constitution, it was formed by the states, that is, by the people in each of the states acting in their highest sovereign capacity, and formed consequently by the same authority which formed the state constitutions. Nor is the government of the United States created by the Constitution less a government, in the strict sense of the term, within the sphere of its powers than the governments created by the constitutions of the states are within their several spheres. It is like them, organized into legislative, executive, and judiciary departments. It operates like them directly on persons and things, and, like them, it has at command a physical force for executing the powers committed to it. It was intended to be perpetual, and not to be annulled at the pleasure of any one of the contracting parties. The old Articles of Confederation were entitled Articles of Confederation and Perpetual Union between the States, and by the 13th Article it is expressly declared that the articles of this Confederation shall be inviolably observed by every state, and the Union shall be perpetual. The preamble of the Constitution of the United States, having express reference to the Articles of Confederation, recites that it was established in order to form a more perfect union, and yet it is contended that this more perfect union does not include the essential attribute of perpetuity. But that the Union was designed to be perpetual appears conclusively from the nature and extent of the powers conferred by the Constitution on the federal government. These powers embrace the very highest attributes of national sovereignty. They place both the sword and the purse under its control. Congress has power to make war and to make peace, to raise and support armies and navies, and to conclude treaties with foreign governments. It is invested with the power to coin money and to regulate the value thereof, and to regulate commerce with foreign nations and among the several states. It is not necessary to enumerate the other high powers which have been conferred upon the federal government. In order to carry the enumerated powers into effect, Congress possesses the exclusive right to lay and collect duties on imports, and, in common with the states, to lay and collect all other taxes. But the Constitution has not only conferred these high powers upon Congress, but it has adopted effectual means to restrain the states from interfering with their exercise. For that purpose, it has in strong prohibitory language expressly declared that no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts. Moreover, no state shall without the consent of Congress lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and if they exceed this amount, the excess shall belong to the United States. And no state shall without the consent of Congress lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. In order still further to secure the uninterrupted exercise of these high powers against state interposition, it is provided that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. The solemn sanction of religion has been superadded to the obligations of official duty, and all senators and representatives of the United States, all members of state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. In order to carry into effect these powers, the Constitution has established a perfect government in all its forms, legislative, executive, and judicial, and this government, to the extent of its powers, acts directly upon the individual citizen of every state and executes its own decrees by the agency of its own officers. In this respect, it differs entirely from the government under the old Confederation, which was confined to making requisitions on the states in their sovereign character. This left it in the discretion of each whether to obey or to refuse, and they often declined to comply with such requisitions. It thus became necessary, for the purpose of removing this barrier, and in order to form a more perfect union, to establish a government which could act directly upon the people and execute its own laws without the intermediate agency of the states. This has been accomplished by the Constitution of the United States. In short, the government created by the Constitution, and deriving its authority from the sovereign people of each of the several states, has precisely the same right to exercise its power over the people of all these states in the enumerated cases that each of them possesses over subjects not delegated to the United States, but reserved to the states respectively or to the people. To the extent of the delegated powers, the Constitution of the United States is as much a part of the Constitution of each state, and is as binding upon its people as though it had been textually inserted therein. This government, therefore, is a great and powerful government, invested with all the attributes of sovereignty over the special subjects to which its authority extends. Its framers never intended to implant in its bosom the seeds of its own destruction, nor were they at its creation guilty of the absurdity of providing for its own dissolution. It was not intended by its framers to be the baseless fabric of a vision which at the touch of the enchanter would vanish into thin air, but a substantial and mighty fabric capable of resisting the slow decay of time and of defying the storms of ages. Indeed, well may the jealous patriots of that day have indulged fears that a government of such high powers might violate the reserved rights of the states, and wisely did they adopt the rule of a strict construction of these powers to prevent the danger. But they did not fear, nor had they any reason to imagine, that the Constitution would ever be so interpreted as to enable any state by her own act, and without the consent of her sister states, to discharge her people from all or any of their federal obligations. It may be asked, then, are the people of the states without redress against the tyranny and oppression of the federal government? By no means. The right of resistance on the part of the governed against the oppression of their governments cannot be denied. It exists independently of all constitutions, and has been exercised at all periods of the world's history. Under it, old governments have been destroyed, and new ones have taken their place. It is embodied in strong and express language in our own Declaration of Independence. But the distinction must ever be observed that this is revolution against an established government, and not a voluntary secession from it by virtue of an inherent constitutional right. In short, let us look the danger fairly in the face. Secession is neither more nor less than revolution. It may or may not be a justifiable revolution, but still, it is a revolution. What, in the meantime, is the responsibility and true position of the executive? He is bound by solemn oath before God and country to take care that the laws be faithfully executed, and from this obligation he cannot be absolved by any human power. But what if the performance of this duty, in whole or in part, has been rendered impracticable by events over which he could have exercised no control? Such at the present moment is the case throughout the state of South Carolina, so far as the laws of the United States to secure the administration of justice by means of the federal judiciary are concerned. All the federal officers within its limits, through whose agency alone these laws can be carried into execution, have already resigned. We no longer have a district judge, a district attorney, or a marshal in South Carolina. In fact, the whole machinery of the federal government necessary for the distribution of remedial justice among the people has been demolished, and it would be difficult, if not impossible, to replace it. The only acts of Congress on the statute book bearing upon this subject are those of February 28, 1795, and March 3, 1807. These authorize the President, after he shall have ascertained that the Marshal, with his posse comitatus, is unable to execute civil or criminal process in any particular case, to call forth the militia and employ the army and navy to aid him in performing the service. Having first, by proclamation, commanded the insurgents to disperse and retire peaceably to their respective abodes within a limited time. This duty cannot by possibility be performed in a state where no judicial authority exists to issue process, and where there is no marshal to execute it, and where, even if there were such an officer, the entire population would constitute one solid combination to resist him. To bear enumeration of these provisions proves how inadequate they are without further legislation to overcome a united opposition in a single state, not to speak of other states, who may place themselves in a similar attitude. Congress alone has power to decide whether the present laws can or cannot be amended so as to carry out more effectually the objects of the Constitution. The same insuperable obstacles do not lie in the way of executing the laws for the collection of the customs. The revenue still continues to be collected as heretofore at the Customs House in Charleston, and should the collector unfortunately resign, a successor may be appointed to perform this duty. Then, in regard to the property of the United States in South Carolina, this has been purchased for a fair equivalent by the consent of the legislature of the state, for the creation of forts, magazines, arsenals, etc., and over these the authority to exercise exclusive legislation has been expressly granted by the Constitution to Congress. It is not believed that any attempt will be made to expel the United States from this property by force. But if in this I should prove to be mistaken, the officer in command of the forts has received orders to act strictly on the defensive. In such a contingency, the responsibility for consequences would rightfully rest upon the heads of the assailants. Apart from the execution of the laws, so far as this may be practicable, the executive has no authority to decide what shall be the relations between the federal government and South Carolina. He has been invested with no such discretion. He possesses no power to change the relations heretofore existing between them, much less to acknowledge the independence of that state. This would be to invest a mere executive officer with the power of recognizing the dissolution of the Confederacy among our 33 sovereign states, It bears no resemblance to the recognition of a foreign de facto government involving no such responsibility. Any attempt to do this would on his part be a naked act of usurpation. It is therefore my duty to submit to Congress the whole question in all its beatings. The course of events is so rapidly hastening forward that the emergency may soon arise when you may be called upon to decide the momentous question whether you possess the power by force of arms to compel a state to remain in the Union. I should feel myself recreant to my duty were I not to express an opinion on this important subject. The question fairly stated is, has the Constitution delegated to Congress the power to coerce a state into submission which is attempting to withdraw or who has actually withdrawn from the Confederacy? If answered in the affirmative, it must be on the principle that the power has been conferred upon Congress to declare and to make war against a state. After much serious reflection, I have arrived at the conclusion that no such power has been delegated to Congress or to any other department of the federal government. It is manifest upon an inspection of the Constitution that this is not among the specific and enumerated powers granted to Congress, and it is equally apparent that its exercise is not necessary and proper for carrying into execution any one of these powers. So far from this power having been delegated to Congress, it was expressly refused by the convention which framed the Constitution. It appears from the proceedings of that body that on the 31st of May, 1787, the clause authorizing an exertion of force of the whole against a delinquent state came up for consideration. Mr. Madison opposed it in a brief but powerful speech, from which I shall extract but a single sentence. He observed, "The use of force against a state would look more like a declaration of war than an infliction of punishment, and would probably be considered by the party attacked as a dissolution of all previous compacts by which it might be bound." Upon this motion the clause was unanimously postponed, and was never, I believe, again presented. Soon afterwards, on the 8th of June, 1787, which incidentally adverting to the subject, he said, "Any government for the United States formed on the supposed practicability of using force against the unconstitutional proceedings of the States would prove as visionary and fallacious as the government of Congress," evidently meaning the then existing Congress of the old Confederation. Without descending to particulars, it may be safely asserted that the power to make war against a state is at variance with the whole spirit and intent of the Constitution. Suppose such a war should result in the conquest of a state. How are we to govern it afterwards? Shall we hold it as a province and govern it by despotic power? In the nature of things, we could not by physical force control the will of the people, and compel them to elect senators and representatives to Congress and to perform all the other duties depending upon their own volition and required from the free citizens of a free state as a constituent member of the Confederacy. But if we possessed this power, would it be wise to exercise it under existing circumstances? The object would doubtless be to preserve the Union. War would not only present the most effectual means of destroying it, but would vanish all hope of its peaceable reconstruction. Besides, in the fraternal conflict a vast amount of blood and treasure would be expended, rendering future reconciliation between the states impossible. In the meantime, who can foretell what would be the sufferings and privations of the people during its existence? The fact is that our Union rests upon public opinion, and can never be cemented by the blood of its citizens shed in civil war. If it cannot live in the affections of the people, it must one day perish. Congress possesses many means of preserving it by conciliation, but the sword was not placed in their hand to preserve it by force. But may I be permitted solemnly to invoke my countrymen to pause and deliberate before they determine to destroy this, the grandest temple which has ever been dedicated to human freedom since the world began. It has been consecrated by the blood of our fathers, by the glories of the past, and by the hopes of the future. The Union has already made us the most prosperous, and ere long will, if preserved, render us the most powerful nation on the face of the earth. In every foreign region of the globe, the title of American citizen is held in the highest respect, and when pronounced in a foreign land, it causes the hearts of our countrymen to swell with honest pride. Surely, when we reach the brink of the yawning abyss, we shall recoil with horror from the last fatal plunge. By such a dread catastrophe, the hopes of the friends of freedom throughout the world would be destroyed, and a long night of leaden despotism would enshroud the nations. Our example for more than 80 years would not only be lost, but it would be quoted as a conclusive proof that man is unfit for self-government. It is not every wrong, nay, it is not every grievous wrong, which can justify a resort to such a fearful alternative. This ought to be the last desperate remedy of a despairing people. After every other constitutional means of conciliation had been exhausted, we should reflect that under this free government there is an incessant ebb and flow in public opinion. The slavery question, like everything human, will have its day. I firmly believe that it has reached and passed the culminating point, but if in the midst of the existing excitement the Union shall perish, the evil may become irreparable. Congress can contribute much to avert it by proposing and recommending to the legislatures of the several states the remedy for existing evils which the Constitution has itself provided for its own preservation. This had been tried at different critical periods of our history, and always with eminent success. It is to be found in the 5th article providing for its own amendment. Under this article, amendments have been proposed by 2/3 of both houses of Congress, and have been ratified by the legislatures of 3/4 of the several states, and have consequently become parts of the Constitution. To this process the country is indebted for the clause prohibiting Congress from passing any law respecting an establishment of religion, or abridging the freedom of speech, or of the press, or of the right of petition. To this we are also indebted for the Bill of Rights, which secures the people against any abuse of power by the federal government. Such were the apprehensions justly entertained by the friends of state rights at that period, as to have rendered it extremely doubtful whether the Constitution could have long survived without those amendments. Again, the Constitution was amended by the same process. After the election of President Jefferson by the House of Representatives in February 1803, this amendment was rendered necessary to prevent a recurrence of the dangers which had seriously threatened the existence of the government during the pendency of that election. The article for its own amendment was intended to secure the amicable adjustment of conflicting constitutional questions like the present, which might arise between the governments of the states and that of the United States. This appears from contemporaneous history. In this connection I shall merely call attention to a few sentences in Mr. Madison's justly celebrated report in 1799 to the legislature of Virginia. In this he ably and conclusively defended the resolutions of the preceding legislature against the strictures of several other state legislatures. These were mainly rounded upon the protest of the Virginia legislature against the Alien and Sedition Acts as palpable and alarming infractions of the Constitution, in pointing out the peaceful and constitutional remedies, and he referred to none other, to which the states were authorized to resort on such occasions. He concludes by saying that the legislatures of the states might have made a direct representation to Congress with a view to obtain a rescinding of the two offensive acts, or they might have represented to their respective senators in Congress their wish that 2/3 thereof would propose an explanatory amendment to the Constitution, or 2/3 of themselves, if such had been their option, might, by an application to Congress, have obtained a convention for the same object. This is the very course which I earnestly recommend, in order to obtain an explanatory amendment of the Constitution on the subject of slavery. This might originate with Congress or the state legislatures, as may be deemed most advisable to attain the object. The explanatory amendment might be confined to the final settlement of the true construction of the Constitution on 3 special points. 1. An express recognition of the right of property in slaves in the states where it now exists or may hereafter exist. 2. The duty of protecting this right in all the common territories throughout their territorial existence, and until they shall be admitted as states into the Union, with or without slavery, as their constitutions may prescribe. 3. A like recognition of the right of the master to have his slave, who has escaped from one state to another, restored and delivered up to him, and of the validity of the fugitive slave law enacted for this purpose, together with a declaration that all state laws impairing or defeating this right are violations of the Constitution, and are consequently null and void. It may be objected that this construction of the Constitution has already been settled by the Supreme Court of the United States, and what more ought to be required? The answer is that a very large proportion of the people of the United States still contest the correctness of this decision, and never will cease from agitation and admit its binding force until clearly established by the people of the several states in their sovereign character. Such an explanatory amendment would, it is believed, forever terminate the existing dissensions and restore peace and harmony among the states. It ought not to be doubted that such an appeal to the arbitrament established by the Constitution itself would be received with favor by all the states of the Confederacy. In any event, it ought to be tried in a spirit of conciliation before any of these states shall separate themselves from the Union. End of Section 7. James Buchanan, December 3rd, 1860, Part 1. Section 8 of State of the Union Addresses, 1857 to 1860. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. State of the Union Address, James Buchanan, December 3rd, 1860, Part 2. When I entered upon the duties of the presidential office, the aspect neither of our foreign nor domestic affairs was at all satisfactory. We were involved in dangerous complications with several nations, and 2 of our territories were in a state of revolution against the government. A restoration of the African slave trade had numerous and powerful advocates. Unlawful military expeditions were countenanced by many of our citizens, and were suffered, in defiance of the efforts of the government, to escape from our shores for the purpose of making war upon the offending people of neighboring republics with whom we were at peace. In addition to these and other difficulties, we experienced a revulsion in monetary affairs soon after my advent to power of unexampled severity, and of ruinous consequences to all the great interests of the country. When we take a retrospect of what was then our condition, and contrast this with its material prosperity at the time of the late presidential election, we have abundant reason to return our grateful thanks to that merciful Providence which has never forsaken us as a nation in all our past trials. Our relations with Great Britain are of the most friendly character. Since the commencement of my administration, the 2 dangerous questions arising from the Clayton and Bulwer Treaty and from the right of search claimed by the British government have been amicably and honorably adjusted. The discordant constructions of the Clayton and Bulwer Treaty between the two governments, which at different periods of the discussion bore a threatening aspect, have resulted in a final settlement entirely satisfactory to this government. In my last annual message, I informed Congress that the British government had not then completed treaty arrangements with the republics of Honduras and Nicaragua in pursuance of the understanding between the two governments. It is nevertheless confidently expected that this good work will ere long be accomplished. This confident expectation has since been fulfilled. Her Britannic Majesty concluded a treaty with Honduras on the 28th of November, 1859, and with Nicaragua on the 28th of August, 1860, relinquishing the Mosquito Protectorate. Besides, by the former, the Bay Islands are recognized as a part of the Republic of Honduras. It may be observed that the stipulations of these treaties conform in every important particular to the amendments adopted by the Senate of the United States to the treaty concluded at London on the 17th of October, 1856, between the two governments. It will be recollected that this treaty was rejected by the British government because of its objection to the just and important amendment of the Senate to the article relating to Roatan and the other islands in the Bay of Honduras. It must be a source of sincere satisfaction to all classes of our fellow citizens, and especially to those engaged in foreign commerce, that the claim on the part of Great Britain forcibly to visit and search American merchant vessels on the high seas in time of peace has been abandoned. This was by far the most dangerous question to the peace of the two countries, which has existed since the War of 1812. Whilst it remained open, they might at any moment have been precipitated into a war. This was rendered manifest by the exasperated state of public feeling throughout our entire country, produced by the forcible search of American merchant vessels by British cruisers on the coast of Cuba in the spring of 1858. The American people hailed with general acclaim the orders of the Secretary of the Navy to our naval force in the Gulf of Mexico to protect all vessels of the United States on the high seas from search or detention by the vessels of war of any other nation. These orders might have produced an immediate collision between the naval forces of the two countries. This was most fortunately prevented by an appeal to the justice of Great Britain and to the law of nations as expounded by her own most eminent jurists. The only question of any importance which still remains open is the disputed title between the two governments to the island of San Juan, in the vicinity of Washington Territory. As this question is still under negotiation, it is not deemed advisable at the present moment to make any other allusion to the subject. The recent visit of the Prince of Wales, in a private character, to the people of this country has proved to be a most auspicious event. In its consequences, it cannot fail to increase the kindred and kindly feelings which I trust may ever actuate the government and people of both countries in their political and social intercourse with each other. With France, our ancient and powerful ally, our relations continue to be of the most friendly character. A decision has recently been made by a French judicial tribunal, with the approbation of the imperial government, which cannot fail to foster the sentiments of mutual regard that have so long existed between the two countries. Under the French law, no person can serve in the armies of France unless he be a French citizen. The law of France recognizing the natural right of expatriation, it follows as a necessary consequence that a Frenchman, by the fact of having become a citizen of the United States, has changed his allegiance and has lost his native character. He cannot therefore be compelled to serve in the French armies, in case he should return to his native country. These principles were announced in 1852 by the French Minister of War, and in 2 late cases have been confirmed by the French judiciary. In these, 2 natives of France have been discharged from the French army because they had become American citizens. To employ the language of our present minister to France, who has rendered good service on this occasion, I do not think our French naturalized fellow citizens will hereafter experience much annoyance on the subject. I venture to predict that the time is not too far distant when the other continental powers will adopt the same wise and just policy which has done so much honor to the enlightened government of the Emperor. In any event, our government is bound to protect the rights of our naturalized citizens everywhere, to the same extent as though they had drawn their first breath in this country. We can recognize no distinction between our native and naturalized citizens. Between the great empire of Russia and the United States, the mutual friendship and regard which has so long existed still continues to prevail and, if possible, to increase. Indeed, our relations with that empire are all that we could desire. Our relations with Spain are now of a more complicated, though less dangerous character than they have been for many years. Our citizens have long held and continue to hold numerous claims against the Spanish government. These had been ably urged for a series of years by our successive diplomatic representatives at Madrid, but without obtaining redress. The Spanish government finally agreed to institute a joint commission for the adjustment of these claims, and on the 5th day of March, 1860, concluded a convention for this purpose with our present minister at Madrid. Under this convention, what have been denominated the Cuban claims, amounting to $128,635.54, in which more than 100 of our fellow citizens are interested, were recognized, and the Spanish government agreed to pay $100,000 of this amount within 3 months following the exchange of ratifications. The payment of the remaining $28,635.54 was to await the decision of the commissioners for or against the Amistad claim, but in any event the balance was to be paid to the claimants either by Spain or the United States. These terms, I have every reason to know, are highly satisfactory to the holders of the Cuban claims. Indeed, they have made a formal offer authorizing the State Department to settle these claims and to deduct the amount of the Amistad claim from the sums which they are entitled to receive from Spain. This offer, of course, cannot be accepted. All other claims of citizens of the United States against Spain, or the subjects of the Queen of Spain against the United States, including the Amistad claim, were by this convention referred to a board of commissioners in the usual form. Neither the validity of the Amistad claim nor any other claim against either party, with the single exception of the Cuban claims, was recognized by the convention. Indeed, the Spanish government did not insist that the validity of the Amistad claim should be thus recognized, notwithstanding its payment had been recommended to Congress by 2 of my predecessors as well as by myself, and an appropriation for that purpose had passed the Senate of the United States. They were content that it should be submitted to the board for examination and decision like the other claims. Both governments were bound respectively to pay the amounts awarded to the several claimants at such times and places as may be fixed by and according to the tenor of said awards. I transmitted this convention to the Senate for their constitutional action on the 3rd of May, 1860, and on the 27th of the succeeding June they determined that they would not advise and consent to its ratification. These proceedings placed our relations with Spain in an awkward and embarrassing position. It is more than probable that the final adjustment of these claims will devolve upon my successor. I reiterate the recommendation contained in my annual message of December 1858 and repeated in that of December 1859 in favor of the acquisition of Cuba from Spain by fair purchase. I firmly believe that such an acquisition would contribute essentially to the well-being and prosperity of both countries in all future time, as well as prove the certain means of immediately abolishing the African slave trade throughout the world. I would not repeat this recommendation upon the present occasion if I believed that the transfer of Cuba to the United States upon conditions highly favorable to Spain could justly tarnish the national honor of the proud and ancient Spanish monarchy. Surely no person ever attributed to the first Napoleon a disregard of the national honor of France for transferring Louisiana to the United States for a fair equivalent, both in money and commercial advantages. With the Emperor of Austria and the remaining continental powers of Europe, including that of the Sultan, our relations continue to be of the most friendly character. The friendly and peaceful policy pursued by the government of the United States toward the Empire of China has produced the most satisfactory results. The Treaty of Tientsin of the 18th June of 1858 has been faithfully observed by the Chinese authorities. The convention of the 8th November 1858 supplementary to this treaty for the adjustment and satisfaction of the claims of our citizens on China, referred in my last annual message, has been already carried into effect so far as this was practicable. Under this convention, the sum of 500,000 taels, equal to about $700,000, was stipulated to be paid in satisfaction of the claims of American citizens out of the 1/5 of the receipts for tonnage, import and export duties on American vessels at the ports of Canton, Shanghai, and Fuzhou, and it was agreed that this amount shall be in full liquidation of all claims of American citizens at the various ports to this date. Debentures for this amount, to wit, 300,000 taels for Canton, 100,000 for Shanghai, and 100,000 for Fuzhou, were delivered according to the terms of the convention by the respective Chinese collectors of the customs of these ports to the agent selected by our minister to receive the same. Since that time, the claims of our citizens have been adjusted by the Board of Commissioners appointed for that purpose under the Act of March 3rd, 1859, and their rewards, which proved satisfactory to the claimants, have been approved by our minister. In the aggregate, they amount to the sum of $498,694.78. The claimants have already received a large proportion of the sums awarded to them out of the fund provided, and it is confidently expected that the remainder will ere long be entirely paid. After the awards shall have been satisfied, there will remain a surplus of more than $200,000 at the disposition of Congress, and this will, in equity, belong to the Chinese government. Would not justice require its appropriation to some benevolent object in which the Chinese may be specially interested? Our minister to China, in obedience to his instructions, has remained perfectly neutral in the war between Great Britain and France and the Chinese Empire, although in conjunction with the Russian minister he was ever ready and willing, had the opportunity offered, to employ his good offices in restoring peace between the parties. It is but an act of simple justice, both to our present minister and his predecessor, to state that they have proved fully equal to the delicate, trying, and responsible positions in which they have on different occasions been placed. The ratifications of the treaty with Japan, concluded at Yedo on 29th of July, 1858, were exchanged at Washington on the 22nd May last, and the treaty itself was proclaimed on the succeeding day. There is good reason to expect that under its protection and influence our trade and intercourse with that distant and interesting people will rapidly increase. The ratifications of the treaty were exchanged with unusual solemnity. For this purpose, the Tycoon had accredited 3 of his most distinguished subjects as envoys extraordinary and ministers plenipotentiary, who were received and treated with marked distinction and kindness, both by the government and the people of the United States. There is every reason to believe that they have returned to their native land entirely satisfied with their visit and inspired by the most friendly feelings for our country. Let us ardently hope, in the language of the treaty itself, that there shall henceforward be perpetual peace and friendship between the United States of America and His Majesty the Tycoon of Japan and his successors. With the wise, conservative, and liberal government of the Empire of Brazil, our relations continue to be of the most amicable character. The exchange of the ratifications of the convention with the Republic of New Granada, signed at Washington on the 10th of September, 1857, has long been delayed from accidental causes for which neither party is censurable. These ratifications were duly exchanged in this city on the 5th of November last. Thus has a controversy been amicably terminated, which had become so serious at the period of my inauguration as to require me, on the 17th of April, 1857, to direct our minister to demand his passports and return to the United States. Under this convention, the government of New Granada has specially acknowledged itself to be responsible to our citizens for damages which were caused by the riot at Panama on the 15th of April, 1856. These claims, together with other claims of our citizens, which had been long urged in vain, are referred for adjustment to a board of commissioners. I submit a copy of the convention to Congress and recommend the legislation necessary to carry it into effect. Preserving efforts have been made for the adjustment of the claims of American citizens against the government of Costa Rica, and I am happy to inform you that these have finally prevailed. A convention was signed at the city of San Jose on the 2nd of July last between the minister resident of the United States in Costa Rica and the plenipotentiaries of that republic, referring these claims to a board of commissioners and providing for the payment of their awards. This convention will be submitted immediately to the Senate for their constitutional action. The claims of our citizens upon the Republic of Nicaragua have not yet been provided for by treaty, although diligent efforts for this purpose have been made by our minister resident to that republic. These are still continued with a fair prospect of success. Our relations with Mexico remain in a most unsatisfactory condition. In my last 2 annual messages, I discussed extensively the subject of these relations, and do not now propose to repeat it at length the facts and arguments then presented. They proved conclusively that our citizens residing in Mexico and our merchants trading thereto had suffered a series of wrongs and outrages such as we have never patiently borne from any other nation. For these, our successive ministers, invoking the faith of treaties, had, in the name of their country, persistently demanded redress and indemnification, but without the slightest effect. Indeed, So confident had the Mexican authorities become of our patient endurance that they universally believed they might commit these outrages upon American citizens with absolute impunity. Thus wrote our minister in 1856, and expressed the opinion that nothing but a manifestation of the power of the government and of its purpose to punish these wrongs will avail. Afterwards, in 1857, came the adoption of a new constitution for Mexico, the election of a president and Congress under its provisions, and the inauguration of the president. Within one short month, however, this president was expelled from the capital by a rebellion in the army, and the supreme power of the republic was assigned to General Zuloaga. This usurper was in his turn soon compelled to retire and give place to General Miramon. Under the constitution which had thus been adopted, Señor Juarez, a chief justice of the Supreme Court, became the lawful president of the republic, and it was for the maintenance of the constitution and his authority derived from it that the Civil War commenced, and still continues to be prosecuted. Throughout the year 1858, the constitutional party grew stronger and stronger. In the previous history of Mexico, a successful military revolution at the capital had almost universally been the signal for submission throughout the republic. Not so on the present occasion. A majority of the citizens persistently sustained the constitutional government. When this was recognized in April 1859 by the government of the United States, its authority extended over a large majority of the Mexican states and people, including Vera Cruz and all the other important seaports of the republic. From that period, our commerce with Mexico began to revive, and the constitutional government had afforded it all the protection in its power. Meanwhile, the government of Miramon still held sway at the capital and over the surrounding country, and continued its outrages against the few American citizens who still had the courage to remain within its power. To cap the climax, after the Battle of Tacubaya in April of 1859, General Marquez ordered 3 citizens of the United States, 2 of them physicians, to be seized in the hospital at that place, taken out, and shot, without crime and without trial. This was done, notwithstanding our unfortunate countrymen were at the moment engaged in the holy cause of affording relief to the soldiers of both parties who had been wounded in the battle, without making any distinction between them. The time had arrived, in my opinion, when this government was bound to exert its power to avenge and redress the wrongs of our citizens and to afford them protection in Mexico. The interposing obstacle was that the portion of the country under the sway of Miramon could not be reached without passing over territory under the jurisdiction of the constitutional government. Under these circumstances, I deemed it my duty to recommend to Congress in my last annual message the employment of a sufficient military force to penetrate into the interior, where the government of Miramon was to be found, with, or if need be, without the consent of the Juarez government, though it was not doubted that this consent should be obtained. Never had I a clearer conviction on any subject than of the justice as well as wisdom of such a policy. No other alternative was left except the entire abandonment of our fellow citizens who had gone to Mexico under the faith of treaties to the systematic injustice, cruelty, and oppression of Miramon's government. Besides, it is almost certain that the simple authority to employ this force would of itself have accomplished all our objects without striking a single blow. The constitutional government would then ere this have been established at the City of Mexico, and would have been ready and willing to the extent of its ability to do us justice. In addition, and I deem this a most important consideration, European governments would have been deprived of all pretext to interfere in the territorial and domestic concerns of Mexico. We should thus have been relieved from the obligation of resisting, even by force, should this become necessary, any attempt by these governments to deprive our neighboring republic of portions of her territory, a duty from which we could not shrink without abandoning the traditional and established policy of the American people. I am happy to observe that, firmly relying upon the justice and good faith of these governments, there is no present danger that such a contingency will happen. Having discovered that my recommendations would not be sustained by Congress, the next alternative was to accomplish in some degree, if possible, the same objects by treaty stipulations with the constitutional government. Such treaties were accordingly concluded by our late able and excellent minister to Mexico, and on the 4th of January last were submitted to the Senate for ratification. As these have not yet received the final action of that body, it would be improper for me to present a detailed statement of their provisions. Still, I may be permitted to express the opinion in advance that they are calculated to promote the agricultural, manufacturing, and commercial interests of the country, and to secure our just influence with an adjoining republic, as to whose fortunes and fate we can never feel indifferent, whilst at the same time they provide for the payment of a considerable amount toward the satisfaction of the claims of our injured fellow citizens. At the period of my inauguration, I was confronted in Kansas by a revolutionary government existing under what is called the Topeka Constitution. Its avowed object was to subdue the territorial government by force and to inaugurate what was called the Topeka government in its stead. To accomplish this object, an extensive military organization was formed, and its command entrusted to the most violent revolutionary leaders. Under these circumstances, it became my imperative duty to exert the whole constitutional power of the executive to prevent the flames of civil war from again raging in Kansas, which, in the excited state of the public mind, both North and South, might have extended into the neighboring states. The hostile parties in Kansas had been inflamed against each other by emissaries from both the North and the South, to a degree of malignity without parallel in our history. To prevent actual collision and to assist the civil magistrates in enforcing the laws, a strong detachment of the army was stationed in the territory, ready to aid the marshal and his deputies when lawfully called upon as a posse comitatus in the execution of civil and criminal process. Still, the troubles in Kansas could not have been permanently settled without an election by the people. The ballot box is the surest arbiter of disputes among free men. Under this conviction, every proper effort was employed to induce the hostile parties to vote at the election of delegates, to frame a state constitution, and afterwards at the election to decide whether Kansas should be a slave or free state. The insurgent party refused to vote at either, lest this might be considered a recognition on their part of the territorial government established by Congress. A better spirit, however, seemed soon after to prevail, and the two parties met face to face at the third election, held on the first Monday of January, 1858, for members of the legislature and state officers under the Lecompton Constitution. The result was the triumph of the anti-slavery party at the polls. This decision of the ballot box proved clearly that this party were in the majority and removed the danger of civil war. From that time we have heard little or nothing of the Topeka government, and all serious danger of revolutionary troubles in Kansas was then at an end. The Lecompton Constitution, which had been thus recognized at this state election by the votes of both political parties in Kansas, was transmitted to me with the request that I should present it to Congress. This I could not have refused to do without violating my clearest and strongest convictions of duty. The Constitution and all the proceedings which preceded and followed its formation were fair and regular on their face. I then believed, and experience has proved, that the interests of the people of Kansas would have been best consulted by its admission as a state into the Union, especially as the majority within a brief period could have amended the Constitution according to their will and pleasure. If fraud existed in all or any of these proceedings, it was not for the President, but for Congress to investigate and determine the question of fraud and what ought to be its consequences. If at the first two elections the majority refused to vote, it cannot be pretended that this refusal to exercise the elective franchise could invalidate an election fairly held under lawful authority, even if they had not subsequently voted at the third election. It is true that the whole Constitution had not been submitted to the people, as I always desired, but the precedents are numerous of the admission of states into the Union without such submission. It would not comport with my present purpose to review the proceedings of Congress upon the Lecompton Constitution. It is sufficient to observe that their final action has removed the last vestige of serious revolutionary troubles. The desperate hand recently assembled under a notorious outlaw in the southern portion of the territory to resist the execution of the laws and to plunder peaceful citizens will, I doubt not, be speedily subdued and brought to justice. Had I treated the Lecompton Constitution as a nullity and refused to transmit it to Congress, it is not difficult to imagine, whilst recalling the portion of the country at that moment, what would have been the disastrous consequences, both in and out of the territory, from such a dereliction of duty on the part of the executive. Peace has also been restored within the territory of Utah, which at the commencement of my administration was in a state of open rebellion. This was the more dangerous, as the people, animated by a fanatical spirit, and entrenched within their distant mountain fastness, might have made a long and formidable resistance. Cost what it might, it was necessary to bring them into subjection to the Constitution and the laws. Sound policy, therefore, as well as humanity, required that this object should, if possible, be accomplished without the effusion of blood. This could only be effected by sending a military force into the territory sufficiently strong to convince the people that resistance would be hopeless, and at the same time to offer them a pardon for past offenses, on condition of immediate submission to the government. This policy was pursued with eminent success, and the only cause for regret is the heavy expenditure required to march a large detachment of the Army to that remote region and to furnish it subsistence. Utah is now comparatively peaceful and quiet, and the military force has been withdrawn, except that portion of it necessary to keep the Indians in check and to protect the emigrant trains on their way to our Pacific possessions. In my first annual message, I promised to employ my best exertions in cooperation with Congress to reduce the expenditures of the government within the limits of a wise and judicious economy. An overflowing treasury had produced habits of prodigality and extravagance, which could only be gradually corrected. The work required both time and patience. I applied myself diligently to this task from the beginning, and was aided by the able and energetic efforts of the heads of the different executive departments. The result of our labors in this good cause did not appear in the sum total of our expenditures for the first 2 years, mainly in consequence of the extraordinary expenditure necessarily incurred in the Utah expedition and the very large amount of the contingent expenses of Congress during this period. These greatly exceeded the pay and mileage of the members. For the year ending June 30th, 1858, whilst the pay and mileage amounted to $1,490,214, the contingent expenses rose to $2,093,309.79, and for the year ending June 30th, 1859, whilst the pay and mileage amounted to $859,093.66, the contingent expenses amounted to $1,431,565.78. I am happy, however, to be able to inform you that during the last fiscal year, ending June 30th, 1860, the total expenditures of the government in all its branches, legislative, executive, and judicial, exclusive of the public debt, were reduced to the sum of $55,402,465.46. This conclusively appears from the books of the Treasury. In the year ending June 30th, 1858, the total expenditure, exclusive of the public debt, amounted to $71,901,129.77, and that for the year ending June 30th, 1859, to $66,346,226.13. Whilst the books of the Treasury show an actual expenditure of $59,848,474.72 for the year ending June 30th, 1860, including $1,040,667.71 for the contingent expenses of Congress, there must be deducted from this amount the sum of $4,296,009.26, with the interest upon it of $150,000 appropriated by the act of February 15, 1860, for the purpose of supplying the deficiency in the revenues and defraying the expenses of the Post Office Department for the year ending June 30th, 1859. This sum, therefore, justly chargeable to the year 1859, must be deducted from the sum of $59,848,474.72 in order to ascertain the expenditure for the year ending June 30th, 1860, which leaves a balance for the expenditures of that year of $55,402,465.46. The interest on the public debt, including Treasury notes, for the same fiscal year ending June 30th, 1860, amounted to $3,177,314.62, which, added to the above sum of $55,402,465.46, makes the aggregate of $58,579,780.08. It ought in justice to be observed that several of the estimates from the departments for the year ending June 30th, 1860, were reduced by Congress below what was and still is deemed compatible with the public interest. Allowing a liberal margin of $2,500,000 for this reduction and for other causes, it may be safely asserted that the sum of $61 million, or at most $62 million, is amply sufficient to administer the government and to pay the interest on the public debt, unless contingent events should hereafter render extraordinary expenditures necessary. This result has been attained in a considerable degree by the care exercised by the appropriate departments in entering into public contracts. I have myself never interfered with the award of any such contract, except in a single case with the Colonization Society, deeming it advisable to cast the whole responsibility in each case on the proper head of the department, with the general instruction that these contracts should always be given to the lowest and best bidder. It has ever been my opinion that public contracts are not a legitimate source of patronage to be conferred upon personal or political favorites, but that in all such cases a public officer is bound to act for the government as a prudent individual would act for himself. It is with great satisfaction I communicate the fact that since the date of my last annual message, not a single slave has been imported into the United States in violation of the laws prohibiting the African slave trade. This statement is rounded upon a thorough examination and investigation of the subject. Indeed, the spirit which prevailed some time since among a portion of our fellow citizens in favor of this trade seems to have entirely subsided. I also congratulate you upon the public sentiment which now exists against the crime of setting on foot military expeditions within the limits of the United States to proceed from thence and make war upon the people of unoffending states with whom we are at peace. In this respect, a happy change has been effected since the commencement of my administration. It surely ought to be the prayer of every Christian and patriot that such expeditions may never again receive countenance in our country or depart from our shores. It would be a useless repetition to do more than refer with earnest commendation to my former recommendations in favor of the Pacific Railroad, of the grant of power to the President to employ the naval force in the vicinity for the protection of the lives and property of our fellow citizens passing in transit over the different Central American routes against sudden and lawless outbreaks and depredations, and also to protect American merchant vessels, their crews and cargoes, against violent and unlawful seizure and confiscation in the ports of Mexico and the South American republics when these may be in a disturbed and revolutionary condition. It is my settled conviction that without such a power we do not afford that protection to those engaged in the commerce of the country, which they have a right to demand. I again recommend to Congress the passage of a law in pursuance of the provisions of the Constitution appointing a day certain previous to the 4th March in each year of an odd number for the election of representatives throughout all the states. A similar power has already been exercised with general approbation in the appointment of the same day throughout the Union for holding the election of electors for President and Vice President of the United States. My attention was earnestly directed to this subject from the fact that the 35th Congress terminated on the 3rd March, 1859, without making the necessary appropriation for the service of the Post Office Department. I was then forced to consider the best remedy for this omission, and an immediate call of the present Congress was the natural resort. Upon inquiry, however, I ascertained that 15 out of the 33 states composing the Confederacy were without representatives, and that consequently these 15 states would be disenfranchised by such a call. These 15 states will be in the same condition on the 4th March next. 10 of them cannot elect representatives according to existing state laws until different periods, extending from the beginning of August next until the months of October and November. In my last message, I gave warning that in time of sudden and alarming danger, the salvation of our institutions might depend upon the power of the President immediately to assemble a full Congress to meet the emergency. It is now quite evident that the financial necessities of the government will require a modification of the tariff during your present session for the purpose of increasing the revenue. In this respect, I desire to reiterate the recommendation contained in my last 2 annual messages in favor of imposing specific instead of ad valorem duties on all imported articles to which these can be properly applied. From long observation and experience, I am convinced that specific duties are necessary both to protect the revenue and to secure to our manufacturing interests that amount of incidental encouragement which unavoidably results from a revenue tariff. As an abstract proposition, it may be admitted that ad valorem duties would in theory be the most just and equal. But if the experience of this and of all other commercial nations has demonstrated that such duties cannot be assessed and collected without great frauds upon the revenue, then it is the part of wisdom to resort to specific duties. Indeed, from the very nature of an ad valorem duty, this must be the result. Under it, the inevitable consequence is that foreign goods will be entered at less than their true value. The Treasury will therefore lose the duty on the difference between their real and fictitious value, and to this extent we are defrauded. The temptations which ad valorem duties present to a dishonest importer are irresistible. His object is to pass his goods through the custom house at the very lowest valuation necessary to save them from confiscation. In this he too often succeeds in spite of the vigilance of the revenue officers. Hence the resort to false invoices, one for the purchaser and another for the custom house, and to other expedients to defraud the government. The honest importer produces his invoice to the collector, stating the actual price at which he purchased the articles abroad. Not so the dishonest importer and the agent of the foreign manufacturer. And here it may be observed that a very large proportion of the manufactures imported from abroad are consigned for sale to commission merchants who are mere agents employed by the manufacturers. In such cases, no actual sale has been made to fix their value. The foreign manufacturer, if he be dishonest, prepares an invoice of the goods not at their actual value, but at the very lowest rate necessary to escape detection. In this manner, the dishonest importer and the foreign manufacturer enjoy a decided advantage over the honest merchant. They are thus enabled to undersell the fair trader and drive him from the market. In fact, the operation of this system has already driven from the pursuits of honorable commerce many of that class of regular and conscientious merchants whose character throughout the world is the pride of our country. The remedy for these evils is to be found in specific duties, so far as this may be practicable. They dispense with any inquiry at the custom house into the actual cost or value of the article, and it pays the precise amount of duty previously fixed by law. They present no temptations to the appraisers of foreign goods, who receive but small salaries and might, by undervaluation, in a few cases, render themselves independent. Besides, specific duties best conform to the requisition in the Constitution that no preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. Under our ad valorem system, such preferences are to some extent inevitable, and complaints have often been made that the spirit of this provision has been violated by a lower appraisement of the same articles at one port than at another. An impression, strangely enough, prevails to some extent that specific duties are necessarily protective duties. Nothing can be more fallacious. Great Britain glories in free trade, and yet her whole revenue from imports is at the present moment collected under a system of specific duties. It is a striking fact in this connection that in the commercial treaty of January 23, 1860, between France and England, one of the articles provides that the ad valorem duties which it imposes shall be converted into specific duties within 6 months from its date, and these are to be ascertained by making an average of the prices for 6 months previous to that time. The reverse of the propositions would be nearer the truth, because a much larger amount of revenue would be collected by merely converting the ad valorem duties of a tariff into equivalent specific duties. To this extent, the revenue would be increased, and in the same proportion, the specific duty might be diminished. Specific duties would secure to the American manufacturer the incidental protection to which he is fairly entitled under a revenue tariff, and to this surely no person would object. The framers of the existing tariff have gone further, and in a liberal spirit have discriminated in favor of large and useful branches of our manufacturers, not by raising the rate of duty upon the importation of similar articles from abroad, but, what is the same in effect, by admitting articles free of duty which enter into the composition of their fabrics. Under the present system it has been often truly remarked that this incidental protection decreases when the manufacturer needs it most, and increases when he needs it least, and constitutes a sliding scale which always operates against him. The revenues of the country are subject to similar fluctuations. Instead of approaching a steady standard, as would be the case under a system of specific duties, they sink and rise, with the sinking and rising prices of articles in foreign countries. It would not be difficult for Congress to arrange a system of specific duties which would afford additional stability both to our revenue and our manufactures, and without injury or injustice to any interest of the country. This might be accomplished by ascertaining the average value of any given article for a series of years at the place of exportation, and by simply converting the rate of ad valorem duty upon it, which might be deemed necessary for revenue purposes, into the form of a specific duty. Such an arrangement could not injure the consumer. If he should pay a greater amount of duty one year, this would be counterbalanced by a lesser amount the next, and in the end the aggregate would be the same. I desire to call your immediate attention to the present condition of the Treasury, so ably and clearly presented by the Secretary in his report to Congress, and to recommend that measures be promptly adopted to enable it to discharge its pressing obligations. The other recommendations of the report are well worthy of your favorable consideration. I herewith transmit to Congress the reports of the Secretaries of War, of the Navy, of the Interior, and of the Postmaster General. The recommendations and suggestions which they contain are highly valuable and deserve your careful attention. The report of the Postmaster General details the circumstances under which Cornelius Vanderbilt, on my request, agreed in the month of July last to carry the ocean mails between our Atlantic and Pacific coasts. Had he not thus acted, this important intercommunication must have been suspended, at least for a season. The Postmaster General had no power to make him any other compensation than the postages on the mail matter which he might carry. It was known at the time that these postages would fall far short of an adequate compensation, as well as of the sum which the same service had previously cost the government. Mr. Vanderbilt, in a commendable spirit, was willing to rely upon the justice of Congress to make up the deficiency, and I therefore recommend that an appropriation may be granted for this purpose. I should do great injustice to the Attorney General were I to omit the mention of his distinguished services in the measure adopted and prosecuted by him for the defense of the government against numerous and unfounded claims to land in California, purporting to have been made by the Mexican government previous to the Treaty of Cession. The successful opposition to these claims has saved the United States public property worth many millions of dollars, and to individuals holding title under them to at least an equal amount. It has been represented to me from sources which I deem reliable that the inhabitants in several portions of Kansas have been reduced nearly to a state of starvation on account of the almost total failure of their crops, whilst the harvests in every other portion of the country have been abundant. The prospect before them for the approaching winter is well calculated to enlist the sympathies of every heart. The destitution appears to be so general that it cannot be relieved by private contributions, and they are in such indigent circumstances as to be unable to purchase the necessaries of life for themselves. I refer the subject to Congress. If any constitutional measure for their relief can be devised, I would recommend its adoption. I cordially commend to your favorable regard the interests of the people of this district. They are eminently entitled to your consideration, especially since, unlike the people of the States, they can appeal to no government except that of the Union. James Buchanan, December 3rd, 1860. End of Section 8. End of State of the Union Addresses, 1857 to 1860.